Citizen AY, the platform where we speak truth to power. Good morning, those of you joining us. If you're joining us for the first time, please go ahead and subscribe to Citizen AY on YouTube. Subscribe, hit the notification button, give us thumbs up. Today, we are looking at the case, focusing on the case of the court judgment on Shettima, particularly the Shettima case. We'll hear a little clip of that just now. It was on Channels News, so let's all see a little bit of it as we're speaking now to see the judgment. So let's hear what they're saying. So we're just going to.
Good morning, my lords. I am Chief Dr. Charles Uwensi Edosawa.
We will play bits of it just so we're going to
make a humble appearance for the fourth respondent. With me, sirs, Chief Adede Akintola, SAN.
Okay, so we're just going to take sections
Chief
of it just to
Afolabi Fashanu, SAN. Sam Ologun Risha,
1 second.
SAN. Solomon Moore, SAN.
So we're just watching that. Please subscribe to Citizen AY on YouTube. Help us grow the platform. We need your support in growing this platform.
Lord,
it's really important.
Friends of the Altar Bar
and we're
also here with us.
Be playing on other platforms as
and
well. But just give us a minute.
So,
So we are just going to go through quick sections of the judgment clips. The other one, the one on the presidential election is due to start, but we're just giving you quick, snapshots of sections of the judgment by the courts on the on Shettima case, where they say they lacked no merit because it was time barred. 14 days. That case should have been put forward within 14 days. It wasn't, they said. And in their view, they don't believe that Shettima broke any rules. That's what the judgment states. So you will hear sections of it. Let me just see if I can push that up a little bit more. So let's just... beg your pardon. We're going to just give me... minute. So you will be hearing that shortly. We're just trying to give you a bit more quick updates. So let us see. So we're going to shortly go into the section in terms of the presidential election itself proper. But for the meantime, we just wanted to just give you a quick synopsis. Of course, this is by Channels News, and we're carrying it here. But for the purposes of what we're trying to do this morning, we want our listeners on Citizen AY, the platform where we speak truth to power, to be part of this process and hear our thoughts as we go through this. So let us see what they're talking about here. I'm just going to try and see if I can give you some ideas. 1 second. So we are going to do that. Sorry about that. Go back again. Sorry about that. Give me a
Petition number CA/PEPC/04/2023 between Allied People's Movement petitioner and Independent National Electoral Commission, All Progressives Congress, Tinubu Bola Ahmed, Hashim Shettima.
So just give us a minute, please. We're just trying to adjust it. Sorry about that. So you're going to be watching it live, and we're streaming solely now. Right now, we're streaming on YouTube only, but we will certainly be doing the same stream on Facebook in due course. Oh, sorry. 1 second. Sorry, that was okay. Let's do it from here.
Please, my lords. Mrs. May Abamuche,
let me just start
INEC National Commissioner, Chair Legal Services,
so,
for the first respondent.
Petitioner is absent.
Petitioner is absent, my lord. First respondent is represented, my lord.
My lord, my name is Dr. Abdullahi Umar Ganduje, National Chairman, APC, for the first respondent. A second respondent.
Okay, so let's watch bits of it. We will forward it as and when possible.
My lord,
today is the 6th day of September. Yes, wait, yes, thank you. Sorry, yeah. I meant to change it. Thank you for that. Thank you. I meant to change it. It is the 6th. Yes, so of course. Thank you very much for bringing that at my attention. I really agree. It's good that you're hot on it. I meant to put the 6, of course. Thank you. We'll make that change straight away. Thank you very much for your sharp steering analysis of observers. Thank you. More today, more money. Yes. It is 6. Yes, I meant to do that, but I was so excited about doing that forward. So thank you very much. More money. I appreciate you. Thank you for the correction. Thanks. More money. Let me make sure I acknowledge you. Thank you. More money. Thanks for spotting that. So yeah, I'm gonna send that right away. I appreciate that, and thanks for doing that. I really appreciate you doing that. It shows that we got people who care about our development of this platform. So I've made the change immediately. Thank you so much. Whilst we are waiting for the second part of the judgment to begin, of course, we're going to try and let me see if I can I make it bigger? No, it will not let me do it bigger. I'm trying to just get it right. Okay, so let's see, is there anything else? So we're going to be waiting to see what's going on with that. Beg your pardon. Just give me a minute. We're, of course, checking the judgment.
With respect, my lords, my name is Andrew Malgui.
So we're going to try and just forward it a little bit along. So they're still talking here.
For the petitioner, and my learned friend of the outer bar, J.O. Olotu, appears with me.
So let's forward a little bit more. Beg your pardon. I don't know what's happened here. Something is not quite right.
Before this cancellation, please, after this, you submit a clean copy.
Yes, my lord. We had to do some changes in court here, and it was too late for us to adjust.
Okay.
Oops, to oblige, my lord.
Yes.
What we want to do is to give you as much info as possible.
Please, my lords. I am Sir Stephen Adehi. I appear with my learned friends of the inner bar, E.M. Inua.
So we will probably shortly go to the beginning of this broadcast proper, but I'm just trying to give us an idea, So the judgment, as we hear it, is that Shettima is cleared of all wrongdoing. And apparently, because of the time barred issue, 14 days within which they had to carry out the petition, that this case falls outside that. It doesn't meet that requirement. And of course, they disregarded many of the things. They were talking about issue about intent of the actions of Shettima, that there was no intent to be holding, to be participating in 2 elections at the same time, one of the senator and of course the VP. And of course, it was nominated, it wasn't in his hand, that kind of thing. So there was some, that is going to create a lot of discussion, no doubt. So we're going to see how that transpires.
Learned friends.
Let us see what's going on.
Adeni Akintola, SAN.
So,
Chief Afolabi Fasano, SAN. Sam Ologunrisha, Esquire, SAN.
So let us see if I can
Solomon
expedite this
Esquire,
forward.
SAN. Yeah, sorry, my lord, it's not Esquire.
So we're trying to skip forward. So,
With profound humility to my noble lords.
One second, just give me a minute.
A. Malik.
Give me a minute. I'm just gonna 1 second whilst I sort that out. Just give me a second. So I'm gonna be on the screen, and I'm gonna quickly just do that change whilst we talk. You're hearing them in the background, but essentially we are trying to give you as much information as to what is being said. So just bear with us a second whilst we continue to bring that forward. 1 second. We'll, just take that away. Okay, so now.
Esquire.
So let's see. They are mentioning the names of those who are,
Shola
speaking for the respondents, Tinubu and others. So do bear with us. I'm just trying to make sure we get this right.
Lords, may I respectfully add
So
last name?
give me a second. I want to make sure I get this absolutely.
I'm only record what is on the list.
Most good, my lord.
What's gonna happen?
About
now
appearance
is-
for the third.
So let us go into the judgment, Papa. I want to just hear.
Well, let's
Let us hear.
going to be laid.
2023 as the President-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that having regard to the joint ticket principle enshrined in Section
1 second, please. Bear with me.
1 of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature.
So what you are hearing is the judgment of the court on the Shettima case. We're just playing sections of it. We're not going to play the whole thing. We may run through the whole video at some point later on. But what we're trying to do is to give you an insight into the thinking of the judgment of the judges as they read the decision to clear Shettima. So it is of immense importance. It doesn't mean, we will all have our views on it. But what we do know is, and this is why we talk about the need for Nigerians to really begin to participate in our governance. The courts are making a judgment. Now, is it in line with what the people expect in terms of the judgment, judgment proper? Is it fair? Is it balanced? Is it reasonable? These are questions that are up in the air. But certainly, they've made a judgment. The judgment is Shettima is clear. They are now shortly going to go into the one where they'll be talking about the presidential election proper with Tinubu. But we're trying to show you what is being done so far, and that's why we just wanted to talk about that. So I'll be coming in and out of this particular section just to make sure we get sorry about that. We get some clarification as we proceed. So let me just see.
For the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 25th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination.
It seems to me like a long-winded way of saying the same thing. That
the second respondent. That
the judgment is based on how they see it. Now we're not lawyers, we're not judges in this case. We don't know what they factored in, but what we do know
as the vice presidential candidate of the second respondent as at 25th February 2023, when the presidential election was conducted by the first respondent.
So please subscribe to Citizen Network, the platform where we speak in power. Help us with more people.
Of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 25th February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the ground of prayer 4 above, an order nullifying and or setting aside the return of declaration of third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 25th day of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria, 1999.
It's an interesting judgment, don't you think? I think it's an interesting judgment. I am not a lawyer, I am not a judge, but as a layman, and I openly say that as a layman who's interested in what is going on in our country, there are concerns that I have about the judgment. Will they provide statements? I hope they will provide further clarification of the statements of how they arrived at that decision, transcripts properly, for us to see their thought process. That's what I would certainly be expecting. Can we challenge it? I don't know. Supreme Court is the final court in the land, open to interpretation.
The respondents were duly
now, based on what they are saying in this judgment,
First respondent replied to
is it
petition
leading us
was
to
filed
think
on 9th
about
of April
the likely
2023.
decision they're going to make in the
Second
presidential
respondent replied to
elections?
the petition was also
The
filed on 9th of
actual
April
INEC
2023. While
actions on the
that
election
third
night
fourth
and all of that.
respondent
How
was
will they?
filed on
Is this
13th
giving us an insight
of
into
April
what they're going to, how they're
2023.
going to decide it?
The
That's
fifth
the
respondent
question that
also filed reply to the
I
petition.
struggle with myself. I struggle with that
On the
because
16th of
it
April
is something
2023,
that is a
the
concern.
petition the
That
petitioner
if they
then
are
filed
telling
replies
us
to
something
the
in a way
respective replies
that is
of the
going to lead
respondent
us
the
to
petition. The
to
respondent
really
filed a number of motions,
that is
all
gonna
of which challenge the competence
not
of the petition.
really, is it going to
These
be,
motions
is
were
it
duly
going to be
heard
fair?
during the
Is it
hearing
going to be,
session
balanced? Is
and
it going to
ruling
consider
reserved.
all of these things? Or is it just going to make a blanket statement and stick
The
to the
first
same
motion was
decision?
filed by the first respondent,
So,
applicant.
I mean, it seems to me they're taking a long,
was filed on
using
the-
many words to say a
on the
very,
6th
very
of May, wherein he sought the following
clear
reliefs.
cut decision
One, an order
that they
striking out
are
paragraphs
going to
2, 3,
stick
4,
with the
5,
current
6,
government.
7, 13, 14,
Whether or
15
not
of the
you
petitioner reply,
agree with
filed
that,
on 20th day
that's
of
besides the
April
point. But the
2023.
point is, things that have been done here. Sorry, let me just check what's going on here. Sorry, what's happened here? Give me a second. Something just, okay, we will come back there. So let me just, I don't know what happened there. Okay, 1 second, please. Yeah, we're going to get it. We're still trying to adjust it right, so don't worry about that. It will just come. It does happen sometimes. So we're here. So just bear with me whilst I adjust that correctly.
Ground. Oh, what are these honorable court striking out paragraph 21 to 27, 29 to 100, and 15 for being non-specific, lacking in clarity, generic, nebulous, contravention of the first schedule to the Electoral Act.
Now,
Use of paragraph 4 sub 1
just
sub
bear
D
with me, please. Bear with me.
and sub 2 of the first schedule
I'm
to the
just
Electoral
making
Act
some
and
changes.
variously argue that the paragraphs of the
And I will
which
be
they have
making
listed are
adjustments
liable to be struck out,
as we go
being
forward.
vague,
So bear
generic,
with me.
imprecise, and nebulous. So arguing they relied on several cases which are cited.
So
By contrast, the
bear with
petitioners
me.
have submitted that the respondents' objection in the listed paragraphs of the petition are not vague, nebulous.
So we're just trying to get it working. Oh, something is going to resume shortly. Something is going on. So beg your pardon. It will continue. We're probably going to go into the judgment proper as well, the second part of the judgment. But I wanted to just show you clips of the first part of it, which is principally that Shettima is basically is free. He's not done anything wrong according to what they said. So bear with us. So we'll get that working shortly. I don't know what's happening there. We're just trying to get that working. Bear with me. Just we get it working. Something is not quite flowing as it should, but something is happening. So bear with me. But we will go into the second part of it in due course if this continues. We're just trying to make sure that we give you as much up-to-date information as possible. So whilst we're doing that, let us just quickly check this. There is a need for us to make sure that we got the right information there. So let me just check that. So do bear with me. We're just trying to make sure that this is doing what it needs to do.
Additionally, petitioners have relied on paragraph 17.2, first schedule to the Electoral Act 2022, and argue that the respondents have joined issues with the petitioners on those paragraphs. Having failed to seek for further particulars, they must be taken to under a paragraph. Having failed to seek for further particulars, they must be taken to under a paragraph. They relied on some cases. Now, resolution.
Okay,
I've
resolution.
carefully considered the submissions of the parties and the judicial authorities cited.
Yeah, yes.
It is right that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. The general principle of law is that such pleadings must sufficiently and comprehensively set out material facts so as to ascertain with certainty and clarity matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary the case is to meet, to afford him the opportunity to properly respond. Its aim is to bring to the knowledge of the opposite side and the court, all the essential facts. Therefore, it's a safeguard against element of Shodiko versus Eminent Kane, Odom, others versus PDP and others, Lassan and another versus Ishaku, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based and lives stored by the petitioner, unquote. Paragraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which
So
shall
we're going to
be
go into the second part of it shortly.
confined to a distinct
But
issue
we're
or
trying to
major
give
facts
you a
of
bit
the
of
election
context
petition.
in what we're
Every
doing here,
paragraph shall be numbered.
so that you can at least see the
In addition to the
thinking.
provisions of paragraph 4 of the
judges.
first schedule to the
I
Electoral
mean,
Act, paragraph
Of course, all of
54
us have
the same schedule
reservations
to the
about
Act
this,
has made
what's been
applicable to election
decided,
petitions the rules of procedure
and we are
of the Federal High
concerned
Court
largely as to
2019,
what
subject to such modifications
what
as
their
would
thinking
bring
is
same
and
to
trying to-
conformity with the provisions of the Act.
and
By Order
trying to
13,
really,
Rule 4 of the Federal High Court Civil Procedure Rules 2019,
trying to
every
really-
party to an election petition shall ensure that
see
governments in their pleadings, and I
is
quote,
there
contained in the
fair-
summary
is
form
it fair and
material facts
consistent?
on which the party pleading lies
fair and
with claim or
consistent?
defense, as the
So
case may
when we
be,
just what
but not
happened
the
here,
evidence by which
So
they
give
are
me a minute,
accused,
please. Give me a minute.
and shall,
So let us just
when
wait
necessary,
one
be
second.
divided into
Let me
paragraphs
just-
and
one
numbers per
second.
section. Quote. By subparagraph 4 of that rule, such facts contained in the plea must, and I quote again, be alleged positively, precisely, and distinctly, as briefly as is consistent with a clear statement.
So what we are doing is we're just trying to show you.
The
Give me a
aforementioned
minute,
provisions
please.
contained in the first schedule to the Electoral Act 2022,
So,
as well as the Federal High Court's Rules 2019,
One second,
state
we're
the
hearing
mandatory
it.
requirements
We'll
of
come back
pleadings
out
in election
again,
petition.
and
The requirements for clarity and precision of fact
again, we
by
are
paragraph 4
still
of the first schedule to the
building
Electoral
on
Act
this,
means
and
that
we'll
governments must not be
obviously
vague,
show up. So give me a minute,
ambiguous,
please.
or unclear, leaving room for speculation or conjecture. While the requirements of distinctiveness means that each government must
Okay.
contain a clearly understandable.
So we're just gonna pause that, and then we're gonna quickly make sure we continue with the broadcast. Just give me a minute. We're just trying to check that everything is as it should be, because it's very, very important. Very important. We're gonna come back to the judgment shortly, but we just want to see what they're saying here. So now, one second.
Or question side nomination or sponsorship of the first respondent by the second respondent. That's in
Just bear with me. It's there, but we're just trying to give you as much info.
People's Democratic Party, PDP, and independent.
Let me just make sure we got that right. Something. We're just trying to make sure you have that information. So, and then we'll go to the ongoing one. That's going to take some
Electoral
time.
Commission and others. And
gonna take some
reported
time,
decision
but-
of the Supreme Court, delivered on 26th day of May 2023 in SC/CV/501/2023. I heard the matter has been reported, but
Okay. Just give us time to really adjust this. It's just trying to make sure we get it right for you. It's not a rush. We will be looking at this, for the course of the length of the week for a very long time. And
the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it, challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of any. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law
that
has
is the
always
central
been
one I want you to
that no
listen to.
political party can challenge domination of the candidate
That's the
of
one I want you to
another
listen to.
political party,
That's the one I want you
no
to
matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position, it must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court. Close of court. It is clear, therefore, that a political party such as the petition is sharing only has the local standing to fight.
So you had that court case, the decision right there. The decision right there was this. Look, the courts, the political parties were trying to use as a way to try and cause problems and take act, make it intervene in the affairs of another political party. That's a central part of the judgment for the Shettima case. Let's go forward to the next one.
If election matter, when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondent by the second respondent applicant, the petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent.
Okay. So
The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, Subsection 1 of the Electoral Act stipulates, I quote, an election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election.
Okay.
By the use of the disjunctive word or, it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. By another motion filed on the 15th of May 2023, the fifth respondent, thus Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders are this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. I've also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, subsection 2 and 3 of the Electoral Act 2022.
Yeah.
Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis.
Yes. So he's reading something, but obviously it looks like it's a
sui generis, and its procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election petition.
Okay.
See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP.
Okay.
That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the first respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid.
Okay, those of you joining us on Citizen Wide Facebook, good morning and welcome. We are listening to the judgment of the court case, the recent judgment in favor of Shettima, in the case whereby he had two nominations, he was part of he was going for Senate candidature as well as the Vice President candidature, and they're saying that the judgment should have happened within 14 days.
It may be relevant in a election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. Otherwise, the relief sought in the
please subscribe to Citizen AY on YouTube. Hit the notification button, give us thumbs up, help us grow the platform. Thank you very much.
Or agent of the second respondent, no declaration was made in his favor by the first respondent.
What's going on?
In that respect, I hold that the objection of the fifth respondent on this ground.
Okay, so I'm showing you the section where they actually made the judgment, the critical judgment in support of Shettima. So those of you joining us, welcome aboard. Please subscribe to Citizen AY on YouTube. Help us.
These are the rulings in respect of the petition number 4.
All right, okay. So we're going to go and look to see if there's a further object on that. We will see. There should be a further judgment.
After the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023.
So listen, this is the bit that we need to understand.
Called one witness and closed his case. None of the respondents called any witness, attended some documents from the bar, and the petition was adjourned or adopted or written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein 4 issues were raised for determination as follows. 1. Whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging the qualification and stand of the third respondent as the winner of the presidential election 26th February 2023. 2. Whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134, subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court, question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3. If the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 25th February 2023. 4. Whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been reduced in this judgment, including the issues raised by the petitioner.
So, I'm just trying to see what's going on. Okay. So they paused there for some minutes. We're going to join the second part of the court case, no doubt. the presidential election proper, which is the one that is really critical. This one is important, but of course, what we are seeing and what we are trying to ascertain here is what
now,
is going to be
the
the third
from the
process.
environments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent who have contested the presidential election of 26 February 2023. This is evident in paragraph 15 of the petition, there, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent who have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to contest, jointly contest with the third respondent for the presidential election held on 26 February 2023,
So,
having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraphs 16.1 and 2 of the petition as follows.
yeah. So,
Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135 of section 1 of the Electoral Act, that has been produced earlier. For the purpose of this petition, it is the ground stipulated in section 134.1a that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I consider paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for the termination of the petition.
so this is this
Which
going to
paragraphs
the heart of
have
the
been
decision.
introduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced.
Let's hear your comments as you're joining us. We appreciate you all. Let me recognize
Second
Henry
respondent also filed a
Agomo,
second
Yinka
respondent reply to the
Adeniji,
petition,
and many
also
others who have
averred
joined
to
us on
make
here.
their own averments in
Good morning
paragraph
and welcome.
16,
You're watching this network. Good afternoon to you, in fact. 12:15 is the
21,
time.
22,
Today is the 6th of September, Judgment
25,
Day.
26, and 25, 29.
Roslyn Adenike,
Produced
Okubadejo Oyebanjo.
So from the totality
Wisdom
of the pleadings in the petition
and
the
Baratu.
replies
Good
of the
morning and
respondent,
welcome.
what appears
to you
from
as
the
well.
complaint of the petitioner is that the fourth respondent
Wisdom,
was still a
Wisdom
candidate
and
of the
Baratu.
second respondent
I hope I'm
who
saying it
Borno's
right. So
Central
I welcome you and I
Electoral
recognize
District
you as you're
was
watching
nominated
this
and
broadcast.
did
Thank you
accept
very
to
much.
be the vice president candidate of the second respondent. That this act violated the provision of section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time
Please
of
subscribe to
election.
Citizen NY on
The
YouTube.
petitioner
Go
relied
ahead
on
and
section
subscribe now.
131
Hit the notification button
and
and press thumbs up.
142
Thank you.
of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142.1. In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected the office of Vice President if the candidate is for election to the office of President who nominated him as second associate is duly elected as President in accordance with the provisions of the
we will be going to look at the further
The general
judgment
principles of
as it comes
interpretation of
on.
the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal Republic of Nigeria, Amadi and Ani, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Dokuku, Adol, Peterside, and others, the Supreme Court observed that the principle of conception of the Constitution to the effect that the Constitution is a living document, not just a statute, providing a framework for the governance of the country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution, while constantly bearing in mind the object which such provisions were made serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution being the ground norm superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner, in this case, has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent was still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and prelude objections, we had ruled that the
So let's see, we're trying to hear what's
ruled
going
that the
on.
petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election
So
because
welcome to
he
those of you
nominated
joining
as
us.
associate,
Yinka
whose
Dennis,
nomination
welcome
was
on board
invalid.
again.
Does not flow
If I have
from
not
any
answered
ground
you, I
of
recognize you,
qualification
even though
of
I
the
may not mention,
candidate
if I
to
haven't
office of
mentioned your
president
name.
as
Vivian,
stipulated in
hello,
section
Vivian. Hey,
137
Vivian
and
V.
131 and 137
Hello, my sister. How are you doing?
of 1999.
Let me acknowledge you.
See the cases of Balewa and Mwazu and Faleke and Anik, Azu versus Yorea. And in Shinkafi versus Yari, the Supreme Court held that.
Hi.
The Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state.
We're waiting for further
From the
updates on
record of
the
this court,
second part of the
facts
judgment.
have not
But
disclosed any evidence to
listen to
show
this.
that the first respondent was not qualified to contest elections into the office of governor of Zamfara State. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in Section 177 of the Constitution and is not qualified under
Vivian V.
182
Thank you, thank you. Yeah,
thereof,
I welcome you.
he is qualified to stand election to the office of governor of his state. No other law can qualify him. This
Welcome on board, those of you joining us on YouTube. Please subscribe to Zinewai on YouTube.
Of the Electoral Act.
Let us.
It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of Section 131 or 137 of the 1999 Constitution.
Subscribe to
The complaint of the petitioner who take on nomination on suspension of third and fourth respondent will find accommodation in a pre-election dispute which the petitioner cannot even pursue, not being a member of the second respondent. This Section 84, Subsection 14 of the Electoral Act 2022 and 285, 14 of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, the complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2022 not qualified to contest
the
election.
Vivian, yes, don't forget that the translation you're going to do for us. Here's the number to contact us on, or to send a message directly, Vivian. So, because we need to actually have that on board.
The Electoral Act 2022.
If you can.
As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022.
We'd like you to help us, and if you can even join us live to do it, that'd be great.
He had accepted the nomination as the vice presidential candidate of the second respondent, who was still a validly nominated central candidate of the second.
Thank you so much. That's very well said. Well, okay. Thank you, Vivian. Thank you.
That the second respondent had earlier submitted the name of the third respondent
we appreciate that. Thank you so much.
Fifth respondent to earn it as his presidential and vice presidential candidate for the 25th February 2023 election. However, that before the date of the election, the first respondent,
understood.
The fifth respondent,
I enjoy your day at work, and thank you for joining us whilst you're working, multitasking. Great job. Thank you so much.
The name of the fourth respondent was then submitted to earn it, that first respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents considered that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District.
Let me just answer that.
However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, as second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of fourth respondent are in evidence as Exhibits PA3 and PA4 respectively.
As we listen to this, we are just bringing it to attention. The live broadcast on channels has come to an end, but they are coming back to with the second part. As we speak, the judges who have made the decision to support, to agree, to not do anything in terms of Shettima, or to accept, to say that the 14-day period has lapsed, so they cannot make any. Nobody can challenge things from that point of view, and also that is also a party matter. Those are the decisions they made, and I don't know how we all feel about that. That is what is happening as we speak. But as we speak now, we're just doing a playback so that you can get up to speed. Those of us who are supporting and following Zinewai, to give us updates on what is currently going on and how we and provide a moment to discuss and in the merits of the decision that they made. Of course, I'm not a lawyer or judge, but I can only speak from a layman's term, and also what are the implications of this for the forthcoming judgment on the presidential election case. So that's why we're trying to provide that context. But let's go forward.
It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended the issue of alleged nomination of the fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitutes estoppel parem judicata and binding on the parties placed in this petition. Now, for a judgment to constitute issue estoppel, the conditions I had earlier stated in the rulings, so the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited.
Rich Enoma, welcome on board to Citizen NY on Facebook. Please go ahead and subscribe to us on YouTube. We appreciate you.
The highest and final court in this country. There is no doubt that the decision was final, and the issue that was done by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of APC, a different political party. That may well be so, but it is clear from the judgment, that's Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. So, Doro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded to do so. It is certain law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down binding effect. As in Olu Terba and others versus Abdurrahim, my Lord Fabi JSC said, of course, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now it is apparent that the parties in Exhibit X1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner here that X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and ANIC Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or prisoners to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contramundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. See Black's Law Dictionary, 11th edition at page 1008. Demishola versus Bolanwa, Yanati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, partition supply. It is no doubt that the judgment matter in PDP and INEC others S1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition, as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this
we
issue
urge
in this case,
all those of us
no,
on
the
both
constitutional
Facebook and
judgment.
YouTube, please go ahead
My
to
Lord
Citizen
Okoro
on YouTube.
JSC,
Give
who
us a like.
presided on the panel of the
You may
Supreme
be
Court,
watching on
said as
Facebook, but
follows,
if you have
I
a
quote,
YouTube
there is
platform,
no doubt that the
just
first
go
respondent was
and
at
subscribe to
the stage
Citizen
nominated
on
as a
YouTube. Help us
candidate
grow the platform. The more you do
representing
that,
Borno
the more the
Central District.
platform reaches more
But
people.
upon being
So,
muted,
let's carry on.
he would
Sorry.
pair with the third respondent as vice presidential candidate or second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July.
I'm adding you as a
2022.
moderator as well.
Those of
You're
course.
regular on this platform, so I
After
appreciate you
considering those
adding me as a
documents, his
moderator.
lordship
So when
concluded
you do
at
get
page
a
7
minute and you
of
want to
the
add and
control
watch
judgment that
when I do programs,
But
maybe
it
we
is
can
clear,
interact. So
crystal
please do
clear
get in
that the
touch.
two
Thank you.
exhibits alluded to above, the first respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress. Close quote. My Lord Okoro went on to, after citing Section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, the above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served term on the second respondent of the withdrawal of nomination of 6 July 2022, first respondent was no longer a candidate for the Borno Central District election, and his subsequent nomination as vice president candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the first respondent since his withdrawal on the 6th of July 2022. I've also cited the elaborate contribution of worship against JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the first respondent as the central candidate and vice presidential candidate of second respondent in the 25th
Aguilera Anthem PC, welcome on board. I appreciate you. Please do go ahead to Citizen AY on YouTube and subscribe. Help us grow the platform on YouTube. Thank you so very much for each and every one of you watching. We appreciate you both on Facebook and on YouTube. You are very much valued and treasured as those who support. By you watching us, you're supporting our platform. We're grateful. Thank you.
This petition, which
George and Angel, thank you. Welcome on board.
Disqualify the third and fourth respondent from contesting and occupying the seat of president and vice president of Nigeria on ground of double or multiple nomination of the first respondent and vice president candidate of the second respondent on ground of double or multiple nomination of first respondent has no substance.
Thank you, my brother. We'll do that.
I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms the candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that the candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved. The stipulation in the section being a general provision. In the instant case, neither the intent nor the fact of the first respondent who allowed himself to be so nominated was established. That's why His Lordship Ogumi JSC, in his contributory judgment, in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the first respondent, Shettima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the first respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 25 February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows. Quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nominations without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nominations. It is the intention, design, or purpose to hold two or more nominations as candidates for election that shows that the person so nominated knowingly did so. The second respondent did not intend that the first respondent should be his candidate for Borno Central election and his vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated.
Very interesting.
The word knowingly
he didn't understand.
Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency, as alleged by the petitioner against the first respondent, has not been established.
Yeah.
In other words, both the administrative and actus reus of the Act prohibited by Section 35 of the Electoral Act 2022 were not established.
Yeah.
One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of DJSC highlighted this point in its one as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate, at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. Close of court. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent, because the candidate of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 does not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition held to be devoid of any merit.
Void of any merit. So, very critical moment there. Let me just do something quickly here. I'm going to take this opportunity to read the statement that has been released on all major platforms by the judges on their decision. So let me take this opportunity now, and again, I want to thank each and every one of you that are watching us on both Citizen AY on Facebook and on YouTube. I want to thank you for joining us. It's really, really important. We're looking at a momentous decision here. It has ramifications that many of us are not even aware of, but we will have to say, based on what has been said, we can only say to you what the judges have said in summary. Now, let us read one of the things that came through. It says here, the Presidential Election Petitions Tribunal sitting in Abuja has struck out the suit filed by Allied People's Movement, APM, in brackets, accusing Vice President Kashim Shettima of the All Progressives Congress, APC, of the double nomination in the 2023 general elections. It then goes on to state, the chairman of the panel, Justice Haruna Samani, who read the lead judgment, held that an invalid nomination or double nomination did not qualify as a ground for disqualification in respect of the presidential election, as provided in sections 131 and 137 of the Constitution. Those sections I will go and read through maybe immediately after we, I might even read through it live on air here with you, because I think it's worth looking into that closely ourselves. And, so it helps us, understand their decision, if you like. Now, let's go to the final part of what he said. He also held that Mr. Ibrahim Masari, who was nominated as a placeholder by the APC for the position of vice president was not necessarily party to the petition because he was neither a candidate nor did he win the election. So that is very interesting. I don't know how you see that. I'm going to try, whilst we're looking at this, I'm going to try and dig out 131 and 137 so that we can all read that ourselves. Let us just play. Let's see how this plays out. And of course, not long after that, the judges took a break. We're not sure when they'll be back, but let us hear what was said on channels around this particular issue or what the comments are. So that's probably what we'll be following from what you're seeing on the screen right now. Let us listen for a few more minutes, and then we'll bring that 131, section 131 and 137 to you on here shortly. Let's proceed. Thank you. So whilst we're waiting, I'm going to be doing some stuff, as you know, in the background, bringing up that section 131 and 137. As you know, I have that on the citizenay.org. If you haven't got that, also, I have that website. Please make sure you have that as a website on your page. In fact, I will get that to you on the screen so you can actually join that on both platforms as well, or at least have it on your system so that when I go live, you can also check there as well. But we're putting that here on YouTube, and I'm going to put it on Facebook shortly. But in the meantime, we are trying to get that information, section 131 and 137 up, so we can go and look at it ourselves and refresh ourselves. At least it gives us an idea of how they are arriving at the decision that they are making. So, like I said, the judges are taking a break right now, and a lot of people are making. We may go and look around on social media platforms to see what people's views are on the judgment so far, and also based on this, I want you to think about this as you're watching. With the judges making this kind of decision, supporting Shettima and giving the reasons, one, do you agree with the reasons? Do you agree with the with the decision made? Two, and three, what is the likely decision that they're going to make based on what you heard now, the decision they make now? How does that guide us to what decision they are likely to make on the presidential elections? How do you view that? Is that something? Are you viewing the forthcoming, the soon coming decision that they're going to decide on the president election in terms of INEC's actions? Are you viewing that with trepidation? Are you confident that your position will be supported? Let's hear in the comment section.
Moving up and down. So, as an elderly person, I know what is going on.
So let's hear what they're saying in the meantime. Whilst that's going on, I'm seeking out 131 and 137. So.
My lord, please. You just needed to know, sir.
Yes.
Thank you very much, my lord. Thank you, sir.
Okay, so they were asking a question. One of the lead counsels was asking a question, and they're going to read all the judgments. So. Now, there is something I found the 131 and 137. I'm going to try to put it on the screen so that we can follow that. You're going to hear them in the background, I think, but I'll play by ear. Let us see what they do in this section, because now they're all having a break. You can see a lot of the Shettima and others are coming off they're getting off their seat, and they're probably all going to have a break. As we all know, President Tinubu is in India having discussions with the Indian business community, try to generate some sort of so let's listen to what they're saying on channels. This is by channels news, of course. Let's listen to what they're saying. Then I'll bring 131 and 137. Let's listen.
Just gone underway. Well, what the justice said was that's the fourth item, so to speak. So there's still the third one, there's the second and the first. But the reason they're taking them all up together is, according to the justice, they are consolidated. In other words, they are all related one way or the other. You'll see that a number of times he would say, look, as we had previously mentioned, it's a pre-election matter. As previously mentioned, it's a pre-election matter. But at least one thing can be said clearly now, that this court has struck out APM's suits against Shettima and Tinubu for lack of merit. For the preliminary objection, the court held that the petitioner, that's APM, ought to have filed the case before the Federal High Court within 14 days from the course of action, from the day of the course of action arose. The court agreed with the respondent that the issue is statute barred, and consequently, the justice who read the leaked judgment added that Section 285 sub 14C does not allow members of any political party to challenge the nomination of candidates of another political party, and consequently declared that the petitioner lacks the local standing to institute the petition.
And recall that the PDP did indeed take the matter to court as a pre-election matter, and the Supreme Court held that there was no double nomination. So on this case, the judge has ruled that the petitioner failed to prove that the third and fourth respondent failed to prove that they were not validly nominated, and on that strength, has been struck out for lacking in merit.
It's a long haul. We're still. This is pretty much, as we have been informed, the long haul.
The long haul being verification. We could be here for another 2 to 3 hours, so to speak. But in response to one of the council's inquiry just moments ago, Justice Samani.
So the judges are vacating the chambers to go and have a break.
What's the implication of that? Is it that it's a contributory judgment from all of the other 4 justices, or will there be a dissenting judgment?
Well, I guess that's what we would wait to see, because, if you recall what Mr. Kwek has told us the other time, as well as Dr. Otitoju in Abuja, that look, a lead judgment could take X number of hours. And if you also recall what the justice said to us, this is just the judgment. There are other arguments in it. You have to get it later. I'm like, okay, so this whole conversation started sometime around 10 o'clock?
9:27 to be precise. I took note of the exact time that the judges walked in.
It's 9:27.
Just also
so
warn
we may
you
replay the whole thing from the beginning again for those who missed it.
In case there's a dissenting judgment, that could also
we'll let you know
some
in advance.
time.
But we want to talk about 23, section 131 and 137.
Contributing judgment, there's dissenting judgment.
We do not know for sure.
I don't know. This is what makes. That's why maybe I should ask a senior journalist of Nigeria and senior advocate of journalism. No, that's Chamberlain and Sheon, because they went to town on the case the other time as well.
Thank you
I guess we'll wait to see the very appropriate. And the court is taking a bit of
a break,
leg stretching break. The justice said 15 minutes, and he said
15 minutes.
Going by the ages of the people informed.
Well, it's been long now. We don't know if it's. Let me see.
Jocularly, that Mr. Buzoko, senior advocate of Nigeria,
I don't think it's 15 minutes.
Up and about
I don't think they're back
due to age. So it was just a good time to take a break.
Well, and that's actually humane. The fact that we have work to do does not mean that we shouldn't be sensitive to the issues. So I guess that's 1 down, 3 to go.
Yeah, 1 down, 3
You were
to
talking
go.
about senior advocate of journalism. The senior advocate of journalism in Abuja was telling us earlier that there are 3 main hinges upon which the judges always rule. The strength of the case, that's the strength of the argument, the facts of the matter, and evidence
Right,
tendered before the court. And we're seeing that play out in the first of the many items before the courts today.
See why I called him senior advocate in journalism?
Yeah.
Okay. So we'll take a short break in a moment or two, just to let you know that any moment from now we will continue with our broadcast of this.
Okay.
And as we mentioned to you, we've been trying. Oh, by the way, we could also inform you that not a few issues are trending right now on
check
X
what's going on
about this particular case. Number 1, the PPT judgment.
Whilst they're doing that, I think it's pertinent for us to talk about the issue of Section 131 and 137. I think I have it on the screen. I'm going to try and read it to you. So let me see. Hopefully you can be able to read 131. Sorry. I want you to be able to read it. I'll put it on the screen. You're going to see it come up. I want you to be able to follow and read it with me as well. So Section 131, it says here, a person shall be qualified for elections to the offices of the president if he is a citizen of Nigeria by birth, he has he has attained the age of 40 years. He is a member of a political party and is sponsored by the political party, and he has been what's the word here? He has been educated up to at least school certificate level or its equivalent. So that's what it says about Section 131. I wanted to just bring that to attention. We're going to certainly go to the judgment proper again. It's not been on. We'll be bringing it to you shortly whilst we're doing that. So I'm going to be bringing that, but I wanted to just show you that. Now, the second part of what I want you to also be aware of is section, they talked about 137 in that judgment. Let's go and look at section 137. So section 137 states, let me just read that to you, and then we can then begin to go ahead. Section 137 says, it's quite a, maybe it's a, I'm not quite sure if it's 1A. Let me see. Let me see the basis upon which they read it, because it just says 137. But the 137 is quite a long one. So I'm not quite sure if I'm going to read all of it, because it's quite a long one. And I was thinking it's more in terms of a particular specific section. But let us see. Let us see what it says here in that judgment. Because then I'd have to refer us to go and read that ourselves individually. But let me just check something here. Section 137. Sorry. So now let's see. It says Section 137. So I think it is asking to read all of 137. A person shall not be qualified for election to the office of the president if, subject to the provisions of Section 28 of this Constitution, he has voluntarily acquired the citizen of a country other than Nigeria, or except in such cases as may be prescribed by the National Assembly, he has made a decision of allegiance to such other country, or he has been elected to such offices or office at any two previous elections, or under the law, any part of Nigeria he has he's adjudged to be a lunatic, or otherwise declared to be of unsound mind, so on and so forth. So that is a long one. That's why I don't necessarily want to read that too much. But it's just to give us an idea of the... So you can read section 131 and 137. We read the 131 all in its entirety. 137 is a fairly long one. I could do it. But what I want to do is, I think there is they've already started the judgment again, the case again up and running, and I want to bring that to you as much as I can. I'm sourcing it from various places. Let's see if I can find it. If it comes up, then I would happily, obviously, bring it up here. Let me just see what is going on here. Arise. Okay, let me just see if there's anything on Arise now. To see, I'm just trying to just check as we speak. So we're just trying to get that information to you, because it's very important what's going on now, and I don't want it to be delayed any longer. So what I will do, whilst I'm going to leave it on the screen, and I'm going to quickly source this thing out, because we do need that information to be, to be relayed to you live as we speak. Let me see. So we are trying to see things. So do bear with us. So it gives you an insight into the thinking of the judges, certainly. Do we agree with it? Can we debate about it? Yes, but it also is preparing us to what is their likely decision. All the while we are now sensing and realizing that their decision is going to be based on what this is giving us a window into their minds as to how they're thinking of the final judgment that they're making. Because whether we like it or not, one would like to say that those judgments are not going to be. They're not going to be. They're not going to be linked. But I can tell you now that it is going to be linked. However much they try to say it's a separate judgment and everything else, I just don't see how one can separate that. I don't see how one can separate it. But we will play this now, this live presidential election thing now. We're going to do that now, so that we can all join it and see what is happening. I don't want to preempt anything else other than just sort of say what is there. But of course, one can only say we don't know what that judgment is going to be until it actually happens. So let us see what is going on here. I want to make sure that you do not have things that are unnecessary in the broadcast. So that's why I'm trying to check. So now let us go back here. I think we're back. I think it is safe to say that we are back. Let me see if I can. I'm going to try and bring that down so that you can see it in its entirety and not miss out on anything per se. We do not want you to miss out on anything that is on the screen. Then we will start showing it properly, because we do believe that you need to have this access to this information yourself. That's just rather, I don't understand why that is happening there, but don't worry, we will get it sorted out. Of course, we will do that. So let us do this. We're just trying to check everything before we proceed, so that you can follow the live broadcast uninterrupted. It's very important we provide that as we go forward. So yeah, let's two things to keep in mind: the decision of the courts as to how they see it, and going forward, that decision, and it's something that for us all to think about. So let's hopefully we'll be able to get through. I'm still be looking at other means to give this to you live, but let's see. We're gonna try and play it. Let's play first for a while. So yeah, hang on a minute. I don't know what's happened there. You see, that's why I didn't want that to happen. I wanted you to have the underrated thing, but you see, sometimes you do have to look at things from that point of view. Okay, so Go ahead then. That's why I wanted to check that. Okay. So I'm just giving me, bear with me. I don't know what's happening, but we're gonna try and play that for you. Just bear with me. We're trying to get that working,
opportunity to react to it.
Here
It's my humble view that the position of the law, as can be gleaned from the section 2855 of the Constitution, paragraph 4, 14.2 and 16.1 of First Schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use for exploit to overreach the respondents. That is the stand of the Supreme Court, Oke and Mimiko, number 1 Supra, followed by this court, Oba and Vincent Supra, those of court. Again, in Ararume and another, but Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. Therefore means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, aligned with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the First Schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or aspire witnesses, and whether they are willing or are supreme witnesses, their witness deposition must be filed along with the petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiagu, SAN, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a supreme witness, Ama Ibom Abu, PW2, on the same ground that the witness statement on oath of the same witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on supreme witnesses in election petitions, favored by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed filed at the registry of this court by the petitioner counsel, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by short summons as stipulated in paragraph 42, sub 1 of the First Schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. Clear from the provisions of that paragraph that is a person summoned by the court suo motu in exercise of its powers under paragraph 42(1), that is a witness of the court and not a person subpoenaed at the request of a party to the case.
Interesting.
In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, 2 flash drives containing third annex consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is a staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 election in Nigeria. PW6 is a staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Day, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS health dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious. This is a serious matter, it's not a last one. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the present elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, the metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as exhibit PCR, was, however, addressed to him personally and not through INEC. It's pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PF2, Tender 3 PW4. Exhibits PCG1 and PCG2, Tender 3 through PW5. Exhibit PCH1, Tender through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, Tender through PW7. And exhibits PCK1 and PCK2, Tender through PW8. The said exhibits are, I have estimated them in the judgment. The respondents' essential argument is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 5(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoenaed witnesses, whom we have already declared incompetent, because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 45(b) of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be expunged from the record. In the case of Buhari and INEC, the petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from the bar pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by the order of the court, since the same has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it's stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself by so doing. Ishanu and AfriBank are way for JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph D2A, restated the position of the law that even when pieces of evidence had been improperly received in evidence, trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondents to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1, PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83, Subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that, as provided in Section 83, Subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court, that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. As in Latwaja and Ajimobi, where the Supreme Court, by Peter Odili, JSC held as follows: our court. In respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards the phrase, a person interest, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested in which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91 of Section 3, which is now the Section 83.3. I think the phrase, a person interested, ever more so has been quite definitely put in the case of Halton and Halton to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings and therefore would have no temptation to pervert the truth to serve his personal, private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. VPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence and Truth and Health does. By the provision of Section 91.3 Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding and therefore will have no have temptation to pervert the truth, serve his personal, private ends. In fact, it is in its most recent decision in Oyetola and another versus Annex, the Supreme Court, arguing JSC, restated this position in the following words. The other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis, carried out the analysis from the conclusion that the results were invalid. It testified to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents to be relied on to prove the petition it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition, when the petition was anticipated to establish that the election result was invalid, is not admissible evidence by virtue of Section 83.3 of the Evidence Act 2011 as amended. Close of court. In the instant case, EW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by a second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed on 20th March 2023. Obviously, the report Exhibit PCD1, PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness. He admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. He also admitted that the report she presented in Exhibits PCJ A to F are public information posted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and
One second, please. One second, please. Just a bit of a technical fault this end. We're trying to resolve it quickly. Sometimes it does happen, so just bear with us, please. Thank you. It's still, the court process is still going. We just want to get back in.
PCG2, PCH1, PCJ1, PCJ2, PCJ3F, PCJ4, PCK1, and PCK4 tended through the incompetent PW4, 5, 6, 7, 8 are hereby extended from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection to Exhibit PBP1 to PBP21, the IRF report for Adamawa State, on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCB1 to PCB6, referred to by the petitioners in response to the objection, are IRF certificates of compliance for Bayelsa, Benue, Ikiti, Niger, Ogun, and River States. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually Beavers reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of.
Thank you very much for your understanding and for supporting us. Please continue to subscribe to Season A, the platform where we speak with power. Thank you so much.
PCA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from Annex IRF portal and were certified by Annex as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by Annex authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and BC, where the Apex Court held that the computers from internet-generated documents printed from the website of a public institution is a public document. Only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 admissible. That I've cited the dictum of Supreme Court by Akas JSC Court. Exhibits PBP1 to PBP21 having been downloaded from INEC report and duly certified by INEC are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive tendered by PW5, the staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of its production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2020 final report. As rightly observed by the fourth respondent, the photocopy of the document is certified by a secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104.1 of the Evidence Act 2011, secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of same to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and where he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104.1 of the Evidence Act 2011. The Omiseri and Arebashola Manuel Vasumana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit H2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit H2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts over the documents objected to. The said documents objected to by the respondents are so many they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to PCC, that paragraph. However, election petitions are sui generis, and it is certain that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore, Ahmed, Yazu, and Oti. In the latter case of PDP and ANIC, the Supreme Court was categorical on this mandatory requirement for specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting, several polling points, disruption of election, non-conclusion of election, printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars, or the polling units where the alleged malpractice took place. Lower court was therefore right when it held as follows. Paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be biased. The fact that a party can file further particulars, but deny in a reply. The vermin in the pleading must not be general, it must be specific as to facts. The settled law that a petitioner's obligation to plead particulars of fraud or falsification, without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court.
3 or 4.
That's where allegations of non-compliance and corrupt practices are made, such as in the instant petition, the polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent, its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practice in the same set of facts pleaded above. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Oyo, Ondo, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioners failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have
just a slight pause. I'm not quite sure what's happening there.
averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioner failed to state the scores improperly computed
Please subscribe
and
to
how they were
the platform where we speak
favored.
to power. Thank you.
As regards to objection to exhibits PCE1 to
Special thanks to our moderator.
it to be 18,084 and 88 large results
Please
downloaded from IREF and contained in 4 boxes.
Thank you. Help us grow the
The
platform.
petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units, which those large reports relate, is an impossibility because the results are unreadable. The details of most of the polling units are stated in PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 large results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report of PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report
Good afternoon,
was
and
the IRF portal.
Azubrike, thank you very much for
Did
joining
not
us.
state how he was able to determine
Please,
the
we urge
particular
you
polling
to subscribe
units
to Susan Ewa on
and-
YouTube and help us grow the
and
platform
the
on
impacted
YouTube.
votes,
We
accredited
have
voters,
over
and the number of
19,000
PVCs
followers on
collected.
Facebook, but Facebook
As I earlier stated,
unpredictable, so we are trying to grow the platform on YouTube. So please be kind
as I earlier
to join
noted,
us, subscribe to Susan Ewa
PW4's
on
report
YouTube,
was
help us grow the
concluded
platform.
on
We
19th
appreciate
March
your support.
2023 before the
We
petitioners
need to give you
filed
very
this
important
petition
information
on 20th March
about
2023,
how we see
which
things
means the
progressing
petitioners
in
were
what we
aware
call Nigeria.
of
So
the polling
thank you for
units
joining us.
to which their
Please go ahead and
complaints
subscribe
relate,
to Susan Ewa
even
on
before they
YouTube.
filed the petition.
Thank you.
So their theory of impossibility which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows.
I want to
Paragraph
take this
7.
opportunity to
The
greet those of
petitioner
you
is
who
the
are
body
watching us
corporate
on
with perpetual succession and in
Oduduwa TV
sponsorship
Radio.
of
Thank
the
you all
first
so very
petitioner
much. Please don't forget,
and the conduct
we
of the
also would
election
like you to
thereof,
subscribe to
acted
Cinema
through
on
its
YouTube, and
members
of course
duly
Oduduwa
appointed
TV
as
Radio 2
agents
on
at all
Facebook.
stages of
You're
the
very much
election,
appreciated.
namely
The programs
at
that
the
we
polling
do
units,
on
the
Oduduwa
ward
TV
collation
Radio
centers,
is
local
in
government collation
Yoruba,
centers,
and we are
state
streaming
collation center,
multi-streaming
and the ultimate
on
collation center at the federal level
and
in Abuja.
Oduduwa TV Radio
Paragraph 8.
simultaneously. And
In the conduct of the election, the agents duly appointed by the petitioners performed their
and other
assigned
platforms
and
that we possess,
statutory
that we have.
statutorily
So we want to thank you very much for your support. Please continue to help us share the broadcast.
designated
Subscribe to Cinema on
roles
YouTube
at
and
the
of course,
election.
Oduduwa TV Radio
Those
2
roles,
on YouTube. Thank you.
these roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form upon the first respondent agent duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioners' contention that they have complied with paragraphs 4, 5C, and 41A of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the corresponding objection to petitioner's pleadings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials stated in paragraph 41(1)(d) and 2 and 41(8) of the same schedule, so as to enable the adverse party to know the exact case he is to make and to respond to them accordingly. As stated in our
It seems to be
earlier
paused
in
in
the
what is
report,
written,
which the
but I
petitioner
suppose
stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent opportunity to respond to same, but was merely tendered at trial, by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 ballot results relate, the state documents are clearly inadmissible. State exhibits hereby discountenance and expunged from the record. We now go to petitioner objections to the respondent's documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, F5, 6, and 7 through his sole witness, Dr. Lawrence Bayode, a deputy director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opeyemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objection to be adduced at the stage of final address. Pursuant to the order of this court, that parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondents. The written address in support of the objection of the first respondent documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent document, Dr. Livy Uzoku, Land Senior Counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and cited cases, exhibits R8, 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent documents, the petitioners raised the sole issue of whether, having regard to the said pre-hearing session report and paragraph 41(3) of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Plaintiff pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, the witness of the first respondent, thus RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate at the same time. Since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. Then we just go direct to the resolutions. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. And the case of Onwuzurike and Doziem and others, where the Supreme Court by Onogen BSc held, as it then was, held that a private document sent to the police form part of the record and of the police and is consequently a public document within the provision of Section 109 of the Old Evidence Act, now Section 102 of the Extant Evidence Act 2011. It also tried that a public document duly so satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party to the case. See the case of Maranro and Adebisi, Agash and Bulama, Mustafa, Shettima and others versus Al-Haji Bukar Custom. Exhibits RA1 and RA2 being in the public record of the first respondent are public documents and are therefore admissible in evidence, having been certified by the first respondent under Section 104 of the Evidence Act 2011. On the petition objection to Exhibits RA6 and RA7, the record of proceedings of this court of 4th July 2023 shows that contrary to the assertion of the petitioners, the said Exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance to Section 84 of the Evidence Act respectively, were not tendered from the bar but through RW1. Indeed, the record shows that the petitioners consented to the said documents being taken as read and demonstrated, therefore have no hesitation in discountenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to Exhibits RA1, RA2, RA6, and RA7 tendered first respondents and meritorious, it is hereby overruled.
Overruled.
Now go to objection to the petition objection to the second and third respondents' documents. We consider the
yeah, we're gonna listen to this for a few more minutes, for to its entirety. But we are trying to see if we can do this also on space, spaces on X as well. We're working on that. We'll see if we can bring that and link it to the broadcast as well, because that's really important what is going on here. Okay, let's see how that goes. Thank you.
Yes, the resolution without objection on the petition objection to exhibits RA8 and RA9. An examination of the petition shows that in paragraph 28, they have challenged the simple respondent qualification to contest the election on the ground that he was fined a sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightly submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, and confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, a centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants against the second respondent. The respondents shall found and rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Yes, the date is wrongly stated, corrected. From the foregoing, it is obvious that issues were joined by the parties on the indictment alleged by the petitioners, and Exhibit RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, Exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while Exhibit RA9 is the reply to Exhibit RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigerian police and are therefore public documents under Section 102B of the Evidence Act. Certification by the Nigerian Police Force is a confirmation that Exhibits RA8 and RA9 are true copies of those documents which are in their custody. Onwuzurike and Idozem, Abaji and Koka. With regard to the petition objection to the relevance of Exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioner have not joined issues with the second and third respondents in their reply to the second and third respondent reply. That the court of law adjudicates only on matters over which parties are in dispute. The DDG and Olosho and another Trade Bank PLC versus Benelux Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to the termination of this petition, hereby discountenance. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioners have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking, and in response to this allocation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore a considered view that Exhibit RA 11 and RA 16 are relevant to these proceedings. Petitioner objection to them hereby discountenanced. As for Exhibits RA 17 and RA 18, the petitioner's reason for objection to them has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's local standard to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's local standing whilst resolving the respondents' preliminary objections. We have already resolved same in favor of the petitioners. Therefore, this objection has been overtaken by our ruling on the preliminary objection. On the petitioner contention that Exhibit RA 19, the report of the committee on the location of the federal capital Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and returned elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which renders Exhibit RA 19 relevant. On the petitioner's objection to the admissibility of Exhibit RA 22, we observe that the document is the same as Exhibit RA 2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. Standard of Exhibit RA 22, which is not even certified, is therefore a surplusage, hereby discountenanced. With regard to the objection to admissibility of Exhibits RA 24 and RA 25, which are CTCs of pages 20 and 29 and 27 of Nigerian Tribune newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA 27, the ECOWAS preliminary declaration, is a private document. Said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under the ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. It's undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA 27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA 27 is hereby expunged from the record. As for the objection to Exhibit RA 28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it's clear to us that the document was neither pleaded nor listed or referred to in the statement of PW2. RW2, sorry. As rightly argued by the petitioners, Exhibit RA 28 is inadmissible. Accordingly, it is hereby expunged record. Now we go to the merit of the petition. Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their respective final written addresses, starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Land Senior Counsel for the first respondent, A.B. Mahmoud SN, distilled the following 5 issues for determination. A. Whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election 25th February 2023. B. Having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2022, the inability of the first respondent transfer or transmit the results of the presidential election to the IREF portal real time. Amounted to non-compliance to Electoral Act, whether such non-compliance substantially affected the outcome of the election. B. Whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D. Whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by majority of lawful votes cast. E. Whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the state's federation. The Land Senior Advocate for the second and third respondents, Chief Wale Olani Pekun, formulated the following 4 issues for determination. 1. Having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, salient provisions of the Electoral Act 2022, Judgement of Federal High Court, and FACA BJCS 1454/2022, Labour Party and INEC delivered on 23rd January 2023, which is X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 26 February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission (INEC), delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 26 February 2023. 3. Upon a combined reading of sections 134 and 299 as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitutional petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, Senior Counsel for the fourth respondent, also nominated 4 issues for termination as follows. 1. Whether having regard to the issues joined and the evidence led on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the District Court in case number 93C4483. The petitioners have established that second respondent was not qualified to contest the presidential election held on 26 February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 26 February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority or lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25 February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. On the part of the petitioners, their lead senior counsel, Dr. Livy Uzoku SN, distilled the following 3 issues in the petitioner final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, Subsection 1D, 142, Subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2022. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Electoral Act 2022 and the statutory legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25 February 2023. In response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for determination with the earlier filed on 18th May 2023 during the pre-hearing session. These are 1. Whether the second respondent at the time of the presidential election held on 25th day of February 2023 was not disqualified to contest the said election by virtue of the provision Section 1371D of the Constitution of the Federal Republic of Nigeria amended. 2. Whether the third respondent at the time of the presidential election held on 25th February 2023 was qualified to contest the said election as the vice president candidate to the second respondent, and if answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3. Whether the presidential election held on 25th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and early guidelines and regulations for the conduct of the election 2022 made partial to the Act. From the pleadings, the evidence adduced, and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1. Whether having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the Evidence and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. 2. Whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022, and that the non-compliance substantially affected the results of the election. 3. Whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 26 February 2023 was invalid by reason of corrupt practices. 4. Whether from the evidence adduced by the petitioners have established that the second respondent was not duly elected by majority of lawful votes.
And we're on MySpace and we are on YouTube and Facebook. So I'm going to answer Vivian here. She's a moderator on.
As we stated earlier, we have summarized the submissions of counsel. We didn't want you to reading them out.
So I want Atiku, who claimed they came second. See, they know Atiku will never go against his brother in Niger. Yeah. So
the first issue is
they're being threatened. Yeah.
Whether having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023.
So, ladies and gentlemen, you're listening to the judgment, the ongoing judgment and the case of the president elections, Tinubu, and of course, case brought by Peter Obi and Atiku, and the grounds upon which they are contesting elections. This been addressed, and will democracy remain after this in Nigeria? Depending on where this judgment falls, it's looking like it's going to support President Tinubu.
Well, I think.
But let's proceed.
Issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution. This issue.
So we're looking at it.
The only exception is the allegation on the issue of second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 32 of the petition, is that the second respondent is disqualified from contesting the presidential election because they stated in paragraph 28 of the petition as follows. The petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest the election to the office of president, as he was fined the sum of $460,000, one offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in the account of 263226 held by First Heritage Bank in the name of Bola Tinubu. Funds in the accounts 394833134, 394833396, 4650279566 held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in accounts number data held by Citibank International in the name of Bola Tinubu Dependents. The petitioners have pleaded and relied on the order of the U.S. court in P5, which they tendered from the bar, and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine or any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court.
This is going to be interesting.
Tribunal was substituted by a competent court, by a competent authority, or any other sentence imposed on him by such court or tribunal. A careful examination of the above provision shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary, 6th edition, at page 1081, defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights. As unpunishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. The judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph E of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held,
1371, you see, I read it before.
In Action Congress versus ANIC, as follows. The disqualification in section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt or embezzlement or fraud in derogation of the safeguards in section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. clearly imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offences by an administrative panel of inquiry implies a presumption of guilt, contrary to Section 36 of Section 5 of the Constitution of the Federal Republic of Nigeria 1999, whereas conviction for offences and imposition of penalties and punishment are matters appertaining exclusively to official power.
Moderator there.
See also the cases of Amici and Anis Omuwaye versus Attorney General of
Nigeria, weak party all over.
Karim and others versus Shinkafi.
Atimo, Boshinlo. Yeah. I can't argue with it.
The careful perusal of the careful perusal of Exhibit 5 relied upon by the petitioners so that the case number
this on both
193
Facebook on
TV 04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank N.A. N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personal against the second respondent.
What are your thoughts? How are you seeing this?
In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held in inter alia that Section 17 of the Advance Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture property under Section 17 of the Advance Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Baths Limited was very from Nigeria, Elizon Madoike versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud, envisaged in Section 137 of Section 1D of the Constitution, is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted, or charged, or arraigned, tried, and convicted, and was sentenced any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement on oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49.
It is quite a concern. Welcome
in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Region, which was pleaded by the petitioner.
Comments. We appreciate you.
1. No criminal charge was filed against the second respondent. 2. The second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime.
What is
3.
the response
The second respondent did not go through a criminal trial. 4. The second respondent was not convicted of any crime or any criminal activity.
We are already looking at
5. No sentence of imprisonment was imposed on the second respondent. 6. No sentence of fine was imposed on the second respondent.
Nigeria is a legal fiction entity.
7. No form of sentence was imposed on the second respondent. Case
Free
number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345
and 1355. They are keeping President Tinubu is going to be in place by the judgment. From what we can see in the judgment, it looks like President
In
Tinubu
paragraph 47, he said, I also know that in case number 93C 4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent.
Just trying to see
49. The second respondent was not convicted in case number 93C 4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks for the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, the Centralized Information Center, that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely on the copy of the said letter of February 4, 2023, signed by Michael M. Bonner.
we are surmising that
Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in that state, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil and not
Can anything be done to change this?
982,
What is the way
which
forward
is criminal,
for collection?
and which the petitioner
How does
stated
this
in their
impact
petition.
our economy?
He further stated that in the
What is
US,
being said
in the
here
US,
is what I
even a
think is
minor
being said.
traffic
I don't know, either
infraction
way.
will
Either way,
be
how does it
reported.
impact us?
So that if someone
These are
has a criminal
fundamental
record,
questions that all of us
general
have to
record,
go
show
in
it.
and look
He
at
added that
and
a
listen
general
and
search
really
was
think
conducted
about.
in respect of
How
the
does this
second respondent.
impact us?
A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied with the exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC, ABJ, volume 24 to 89, regarding Governor Bola Ahmed Tinubu, the record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest.
And saying if you see
Record
how you
once
if you
or
doing how you
Bola
say
Ahmed Tinubu,
that
EOB
doesn't really
29 date of
solve
birth,
the problem.
March 1952.
I mean,
For information
those
of
of you
your
watching, what are your thoughts now?
department,
We can
NCIC
conclusively, I mean,
is
we can almost
centralized
say now for
information
a fact
center that maintains the
Tinubu
record
is now going
every
to be the president, and that's this case is going to be
criminal arrest and
been
conviction
decided
within the United States
So
and its
as we're
territories.
seeing that, what are
Apart
your
from the
thoughts on
above,
this? How do
Section
you see it?
249
How are
of the
you
Evidence
doing
Act 2011 has stipulated how previous criminal convictions outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2. A certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America while a crime was alleged to have been committed by the second
How do you
respondent.
feel about this? I'm asking generally. I'm genuinely
It's
asking.
significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case, not on the weakness of the respondents.
How are you reading this?
Okereke vs. Umahi, Minike vs. PDP, Omushore vs. Rebushola, Ucha and Elechi.
It's crazy.
The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1991 Constitution because he was fined a sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine or an offense involving dishonesty or fraud within the contemplation of Section 137 of D of the 1999 Constitution. As regards whether paragraph E of Section 1, as regards whether paragraph E of Section 137(1) will be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision, on the principle that by enacting a separate provision for a part of the general class intends that the same part not be treated same with the general class.
This is worrying. This is a concern, ladies and gentlemen. We are confirming that the status quo remains. How will this translate? What will this translate to on the nation?
In both paragraph D and E of Section 137,
going to remain one? Is
the
it
sentence
gone?
for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced.
Let
Then
me know
it
what
means,
you think.
in respect of the sentence for offense of dishonesty, the two paragraphs must be read together. That for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used
section
for
provision.
qualifying
Exactly. This is what I mean. It is a way. I agree with you. What is you not
It is also a cardinal principle of
you said
interpretation of
something. You
Constitution
said,
that relevant
unfortunately,
provisions
the
must be read
judicial
together
trial is
and
not translated into
bent
Nigerian indigenous people language. All this section provision. That's very, very true. If it was in our language, the people will, this is what I mean. We need
from
this
all
in
the
our
foregoing,
local
it is
language.
clear that having regard to the
It is a way
provisions
to keep
of
us
Section 137 of the Constitution of Federal Republic of Nigeria 1999
It's almost
as
like a way
amended
to
and the evidence laid before this court, the second respondent was
deny
not disqualified from contesting the presidential election held on 26 February 2023.
very valid
Consequent
point
issue
made there.
1
Why
is hereby
should we do
resolved
that?
against the petitioners and in favor of the respondent.
So
Issue 2 is
in favor
whether,
of the,
having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022, and that the non-compliance substantially affected the results of the election.
Wow. Wow. This has huge ramifications. This has huge ramifications. What is going on right now?
Then we shall.
This has huge
skip
ramifications. Let us hear your thoughts.
Commissions of council.
This has huge ramifications.
But the
Please don't
appropriate
forget to go ahead and
starting
subscribe.
point
This is an
for the
NY
resolution
on
of this
YouTube,
issue
the
is to
platform
first
where we
consider
speak
the
to the
objection
power. We are
of the
listening to the
first
judgment
respondent, grant 2 of the
electoral,
petition, which they raised at preliminary stage,
election
at which
that
we deferred
President
the
Tinubu
stage. Because
whether
it
you
touches
for or
on the
against,
substance of the petition.
whether you're in or out, whether you...
The first respondent objection
whether
is
you
that
are
the
local,
petitioners
you
are stopped from litigating the issue contained in paragraph 2,
is this going
paragraph
to
33 to
our
79,
nation?
as well as reliefs 5.1
What is it going to do?
and 2 of the petition, as is released to electronic
and what does this
transmission
say?
and collation of the election results.
Does
in
this,
view of the subsistent
does this,
judgment
side,
of the Federal
does
High
this
Court,
lessen the
in
clamor
suit number
for Yoruba Nation, Biafra Nation? Does it lessen it?
1454
Knowing fully well, in the
Labour
minds
Party
of many, it's
Independent
likely
Electoral
people will
Commission,
probably see that this
delivered
judgment
23rd
hasn't
January
been fair
2023.
in their eyes. Will it lessen it? We're just asking questions. I don't know.
Certified.
I mean, I'm not. We cannot. All we can do is to really talk about it.
2 copies of which they
what
attached
is
their
your thoughts on
petition
this?
as
How are you
Exhibit
reading
A,
it?
and which was later entered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55
concerning.
and 74 of the petition, and submitted that the facts alleging non-compliance
so we are still on X space, of course.
which are set out in paragraph 36 of the petition
judgment.
are hinged on the same issue of
the
electronic
judgment is
transmission of results,
damning.
which was resolved against the second petitioner in the said suit number FHC ABJ SC 145.
One thing we can say is
the effect that there is no mandatory requirement
for
the first respondent to electronically transmit results of the election. Reliance was placed on Bamdegin and others was Oriade, Oye Roba, and another was Laupa. An examination of petitioner petition and Exhibit X1 shows that in their petition, specifically paragraph 37.45,
what is your reaction?
And 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transmit or
things that we're asking.
Or transfer rather the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal RF in real time. 45.
So do this.
The petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of the result, 1. Electronically transmit the result of the polling unit directly to the collation system as described by the first respondent. 2. Use the beavers, upload or a scanned copy of the Form EC8A to the annual result viewing portal RF as prescribed by the first respondent. And 3. Send the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area reward collation officer in the company of security agents.
So we are looking at it. We're trying to see
the polling agents may accompany the presiding officer to the registration area.
How are you seeing this? How does it look like to you?
In Exhibit S1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454/2022 Super, which the first respondent is contending to constitute estoppel to ground 2 of this petition.
This is
the sole question presented for examination in the original summons
should
as
really
follows.
be in our languages.
Whether, having regard to combined effect of sections 47.2, 52, 64,
there should be a
55,
simultaneous
and 61 and 2, and other relevant provisions of the Electoral Act 2022.
This kind of thing.
The respondent can
There should
still
be every
insist
effort made
on manual
to
collation of
translate this
results
into our local
before
languages.
forthcoming general election. Upon
So,
determination
hi,
of
Vivian, my
the
sister,
above questions,
welcome on board.
the
Yes,
plaintiff,
yes,
which is the
yes,
second
yes.
petitioner
I'm glad
herein,
to see you.
sought for the following reliefs.
Moderators of the
1.
platform
A
chatting.
declaration that the
Appreciate you.
respondent has no power to
we
opt
are
for
trying to
manual
build
method
that platform
rather
on
than electronic
YouTube.
method provided
Thank
for
you
by
so
the
much
relevant provisions
for
of the
discussion,
Electoral Act.
for your
2. An order of this
listening.
honorable court
So,
directing
what is,
from compelling the respondent to comply with the Electoral Act 22 in electronic transmission of results in the forthcoming general
in this
election.
house for some time. So thank you.
In its
both
judgment
so
in
very
Exhibit
much.
X1, the Federal High Court
And
held
it's
as
just
follows.
allow us to be able to
In view of the foregoing,
to give
can
a
the act
better-
of the
much
defendant
better,
in collecting and transferring election results
service to
manually in the forthcoming 2023 general election
platform
is said to be contrary to the relevant provisions of the Electoral Act
to
2022?
engage with
The answer can only be in the negative,
or who
as
will
there
tune
is
in
nowhere
to
in the above cited
we
section
really appreciate
where
you
the Commission
very much.
or
We
any
appreciate
of
the
its
work
agents is
that you're
mandated to only use an electronic means
what is
of collecting
worrying
or
is
transferring,
this
transferring of election
we
results.
should always
If any, the
remember that
Commission
this
only
judgment is
mandated to
translated
collect and
our
transfer the
community
election
in our
results
languages.
and number
We
of
should have
accredited
3
voters in the way
translators
on
on the screen
manner
right now.
deemed by
In
it.
Hausa, in Igbo,
In view of the above, I
at
am
least. Yes, we can talk about it, but at least we begin to
I'm
provide
finding that by the provision of sections 52 and
perhaps even have
65
simultaneous
of the
translation
Electoral
to all
2022,
communities as we
the
speak.
correct interpretation of
I
said
think
statute
we
is
need
that
that
the defendant,
because
Independent
this is
National
really
Electoral
worrying
Commission,
what's going on.
is at liberty
I
to
think we
prescribe
should
the
all be
manner in
concerned.
which
These are
election
we are
results
in really
will be
critical
transmitted
times now.
and are so called. Consequently, this matter is hereby dismissed. Clause of court. It is tried law that for a judgment of a court to constitute estoppel in a subsequent action,
Wow.
it must have finally decided the same issue in contention between the same parties or their previous.
Wow.
The Anchorage Leisures Limited and others versus Eco Bank Limited.
This is
and
Amori.
Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that it was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers upload a scanned copy of the Form ECNA, the first respondent result
to use
viewing
grammar
portal,
to pummel the citizens into submission. And that is
First,
not right.
it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. From the above referred to averments in this petition and the relief sought by the petitioner in second petitioner, in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system.
Yeah.
With the judgment of the Federal High Court X, the excerpt of which has been reproduced above, it is evident that the Federal High Court had decided the issue against the petitioners herein by holding that the first respondent cannot be compelled to electronically transmit election results.
Wow.
There is no evidence before this court that the second petitioner against whom the judgment X1 was given has appealed against that decision. The settled law that unappealed decision of the court remains subsisting, binding on the parties. The Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the Labour Division of this court in appeal number CA/LAG/CV/332 of 2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FLC/L/CS/370/23, Labour Party and others versus ANIL. Another case, forum shopped by the second petitioner at the Labour Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CALG-CV-332-2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner's contention, which they are making in this petition, that INEC is mandatorily required to electronically transmit election results. By virtue of Section 122 of Section 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CALG-CV-332-2023, APC versus Labour Party and 42 others.
Okay.
Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncement, decided that under the Electoral Act and admin regulation guidelines for the court of election,
I see your point,
first
and I can't argue
cannot be
with
compelled to electronically transmit election results.
In that
the
respect,
petitioners are clearly stopped by those decisions from contending ground two of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system.
Thoughts on the judgment, you know? So, what are your thoughts?
As a court of first instance,
the case effectively against
this petition, we shall notwithstanding our above finding proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seems to us that the to me that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of petition, while specific allegations of corrupt practices were made in paragraph 60 to 78, even though them were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of petition, which are produced below. Have produced.
So
the respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. He further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election.
View on this. I think that's the most important.
Paragraph 31 of the first respondent's reply. He also stated that the VIVAS is designed to upload the accreditation data at the end of the accreditation process and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal. First respondent further advised that the upload of data or images captured and automatically restored on the VIVAS device requires data service, and where there is no such data service, where the service is poor, the VIVAS service is designed to work offline. The upload of data will occur when data service is available.
Live on air.
He also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election. But some of the results were not visible on the IRF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure,
so there you go, subscribe to
refusal and neglect to instantly transmit and upload the results electronically from the VIVAS to the IRF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows.
So, thank you for that. Subscribe to us on YouTube.
Immediately after the election of 25th February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the VIVAS. There was a temporary failure of communication between the e-transmission system and the IRF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the IRF portal because it could not map the result uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error of technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the IRF portal. The results are available
in all
generated in the original form using the VIVAS. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was any technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to upload the presidential election results using the VIVAS to the average was employed to manipulate the actual results of the election.
Listening to the case, fact of the matter, and coming to a reasonable.
As indicated in their pleadings and submissions of counsel, the petitioner's allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of Election 22 is anchored on the provisions of sections 47.2, 61.2 and 5, 64.4a and b, 64.5 and some 3.2 of the Electoral Act and paragraph 38(1) and 2, 48A, B, C, 55, Roman 5, 7 and 20, 51(2), 54(12), and 55(12), 93 of the regulations and guidelines. I have carefully considered the submissions of the parties on this issue
what are your
of
thoughts
non-compliance
on what we're
Electoral
hearing?
Act and the paragraphs of,
What does it
of
sound
the
like to you?
regulations and guidelines for the conduct of the election 2022.
What does it sound like
The
to you?
Independent National Electoral Commission,
How are you seeing this?
the first respondent hearing, is established by Section 155
I'll
53,
be calling
subsection
back
1F of the
and
Constitution
live
of the
broadcast on my
Federal Republic of Nigeria
board.
99, and part of its functions are stated
do
on
that
paragraph
separately. I'll be
15
adding
in
that
Item
to
F, Part 1 of the
the
third schedule to the
talk about things
State
like
Constitution, is to organize, undertake, and supervise elections, including election to the office of the President and Vice President, among other political officers listed. Being a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158, subsection 1 of the Constitution, INEC shall not be subject to direction or control of any authority person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission.
Okay.
Further, Section 64(4) states that the collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected result are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 Act.
Anybody know?
And B, the votes
likely to
stated
happen?
on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under
Sunday,
Section
good
60,
afternoon to you,
subsection
my
4
brother.
of the Act.
What is
At
likely
this
to
stage,
happen?
it
You are
should be
listening to
noted
the
that Section
judgment
47
of
sub 2 referred to in
the
Section
Court of Appeal, I believe it
54(4)A
is, whereby
relates
they've
to
now
the
decided
procedure
that
for accreditation
they've
of
thrown out the
voters
case
by the presiding
against
officer
they've thrown out the
using
case
the
against
technological
Tinubu
device prescribed
and
by the
Shettima
Commission.
on the basis of some
As for Section
laws
64,
that they are
referred to in
putting to us.
Section
The question I want to ask is,
44B of the Act,
what is
it
the
only
impact
mandates
of
the
this on
presiding
the
officer
people?
to count and announce
What
the
does this
results at the
do
polling
to
unit.
the democracy
In fact,
in
Section
Nigeria? That's
Section
the
5
question I want to
of
ask.
Section 60 goes ahead to
Yes,
mandate
at
the
least
presiding
translate in
officer to
broken
transfer
English.
the results,
VV, yes.
including total
Yes.
number of accredited voters
Translate in
and
broken
the results
English. I
of the
agree.
ballot in a manner
That is very
prescribed
important for
by the
people to
Commission.
know what is being said.
The
And
Act
I
also
think you're
provides
right.
in Section 64(5) that the
those of
collection
you joining
officer
us
or
on the
returning
MySpace,
officer
X
shall use the
Space,
number of accredited
welcome on
voters
board,
recorded
Sunday,
and
I
transmitted
recognize you.
directly
I
from polling
recognize
units
your thinking,
under Section 47
your
2
comments.
of the Act, and the votes or results recorded and transmitted directly from polling
Thank you
units
for
under
listening.
Section 64 of the Act to
we are
collect and announce the result
translating-
of
we're-
an
we're
election
playing
if
the-
a collected result
the live,
at his or her lower level
the
of collection
live
is not correct.
audio of the judgment as it's being read out of the court. and it's
From
on
the aforementioned
X
section,
space
it is
here.
clear that while subsection 4
what we
of
are asking
section
is,
64 provides
as
for what the
citizens
collation or
in that
return
nation,
officer
what is
will
the
use to
impact of
verify and
this
collect the results.
on
Subsection 5
our
also
democracy?
provides for what the collation or
What
return
is
officer
the,
will use
how
to
do
collect the
people feel
results.
about this?
Subsection
That's
6
the question we're
of the
asking.
same section
We're not
provides for what the
here
collation or
to
return officer will use to determine
pass
the
judgment or
correctness
anything.
of
We
the
just want to
results where
reflect
there
what
is
the
a
people are
dispute.
feeling.
These are
And I think that is one
the
of the things
original
we
of
need
the
to do.
disputed collected
We
results
should
for each polling unit
reflect
where the
what the
election is
people
disputed,
really feel. Sorry
which
about
in
that.
our view means
We
the
just want to
physical
reflect
or
the
hard
feelings
copy
of the
of the
people
disputed
in
result.
what they are
B,
facing.
the technological
And
device
it's
used for
best not
accreditation
to
of
actually
voters
make
in
any
each polling unit where the election
judgment.
is
The
disputed.
court case, Chidalu, good
The
afternoon to
data
you.
of accreditation recorded and
And
transmitted
I want to,
directly
if you do want
from
to
each
talk
polling unit
or discuss
where the election
on
is
this
disputed,
discussion,
as prescribed
just
under
indicate
section
and I'll add
47
you as a
subsection 2 of the
as
Act. And D, the votes
what's
and
it called?
result of the election
As a
recorded
speaker,
and
so you can
transmitted
speak.
directly
Because what is
from
really
each
going on
polling
here? In
unit
fact, I'll
where
invite
the
you as a
election is
speaker.
disputed and,
So if you do want to
as
speak, you
prescribed
can.
under section 64
You
sub
can
4
speak.
of the Act,
I'm going to
which
invite
requires
you
only
to
the
speak.
counting and
And if
announcement
you want
of
to
those
talk about this,
polling
because
units.
we need to begin to really address
Careful
the
examination
concerns
of the
and
above
this is
section
bringing serious
that
concerns.
opened by the petitioners
And I don't
shows that
know
the
if
Electoral Act had used the
I don't know
words
how you're
deliver
reading this,
in
but
section
it is
60
a big
subsection
concern.
1,
For
transfer
those of you watching
in
us
section 60
on
subsection 5, and transmitted
YouTube and
directly
Facebook, we are
in
also on
section
X,
50 sub
on
4,
X space,
5 and 6 of the
doing
Electoral
a
Act
simultaneous live
2022,
broadcast.
and stating how
You can
results
hear the
of
audio in the
election should be
background
handled under those
of the
provisions.
judge. This has huge ramifications for all of us. So I want to just say thank
A
you.
look at the
You're
definitions
for
of those
coming in.
words in the Blackflow Dictionary 6th edition
keen
shows
for
that
things to just-
the word transfer is
which way
defined
forward?
at page
Which way?
1497
Which way?
as to convey
You know,
or
Sonny
remove
Okosu
from
said,
one place,
which way
person,
Nigeria,
etc. to another,
which
to
way
another,
Nigeria,
or to pass or
Which
hand
way
over from one to
Nigeria?
another, or
which way
specifically,
Nigeria, which
or
way?
to specifically to change over the possession
Are we sure?
or control. The word
Is
transmit,
this-
on the other hand,
Does this
is
judgment
defined by
have
the same law
overwhelming
dictionary
support
to
of the
mean to
people?
send
That's the
or
question we're
transfer
asking.
from one
Does
person
it have the
place to
overwhelming
another
support
or
of
to
the people?
communicate. In
And
my
what
view,
does this say
the Electoral
about
Act
the rule of
2022
law in
has used the
Nigeria?
words deliver, transfer,
I'm
and
just asking a
transmitted
simple
directly,
question. I'm not here
interchangeably,
to
to
judge.
describe how the results of the
Will
election
this move
shall
the
be
nation
moved
forward?
from one state to another
These are
until the
questions
results
that we
are finally
should all be
collected
asking.
and declared.
So
In all
and that's the
these,
question I'm
the
saying.
Electoral
putting
Act
forward. Let me
2022
see if
has
anyone
not
wants to
specifically
join.
provided
I've
that the result
invited,
of the election shall be
but people
electronically
haven't spoken, and
transmitted.
that's fine. We don't have to speak.
It is in the
if you don't
exercise
want to
of
speak.
its
Chidalu,
powers
I'm
under
glad
Section
that you're
160
listening,
of
but
Section
we
1
are
of the
looking at things
1991 Constitution and Section 148
from the
of the
point of view of
Electoral
what
Act
is going on
2022
and the impact on our
that,
nation. So
that the first
if
respondent
you're
does
welcome
find
to
it
come in.
herein
If you don't
make
want to,
the
you don't have to come
regulations
in.
and guidelines
But
for the
please don't
conduct of
forget, if
election
you're joining, those of you
2022
joining us
as well as
on
any
the X
manual
space,
for
please
election
subscribe to
officers
this AY on
2023.
YouTube. Help us grow the
In
platform.
paragraph
And of course,
14A
follow us.
and
Give us a follow
18A of the
on
regulations, the first respondent prescribed the
follow you back,
bimodal
so
voter
I-
accreditation system
my other
gives
brothers
us
that
as a
Daniel
technological
joined me. I'm
device
sorry I
for
didn't
the
follow
purpose
immediately. I was
of
trying to,
accreditation
but
and
sometimes it
verification of
takes a while,
voters
you
in the
know. So
2023
we will
general
add you,
election.
and you know.
The
we will
petitioners
come
have
to-
also
we will
hinged
come
their
conclusions
allegation
on this
of
discussion. Very important.
non-compliance
So
on paragraph 38(1) and 2, 48A, D, D,
So
55 and 7 and 20, 51, 2,
it is a
54,
concern.
7, 55, 7, and
So-
93 of regulations and
So
guidelines.
I have followed
Paragraph
you.
38 of the regulation
So-
provides as follows.
My brother, let me just see.
Uh,
Let me just see.
Depends on paragraph
Chidalu, I've
38
followed you as
of
well.
the guidelines.
I will endeavor to
and
follow
2,
others as well.
48A,
I'll come to you.
use it in this
Let's
judgment.
have a look at this.
55,
1 second, please.
and 7 from the foregoing provisions of the regulations and guidelines relied upon by the petition 5, 7, and 9 clearly evident to me that although the Electoral Act has provided in section 64 subsection 1
Let me just
for the delivery by the president of the result along with other election materials under security and accompanied by candidates with their polling agents
So,
were
yes.
available. Such a person
We are
as
trying to see
as may be
at
prescribed by
least
the
transition
first
in
respondent.
Brooklyn. I like
The
that
first
idea.
respondent has
Pick
by
that up,
paragraph 38
my
of the
sister
regulations
DNV.
and
I
guidelines
like
quoted
that
above,
statement.
introduce electronic transmission to a collation system in addition to the
At least
physical
translate
transfer of
in
the election
broken
results
English. I
to the
agree with
registration
you.
area
Because
of
people
one
need to follow
election
what's going
officer.
on. We
As
need
stated
this kind
earlier,
of
the
discussion
technological
to be
device
had
as
so that
prescribed by
everybody
ANIC
follows
in the
what's
conduct
going
of
on.
the 2022
Because what the
election
danger of what
is
is
the
happening now is
bimodal
people
voter accreditation system
will
BVAS.
have to
The
comply
function
to
of the
accept this
BVAS,
position
as stated in
and not
paragraph 14A
understand what has been
and
done at this
18A,
point.
is for verifying the voter
damaging
through
to
a
them.
positive identification of the voter and authentication of the voter by matching his or her fingerprints or face, facial recognition,
Why
thus
are we
accrediting the voter to vote at the election and storing the
Isn't
data
the
and number
judgment
of
should be
such
about
accredited
the
voters.
law, not
By
about
paragraph
discussing
38, 2 and 3
the
of the regulation,
intricacies of
the
the
BVAS is also to be used
beavers?
by the presiding officer to upload a scanned copy of the
I don't
EC8A to the
know.
ANEC
Is
results.
it me? Shouldn't
Very
the
important,
judgment
IRF.
the judgment should not be talking about
After
the
which
IRF
the
and all of
presiding
that. They should
officer
be talking
shall
about
take the BVAS and the original
aspects of the
copy
law
of each of the
that
forms
they
to
are
the
aware
registration
of in
area
conjunction
from
with
ward
what
collation officer.
either the INEC did
From the
or
above
didn't do.
functions
That's
of
just
the
me.
BVAS,
I'm
it
just
is
thinking
clear to me
aloud.
that
Does
apart
that
from
sound
using the
reasonable to say
BVAS
that?
to scan the
Would it
physical
sound
copy of the
reasonable for
polling
me to
unit
say that
result
or for others
and
to say that? I'm just
upload
asking.
and upload same to the IRF,
Would it sound
there is
reasonable?
nothing in the regulation to show that the BVAS was meant to be used electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the INEC results being portal RF is not a collation system. The
On what is
Supreme Court
shown on the
in
screen here,
Oyetola and INEC 2023, INEC 23 LPELR has explained the difference between the collation system and the IRF.
On what I'm seeing here, a lot of
In
people are
that
making a
case,
lot of comments.
IGIM
not,
JSC held as follows court. As their names depict, the collation system and the INEC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides a relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public
I think we need to be very clear that
at large the opportunity to view the polling unit results in the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANEC Manual for Election Officials 2023 show that the Electoral Act provides in Section 62, subsection 1, that after recording and announcement of the result, the presiding officer shall deliver same along with election materials and security, and accompanied by the candidates or their polling agents, such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANEC Manual, also state that hard copies of the election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IRF will be used to collect the results. The petitioners who contend that INEC was mandatorily required to electronically transmit the election results to the collation system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that INEC was mandated to electronically transmit or transfer the results from the polling unit direct to the collation system as prescribed by INEC. Stated that the IRF portal is part of the technological architecture developed or deployed by ANEC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the BVAS machine, and that his investigations and findings were on the IRF portal. He also agreed that it was only INEC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioner, even though he stated that part of his brief by Labour Party was to determine INEC compliance with the Electoral Act 2022 and the INEC regulations and guidelines for conduct of the election 2022. He prevaricated under cross-examination by the first respondent when he first stated that INEC at the IRF portal is an electronic collation system, but later recanted and said the IRF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to RF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, our evidence was basically in respect of the health status of Amazon Web Service, which hosted the ANIC RF portal.
Okay.
The testimony of PW8, the cyber security expert, also called by the petitioners, also related to the ANIC RF portal. On the part of the first respondent, RW1, Dr. Lawrence Biode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of petitioners in paragraph 37 of the petition, there was no collation system of the first respondent, to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the BVAS machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that ANIC has not established any collation system which results will be electronically transmitted from the polling unit.
We need
Thus,
to look at what's
his
going
testimony on that fact remained unchallenged and uncontroverted. It is certain law that the court has a duty to act on unchallenged and uncontroverted evidence.
So,
Bromwell Energy Trading Company Limited, OAM and others.
Is admissible as evidence, then show it. Amazon website. Okay.
In addition, RW2, followed by the second and third
they don't create finish now, my brother.
The first respondent through its chairman made
Let me pin
clarifications
that one. I think I'm going to pin that one. I'm going to pin that statement.
that raw figures of election results will not be transmitted electronically by the first respondent. As such submission was susceptible
like you to
to
join
hacking.
us as you're watching us.
The identified exhibits R24 and RA24 and RA25 as documents he referred to in
We
his
are
statement.
sharing as much information about
These are the certified true copies of pages 28 and 27 of
the
the
judgment
newspapers of 23rd February
There's a lot of
2023,
questions from
wherein the chairman made the said
about
clarification.
what the judgment is actually
As
saying.
indicated in our
I'm
ruling
going to try
on
and
objections
see
to
if I can go
documents,
and skip
the
to
petitioners did not
things
object to the contents of Exhibit
as I am talking
RA24
to you.
and
Let us see
RA25,
what they're
but
saying
only
about the
stated
judgment.
that they were objecting to the heading, but not the
The
content.
judgment as it is
We
going on.
overruled that objection in our ruling because the reason advanced by the petitioners counsel did not amount to a proper objection to those documents. Also noteworthy that the petitioners never
Court of
cross-examined
Appeal judgment. Let us
RW2
see if I
on
can
his
find
oral
it for you.
evidence and the said exhibits in support of his oral evidence. In Exhibit RA24, the ANEC chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying
look at,
that the first respondent failed to transmit scanned copies of polling unit results to the ANIC RF portal, none of the witnesses called by the petitioners had given evidence of the existence
what's going
of
on
any
here.
collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners, that under the regulations, it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results. Paragraph 92 of the same regulations categorically provides that at every level of collation, where the ANEC copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulation provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, a provision of Clause 93 of this regulation shall apply. The said Clause 93 of the regulations, which I had earlier quoted, provides that where the annual hard copy of collection results from the immediately lower level of collection does not exist, the collection officer shall use electronically transmitted results or results from the IRF portal to continue collection. And where none of this exists, the collection officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the annual regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collection of results. There is nothing in the Electoral Act or the annual regulations and guidelines to show that an electronic collection system was prescribed by the Commission, which results will be electronically transmitted. Thus, the petitioners were unable to establish the assertion that the first respondent is mandatorily required to electronically transmit the following unit results to the collation system.
Says only
First respondent, on the other hand, has adduced unchallenged evidence that apart from the IRF portal, no collation system was established by the first respondent.
I'm sorry, I'm laughing, guys. I have to laugh
the presidential election must be
the
electronically
seriousness of the
transmitted
situation that
for
does
collation.
not escape me.
It is therefore my finding that both
seriousness
the
of the
Electoral
situation
Act
that we are
and the
doing
regulations and guidelines provide for manual collation of election results and the electronic transmission to a collection system apparently introduced by the first respondent in the regulations and guidelines are not mandatorily as contended by the petitioners
will we truly
in
get the
herein.
rule of law?
Also, my finding based on the evidence adduced that the only collection system put in place by the first
These are only questions.
respondent
So I don't know.
in the conduct of the presidential election is comprised of the fiscal collection centers in the registration areas or ward collection centers, local government area collection centers, state collection centers, and the national collection centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the INEC result viewing portal, IRF real time, the petitioners averred in paragraphs 53, 97, and 98 the petition that the petitioner also 53. The petitioner also contends that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the IRF as at the time of the purported declaration of the second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent, via a written communication, sought to excuse the manifest non-compliance with the requirements of the Electoral Act 2022 and the regulations by claiming that there were glitches in the electoral system
thank
which
you for those of
prevented
you who are still listening to my broadcast.
that first respondent from uploading the results of the presidential election from the polling units in the IRF portal on the date of the election.
Questions.
The said written communication is hereby pleaded.
I'll follow as many as
98.
possible.
The petitioner shall contend that the alleged glitches
If I follow you on X, please do follow, and also
that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent
injure and prescription dose. Exactly.
credit unlawful votes in the second respondent and thereby wipe out the clear advantage
I feel sad.
which inured
We're laughing,
petitioners
but it's
following the
not
lawful
funny
exercise
in many
of voting
respects. It's
rights
not at all
by the
funny.
electorate. In response to the above allegation, the
And
first
really
respondent adverted in paragraphs 59,
And it's sad.
55, 7, 8, 9, and 10 of their reply to the petition. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server's contents of the IRF hosted on the AWS cloud platform to show that the results of the election were uploaded on the IRA portal, but the first respondent attempted to delete or remove the uploaded results. It is true that a petitioner who alleges non-compliance with the Electoral Act has the legal burden to establish that non-compliance and show how the non-compliance substantially affected the result of the election. Ladoja and Ajimobi, Shinkafi and Yari. In proof of their assertion, the petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not front-loaded, along with the petition, as mandatorily required by paragraph 45 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I have held I had upheld the respondents' objection and sought out the evidence, which include their witness statements on oath and the documents and or reports tendered through them. These are exhibits PCJ-A to F, PCJ-4, 6 reports of AWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7.
I'll show you something. I saw something on X. Somebody said, go into the world and commit crimes. That is what the judgment is saying.
Claimed to be a cloud engineer,
I'm just
or architect, an employee of Amazon Web Service.
It's not.
She stated that she is not only a member of the Labour Party, the petitioner is sharing, but she contested election as a candidate for member
go
of
into the world and commit crimes. That's what the judgment is saying. According to some,
she stated that for an IT application, the SDLC includes requirement gathering, analysis.
I don't know.
And design.
You see, and then somebody wrote
election centers and design. Yes.
There's a tombstone. Yeah, this is bad. There's a tombstone of Nigeria, right?
Taking the software and development.
Over to you, Nigeria. The ball is now in your court. And then it says 1999 to 2023 with a tombstone.
And problems or challenges. Any problems or challenges with the software usually show.
I'm laughing.
Or be flagged. It stated that each function is supposed to be tested, and any issues flagged ought to be remedied before deploying software. It stated that if the software application has any glitch, such a glitch will pop up. That is
somebody said if Equilimadu's organ harvest was determined
from her preliminary review of the public viewing facing the IRF website, is aware that the polling unit images are stored in Amazon S3,
it is not
AWS storage service.
It is not a laughing
stated that as an employee of AWS,
it is something that is
AWS has a service level agreement, SLA.
What is this going to mean?
Which is accessible to the public on docs.
So let's see what is going to be the fallout from this.
And that by
whatever side you're on, what's going to be the fallout
for S3 service?
What's going to be fallout?
Designed to provide 99.999% durability and 99.99 availability of objects over a year. He said this is accessible to the public on http://docs.aws.amazon.com. Amazon S3 latest user guide of data durability.html. He stated that the AWS servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://l.fws.amazon.com from health status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. Stated.
I just saw a video.
That from the post-event summary,
saying those of you who are praying now, what will the pastors Adeboye and others be saying on this?
Cloud servers was on December 10, 2021, which was an internal connectivity issue that affected
upon all the rigging that went viral in election
container API, among other services, access issues
It came back
factoring only one
to
region.
electoral.
Said this is available to the public.
Error glitch.
EW7 stated that she was aware that a glitch in a software means
You're making me laugh.
as a result
It's
of
good
which
to
the
laugh,
application
Charlie.
is not able to
At
perform
this point,
properly,
it's good to laugh.
and that fixing a glitch in a software sort of application by the creation of patches refers to a series of changes made in the system into the system by writing small code, which is imputed into the software, change its current state and
I don't know.
thereby
So
function
which
properly.
will my people
On
which
cross
will-
examination by the first respondent, PW7 admitted that she missed post-production maintenance, which is an important element of software development life cycle. He denied that glitches occur at post-production maintenance stage and stated that it appears
Ladies
at
and
the
gentlemen,
testing
please
stage.
don't forget, as you're
He
watching
stated
the
that she was
broadcast,
aware
thank you
of personal
Go
health
ahead to
dashboard
Susan Ewa
and
on
stated
YouTube
that
and subscribe
the
to
first
the
respondent's
platform.
personal health
We truly
dashboard is
appreciate
not
your
before
support.
the court.
We are facing a
He
moment of
admitted that the
decision.
EWS
This
adopts
decision
a
is a
shared
moment of
responsibility
decision in
model
our lives as
in which AWS
citizens in
plays
Nigeria. I very
part,
much
while the
stated
customer
I've been
plays
very
its
clear
own
from
part
day one. I
when
want
it
to
comes to
the
security. He admitted that the
and I
report
support Biafra.
tended
We
that-
need a referendum.
that only shows the
What
health status
this
of all
judgment will do,
AWS services in all
in
regions
the
in
coming
terms
days and months,
of
no one.
the infrastructure and not
All
security.
we can do is to begin to really encourage us.
He admitted that in order to know what
is to
happened on
really-
applications
we need to
deployed
have
on
a really
AWS
serious dialogue
infrastructure
among
by
ourselves.
a
I've also
customer,
spoken about
it is not
the
necessary
use
to
of
get a
section
technical report.
14.2a and 14.2c. You see, they are bringing
EW7 also
sections of the
stated
Constitution
that
over
she is
and over.
familiar with
But the one
AWS
that is the
Cloud
most
Trail,
powerful one that I
and
want
there
you
is
to know,
a
is
Cloud
the one
Trail
I'm about
for
to read.
every
And that
AWS
is 14.2a
camp,
and 14.2c.
and for every
14.2a.
API
Sovereignty
action made
belongs to the people
on
of
that
Nigeria, from
account.
whom the government.
He admitted that she did not produce the Cloud Trail for
That's
any
you and I. We
flow
possess those powers.
application
How do we use
for
those
the court.
powers? Please
He
listen.
denied that the Cloud Trail is the
14.2c
best
provides
account
how we can use
of
those
what
powers.
transpired
The
on any
participation
developed
by the people in their government
application,
shall be ensured
but did
in
not
accordance
state
with
the
the
best way
provisions
to
of this
know
Constitution.
what
Those
transpired.
are powers we need to begin to use.
He stated that it is highly
Do you
unusual
feel-
for glitches
do
to
you
occur for
feel
primary
that
functions
this,
of applications in production.
judgment reflects
He stated that she was
the
not
will
aware
of the
that
people
glitches happened
in
with
terms
the
of
Central Bank
fairness
of
and
Nigeria
justice.
e-money project.
If you feel
was the
that,
one that happened
then it's good.
with the
If you don't,
MTN
then it is time for us to
Mono
really use our
PSG.
powers.
He admitted
within
that
the
she was
Constitution
a
42
candidate
and
for the Labour
42.
Party
We need
at
to
the last
encourage
election.
ourselves. We've been encouraging.
He also
them
admitted that the
to
subpoena
translate it
under
into
which she came to
local
court was
languages.
served on her
Because what is
personally
going on
and not
now
on
is clearly
Amazon Web
not something
Services.
that is sustainable. A nation
Also on
cannot
cross
exist in this
examination
way.
by the second and third
I
responders,
noticed somebody was laughing
EW7
that people were
admitted
saying
that
God will
exhibit
do it, God will do it. They said radio still happens. Nothing will happen.
ECJ2, which she
And
presented as her employment
as many of us
verification
will know,
letter, was not
nothing
signed
will
by
happen.
anyone, but insisted that there
But it
is
requires our collective
the name
effort to
of
make something
Employment
happen.
Resource Center
And that's
written on
it.
it.
And that is why
He also admitted
knowing-
that she had been
going
attending the
back
court
down to the
and
Constitution
watching the
of Nigeria
proceedings
has
before the
been
day
and
her
using the
testimony.
powers within it.
He admitted that the report
You know,
she
so
presented before
and
the
that's
court
the only way.
is public
I can do it.
information
So again, I'm going to
posted by
read before I go
Amazon
and read
that
the
it is
funny
available
comments
and
by
accessible
who are
to the public.
Before I
He,
go ahead,
however,
let me
insisted
just
that
quote this to
the
you.
report is
Section
hers
14.2a.
because she was the one who
Sovereignty
downloaded
belongs
it,
to the people of Nigeria,
brought
people
them
of
to the
Nigeria,
court.
from whom the government, through this constitution, as well as powers and authority. And then 14.2c, the participation by the people in the government shall be ensured in accordance with the provisions of this constitution. Those are the things that we
EW7 also
we
admitted under
need to wait
cross-examination
and
that
continue
she
to
won
encourage
primary
us
election
all
for her constituency under Labour Party,
to
the second petitioner,
to,
and that she even
to really
filed
begin
an
to
action
activate.
against INEC
We haven't done that
because she
in
was not
24 years.
placed on the
So
final
far.
list of candidates
Now,
published by INEC.
I've been
He
doing
admitted that
this,
her
I've been on
complaint
this crusade
was
now,
because she
this
tried several
campaign
times
to
to
raise
upload
the
her
awareness about those
information
powers
on
so that
INEC
we can
side,
begin to use it
but all
collectively,
her
starting from
efforts
within our
failed
community.
because of network
That's what I've
failure.
been saying, and I'm hoping that
He admitted that network failure can happen to either end of an
we will have
application,
to take action
even as she
because we have to
disagreed
collectively
that
begin
there was
to
a
monitor the
glitch.
actions of our government.
INEC side,
Those
he admitted that in her, she admitted that in her affidavit,
executive. They are
stated that
all
INEC
answerable
side
to you and
crashed.
I because ultimately
EW7
sovereignty
also
belongs to
stated
you and I.
that she was aware
And
that
whatever they're doing here,
EW has experienced
unless we
outage
begin
of
to
several
monitor them
hours
using those powers,
on
nothing
Tuesday,
will change.
28th February
Even to get to the
2017,
point of getting a
that as
referendum,
at
we need to
2021,
exercise the powers we possess within
AWS
the
also
Constitution
was reported
to
to
now
have
begin to
suffered
compel those
more than
elected to
27
office
outages.
to
He also
now
admitted that
institute,
what
put
was sent to
into the law
IRF
a
was the
referendum
made of
clause that would trigger
on cross-examination by the fourth respondent, PW Summon stated that she did not know about
across the whole nation.
password protocol
That's my
and
take.
cannot speak about
Everything that's been
password
said now is
protocol
just-
to modify the applications of ANIC.
I
She
can't
admitted
help-
that the
I don't
open
know.
cross
What are
access
your
information
thoughts?
she
I don't know.
downloaded in her report cannot be amended
Ogaju, indeed.
by
Ogaju.
her. In fact, she admitted
Yes. Yeah.
that she was not
And
representing
I can't
Amazon
wrap
Web
it all
Services
over my
in
head.
this case.
Yes, I can't wrap my head
However,
around it.
insisted that she is an expert.
I can't wrap my head around it.
Stated that she was aware of glitch,
Yeah,
which
I
affected
can't.
Japan brokers
So let me
in
put it
September 2021. But stated that the last
can't wrap
one
it around my
she was
head.
aware
It
of
is
was in
concerning.
December 2021.
Severely
So whether
concerning.
glitches can happen again, she stated that anything possible.
I
In
will
his
just,
evidence,
I wish
PW
the
and
court
Dr.
would focus on their
Chibike
judgment.
Ugoike,
I
another expert witness,
I just wish the court would
called
focus
by
on
the
their own
petitioners,
pronouncement.
stated
rather
that he
than-
is a cybersecurity and risk
I
advisory
don't know. There's
consultant,
something that is.
and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the annual regulations and guidelines for the conduct of Election 22 and the annual manual for election officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the Beavers to IRIF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed for production. On cross-examination by the first respondent, PW stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On the 17th and 18th March 2023 and concluded the final report at the end of May 2023. PW stated in paragraph 14 of this adopted written witness statement that he read the petition and the first respondent replied to the
I've had in the
petition.
whole all of
And
fame
in
of
doing
our
this
churches,
his
the
work,
prayers
stated
presented
that
by
he could not
Chukwu
recall
Asube,
whether he
Full
read the
Fighter,
petition.
of Student of Law.
But when his attention was drawn to paragraph
Okay, how does
14
it
of his
relate to our own
statement,
election
he
based on
agreed
the
that he had read
politics
those
as
pleadings.
zero
He admitted
content?
that it is not impossible
Yeah, I
for
can
errors
see.
to
This is
occur
what I'm
after
saying. I'm trying to
deployment
be
of
objective
technology
about
or
this.
application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units. He established that it is possible to show metadata.
I'm trying to be
He stated that there were errors in those polling units, and
you have
he
tried
did not
in
have
that party for now.
to
You can
examine the
travel to your
physical
village in
copies
Agulu and
of
be
the Form
drinking fresh palm
CC88
wine and
of
don't
those
fall
polling
for any
units.
camp.
He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units
So that
were
is a
collated.
statement from Odogwu.
He stated that all the work he
Dear
did
Peter Obi.
was
So
on
that's the
his
reaction
computer.
that you are getting.
You confirmed
I'm
that
just
the
judging
AWS
the
security
reaction
model
of people
is a shared
reading on
responsibility
experts.
model between
How long
AWS and
we
the
go
client.
suffer? Oh, yes. So
Stated that
how
he was
long?
aware
How
of
long?
the cloud
That's
trail.
what the song
He
says.
confirmed that the cloud trail
How
will
long
display the
will we
availability
suffer? How long?
of
How
the
long will I go
application of
suffer?
INEC
How long?
on the AWS
That's why that song is there.
infrastructure.
Let me just bring that up a
PW who
second.
insisted that there was an
Yes, the
electronic
song is how long?
collection
It's a very pertinent question.
system only
When
pointed
people hear me
to an
say that,
upload
and some people
at the
don't
last
hear it,
paragraph
but
of Exhibit
it is relevant to
ECK2
now.
and stated
That
that it
song
means
is
an
so
electronic
relevant to what's going
relation
on.
system.
You know,
When cross-examined by
It's not about
second and third
the-
respondents,
it's not
PW
about-
denied that
but
it
the
was
song,
part of
I
his
wrote
brief
that
to
song
assist the
with
Labour
this in
Party to
mind,
respond
that
to the
things
respondent's
are-
reply.
things
He
are
admitted
falling
that he
apart.
did not inspect any
And
of the
unless
Beavers
we
machines
begin to
and did not
take action
interrogate Festus
collectively,
Okoye,
we
whose
will,
statements
how
he
long are we
referred
going
to.
to do this for? How
He
long?
confirmed that Exhibit
How
A,
long?
which he attached to his report,
that is what
the
I really
metadata
stated
of
there.
23 pages,
Let me see.
showing multiple uploads. He denied that it contains information
That's a complaint.
which are coded and not explained, and insisted that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report, but stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by the first respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IRF, and he did not interact with the presiding officer.
See, how long will it suffer?
And did not
The
see
song
the
is
hard
right.
copies of
It's
those
asking a
results.
question.
You could not
How
also
long
tell
will it suffer?
whether those results
We are asking.
have been collected. Starting with the evidence of PW service,
Only way to put an
it's evident
evidence
that
is to
she
begin
is
to
a person
participate in
who
our governance.
has an interest to serve
That's
in
why the song is
institution,
there.
being a member of the second petitioner,
How long will
under
it
whose
suffer?
platform she
We are
contested
suffering.
election for House of
We need to
Representatives.
participate. Whichever government is in,
Her interest
we
in
must
this
participate
petition
in our
is further
governance. That's what I'm
underscored by
after.
her admission
I'm not even
that she
interested
has
in what is
been
right or
attending
wrong in
court
this case.
and watching the
Whatever
proceedings
happens with
prior
this
to
case,
making her statement on
unless
top
we
and
participate in our
testifying as a
governance,
witness.
nothing will
Her
change.
testimony, therefore,
That's why I say,
was
how long will I
essentially
suffer?
a
We must
demonstration of
participate
her
in our
support
governance.
and loyalty to the second
Because it is
petitioner.
we, by
Her
monitoring the
claim
government,
to
that
being
they
an
will do what
employee
they would do what
of
they're
Amazon
supposed
Web
to do.
Services is also suspect,
All of this
as
is
she
just a
produced no
conjecture.
credible evidence to that
Nothing
effect.
will change
Exhibit
unless
PCJ2,
we
which
collectively
is
in our
the
community
paper
begin
she
to participate
presented
in our
as
governance.
evidence of
Using
her
section 42
employment
and 42,
by
the powers we
AWS
possess.
is obviously a worthless
So
paper.
that song.
It has no author, although she
long?
insisted
How
that
long
the
will it
author
suffer?
is
So
Employee
that's what the
Resource
song is
Center.
saying here.
The paper was also not signed.
So
Her evidence
we are-
adds no
we are trying
value
to
to the
show
petitioner case
what is going on.
because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not terms of security. He had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded. And her only claim to its ownership is that she was the one who downloaded it and brought it to court. He even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. He also admitted that the health status of the first responders application posted on the AWS
I don't
is not
understand.
before the
Yeah,
court.
I mean, there's a
Her
question.
conclusion
There's a lot
on
of
the
questions to
totality
ask
of
here.
value of this witness is that it is devoid of any probative value. As for PW8, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Latoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units.
Seriously,
In
as
particular,
Africans,
PW4,
as
PW10, and
Nigerians,
13,
how are you seeing
all
this?
stated that their polling unit results
Are
were
you
taken
happy
to
with this
collection
result?
centers. Therefore, even the evidence of the
Nigerians, are you
petitioner's
happy with
witnesses
what you're seeing?
showed that the polling units
you happy?
results were physically
Are
taken to
you
the
happy?
registration areas
How
for
do you
work
see
collection
this?
centers. The petitioners have left no evidence
Hey, why,
to
drink some
establish the
water and
existence
tea.
of any collection center
For-
with
for
the
me.
potential
Yes, we'll do. Yes,
election
my
results
brother.
were
Yes,
to
I'm
be
finished.
electronically
Yes,
transmitted for collection.
Yeah,
On the
my
part of the
brother.
first respondent,
You're right,
RW
We do
one
need to look at
testified
things from our
that the
different
failure
view.
to upload some of the
I'm
results
gonna pin this
of the
up.
presidential
This up.
election
I
to the
can't
IRF portal real time on 25th
I'm
February
not-
2023 was due to a technical glitch experienced on their
You have to
transmission
drink- you have to drink water.
system.
Ah.
RW1, through whom the first respondent tendered a
So
RA6
we
and
are
RA7
really
stated
in
that
this
at the end
situation.
of the
I
polls,
don't know how you're reading it. It's a concern for me. We're
some
gonna-
polling units.
But tomorrow we'll be doing discussions.
On 26 February
We're probably gonna
2023,
do MySpace.
it was observed that the first respondent
Anybody that wants to join us in the MySpace, please indicate in the broadcast. Anybody that wants to join us on MySpace, Citizen AY MySpace later on today, join me and we will talk about this. In fact, in the coming days, it may not even be today, but in the coming days, we're going to do a whole day of
was observed
allowing
the first
people
respondent
to voice their
by the first
opinions.
respondent that polling
So
unit
join
results
me in this.
being uploaded
you know?
to the annex e-transmit system by the
Yeah,
design officers
that's why
were
I was
pushed
sleeping-
to the Senate and House of
sleeping
Representatives
I'm-
model
I'm
of the
answering
IRF.
yes.
But the results of the presidential election were not being pushed
I
to the
don't-
presidential model on the IRF.
There's so many.
That based on
Picture.
threat levels and reports by security agencies
I am
that
concerned.
the first responding servers may
It's
be
not about
subjected
being getting angry
to
now.
attacks
It's
on
about
election day.
how
The first
is this
respondent's
impacting
first
our
course of action
You know.
was
So how long will I going to suffer? That's the question the song is saying there. You know, I didn't want to. I mean,
first course of action was
it
to
is so
investigate whether
it's
the
so
servers
pertinent to what's
were
going
being
on.
attacked. The preliminary investigation showed that there was no attack, but the issue was if HTTP 500 error from which the application, within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly.
Excuse me,
A thorough investigation
does
revealed
this sound like
that
it's a defense for
permission
this?
was
The court is a
unable to
defense
map
for
the uploaded
the
results of
respondent,
the presidential election
and
in any
not the
specific
case.
state,
They're not
and
looking
that
at
the
the.
presidential
I don't know.
folder
Is it
structure,
me? It
which was
sounds
meant
like-
to organize
I'm
the
not trying to-
uploaded result
Because if
sheets
you-
in order
the
of
courts-
elections, state, local
The judiciary is
government,
supposed to be in the middle,
area, ward,
impartial.
polling unit, was causing the application
they
to
are-
crash and return as
I don't
cover error
understand.
whenever
Does
it tried
that-
to create the folder structure
I mean,
for the
I'm just
presidential election.
in terms of just purely
And
judiciary.
W1
The
explained that
judiciary is
creating a
supposed to be
folder
impartial
structure to
and
organize
look
the
at things from
uploaded
both
results,
sides, looking at
the
assets
hierarchy
from
of
both sides,
election,
and okay,
state, local
we
government, ward,
rule
and polling
on,
unit
based on what you said
was
here,
was
we
a
agree with
new
that because it
feature
complies with the
introduced
constitution.
as an
Based on what that
improvement
one said here, we
in
disagree because
transmission
it didn't comply with the constitution. That way, but to be talking about,
and that the
talking about
whole
Amazon
system
and
randomly saved
I don't know,
uploaded
I'm
results
just
by
concerned.
timestamps, making it difficult
Does
to upload
this
results
give
sheets
you confidence?
by
Are you,
election or by
are you
state.
filled with
It
confidence in
stated
our
that the
judiciary
deficiency
based
was
on what
observed
you're
after the
listening to?
Washington state governorship
Are you
election
filled with confidence
2022.
in the judiciary
And
based on
W1
what you are
stated
listening
that during
to?
the election of
I'm not
25th February
making judgment. I'm
2023,
just asking a
the application was able
to
to
see
query
where
and
we
detect
are
the
really.
base
That's
status
all.
states
You
for
know,
the senatorial
I mean,
districts
the
and
entire
federal
system
constituencies based on
is
the mapping
compromised
of
anyway.
all central districts
Whoever
and
wins
federal
this election,
constituencies,
the
their
entire system
respective
is
states.
compromised. That's why I talk about this.
And that
Of
this
encouraging
mapping
us- or
still
encouraging us
exists
to
in the
know
database.
This
And the upload was successful because it was able to identify the state and build the folder
43 and
hierarchy
42C.
for the results
we need to
organization.
know those.
But for the presidential election,
those things. We
the
need to have
application cracked because the presidential election does not belong to any state on the first respondents database.
We need that
And any
information to
attempt
be
by
there.
the application to build a folder
that
structure to organize the
we can begin at
election
least
results
to-
failed with a HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. It stated that the first presidential election results were
So
successfully
how do you
uploaded
are you
at
do you have
8:55
confidence in the
p.m. on
judiciary?
the 25th February 2023.
Based on this, will you
Further
be able to
stated
say
that
if the
it
court made a
confirmed
decision,
that the
you'll be
breach
happy with
actually
it?
happened as
That's
well
all
as
I'm asking
the
for.
time that all parties to fix the error
I'm
were
not-
created and deployed and reviewed on
I don't
AWS
gain
the
anything
cloud
by
trail
me
and AWS
putting
functionality
it down. I don't.
that
You know.
allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the cloud trail log. Stated that the technological glitch experienced on
Yahoo
the transmission
boys.
system was
But
not
what's
deployed
Amazon-
to manipulate the election, and the glitch did not affect the results of the election. He then tendered RA6 and RA7, the cloud trail log, and a certificate of compliance with Section 84 of the Evidence Act 2007, and identified same as the documents he referred to in his witness statement on oath. Under cross-examination by the petitioners, RAW1 confirmed that testing was carried out on the e-transmission system, the first respondent, on the 4th February 2023, before it was deployed and a report was issued. When shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data, dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. Petitioners then tendered the report of vulnerability assessment and penetration testing through its witness, which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, the burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2011. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent.
I will state
The first
again,
respondent, on the other
those
hand,
who are listening,
has offered credible evidence in the form of
42A.
RA6
Sovereignty belongs to the people of
showed that
Nigeria,
its
from whom the
e-transmission
government, through
application
this constitution,
posted on the
derives its
Amazon
powers.
Web Services,
14
which
to
is
6. The
supposed to
participation by
upload
the
the
people
results
in the
of the
government shall
presidential
be
election to
ensured
the
in accordance
IRF
with the
has
provisions
suffered
of
a
this
glitch
constitution.
on the election
These are
day
the two powers that
25th
we need.
February
I
2023.
hope we can activate
On the
it.
preponderance of
According to
evidence,
this.
I'm convinced that the
I've
petitioners
said it time
have
and again,
failed to
and I'll continue
establish
to say
their
it
assertion
till
that
every part
the
of our
first
community
respondent
begins to
had
take
deliberately failed to upload the results of the presidential election to the IRF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC Manual for Election Officials 2023. By Section 134, subsection 2 of the Electoral Act 2022, only an act or omission which is contrary to the Electoral Act 2022 can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints for questioning an election. Interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134.2 of the Electoral Act 2022, the Supreme Court held in Newsom and Peterside as follows. Quote, the above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections, by Section 138,
I need to go and do something. I'll be back.
Long as an act of omission regarding such regulation or guideline is not contrary to the principle of the Act itself,
some discussions, no doubt, afterwards. So let us stay with this for a while. Thank you.
We also JGD and INEC. Since, as shown above, electronic transmission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the Deliberations and Guidelines for Conduct of Elections 2022 and INEC Manual for Election Officials 2023. The failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1B of the Electoral Act 2022. The petitioner also alleged in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further alleged that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC 8B1, in respect of the states where the second respondent duly won the election, as done in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that it duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1, as alleged by the petitioners. It was the subordinate senior counsel with regard to the state of the pleadings and the issues of fact in contention, the onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73, Subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. Relied on the decision of this court in First Bank Nigeria PLC, Adjudication Business Investments, and Royal United Nigeria Sterling Bank PLC, admitted that the first respondent did not leave any evidence in proof of their positive assertion there was compliance with the said provision of Section 73, Subsection 2 of the Electoral Act. Landed Council submitted that on the part of the petitioners, they have led evidence through PW12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as PCQ1 to PCQ6. He added that the petitioners have also served subpoena duces tecum on the first respondent to produce said forms but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the forms. Counsel asked the court to invoke the provision of Section 167D of the Evidence Act against the first respondent and hold that the forms if produced would have been unfavorable to the first respondent. He further submitted that the non-compliance with Section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Gawa, Kogi, Kwara, Niger, Ogun, Ondo, Oyo Rivers of Zamfara states, which are shown in the Form ECADA, admitted in evidence as Exhibit EVF. He pointed out that Section 135, Section 1 of the Electoral Act 2022 only deals with non-compliance generally, but Section 73, Subsection 2 of the Act has provided a specific effect of non-compliance with provisions. Relying on Crown's Townsend Organization for the National Institute of Policy and Strategic Studies, he urged the court to hold that substantial non-compliance has been established with petitioners. Arguing per contra, Landed Senior Counsel for the First Respondent referred the court to Section 135(1) of the Electoral Act 2022 and submitted that the petitioner complained of non-utilization of prescribed forms, even though not proved, and not without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude Section 73, Subsection 2 of the Act from the ambit of Section 135, Section 1 is a non-starter because the non-compliance referred to in Section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with Section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved that non-compliance nor shown that it has substantially affected the result of the potential presidential election. I urge the court to so hold. Petitioners had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the negative, and as such, the burden is on the first respondent to establish that they have duly complied with the provisions of Section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Adjudication Business Investment Limited, Royal United Nigeria versus Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Anik, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation rests on him, close of court. Again, this court in Dashi and others versus Druven and others espouse this legal position when Hugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who substantially affirms the positive an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ and Abra was a Northeast Railway Company, 11 Queens Bend Division 440 at 457, when he said that, quote, in an action for malicious prosecution, a plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are after all relative and not absolute laws of court. In the instant case, the petitioners have made their allegation of non-compliance with Section 73(2) of the Electoral Act 2022 by the first respondent as an essential part of their case in challenging the results of the electoral election declared by the first respondent. Not only are the petitioners statutorily required by Section 135, Subsection 1 of the Electoral Act to establish substantial non-compliance with the provisions of the Act, they are required to show how such non-compliance has substantially affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election encompasses non-compliance with all provisions of the Electoral Act, including Section 73, Subsection 2 thereof. In other words, Section 73, Sub 2 is not derogated from the ambit of Section 135, Section 1 of the Act. Indeed, in Buhari and Anik, Toby Joy said, while considering Section 1.51 of the old Electoral Act, similar to Section 135(1) of the Eastern Electoral Act 2022, had held at page 48 paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1) of the Act, the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73, Subsection 1, as part of their course of action, have the burden to establish that non-compliance in accordance with the requirements of Section 135(1) of the Act. The petitioners have also relied on the evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits are acknowledged copies of letters dated 6 March 2023, 14 March 2023, 10 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman of the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioner also relied on subpoena duces tocum served on the first respondent to produce the said form. In his testimony at paragraphs 58 to 60 of his adopted written statement on oath, PW12 merely stated that the petitioners made several applications through his campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30 May 2023 and 13 June 2023 were issued on the chairman of the first respondent to produce some documents. The record also shows that on the 20th June 2023, one Olufimilayo Taiwo, the Deputy Director of Certification on Complaints and Legal Drafting with ANIC, appeared on behalf of the first respondent in answer to the subpoena Duchess Tekum. While she produced some of the documents required of the first respondent in the subpoenas, he informed the court that the documents listed in the subpoenas as listed E, C, D, and E are in the state, and since the subpoena was served on them just before the previous day, it will take some time for the first respondent to get them. An examination of exhibits PCQ to PCQ6, which were tendered by the petitioners through PW12, showed that all except exhibit PCQ are letters addressed to the chairman or the first respondent by the petitioners and their solicitors requesting for inspection of documents and for certified copies of those documents. Exhibit PCQ4 is a covering letter addressed to the Resident Electoral Commissioner, Benue State, from the law firm of Dr. Paniechi Piazzo, SAN and Co., notifying the respondent as the Resident Electoral Commissioner of subsequent action on the solicited letter by the National Chairman, INEC Headquarters, Abuja, dated 6 March 2023. It is instructive to observe that Section 741 of the Electoral Act 2023 mandates the Resident Electoral Commissioner in a state where an election is conducted within 14 days after an application is made to him by any of the parties to an election petition, cause a certified true copy of that document to be issued to the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits an offense and is liable on conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 showed that they were all addressed to the chairman of INEC instead of the resident electoral commissioners in the state, as required by the petitioners by section 74, subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures for requesting for those documents. Also, when the record shows that the subpoenas, which they claim to have served upon the first respondent, were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 has stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, he stated that he was neither a polling agent nor a collation agent. His evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with section 73(2) of the Evidence Electoral Act. The Electoral Act 2022. Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to comply with the provisions of Section 73, Subsection 2 of the Electoral Act 2022. Rather, PW10 Efas Ia, the supervisory presiding officer for Madagali Ward in Adamawa State, who was subpoenaed by the petitioners to testify on their behalf, has stated in paragraphs 4 and 5 of his witness statement on oath that as a presiding officer, he reported to the local government area INEC offices in Bula, Madagali local government area in Adamawa State, on the 24th February 2023 to collect the sensitive and non-sensitive materials for the 25th February presidential election and National Assembly elections, and that after collecting the materials, he proceeded together with security agents and other army officials, which consisted of presiding officers, assistant presiding officers 1, assistant presiding officer 2, and assistant presiding officer 3 to Madagali Ward that evening to the registration area. This evidence was also to the effect that on the day of the elections, everything went well, and after sorting and counting the votes, the presiding officer did the entry and snapped the results with beavers for the upload and transmission of the results to the ANIC portal, but we were unable to upload. And when they complained to him, he requested them to come to the registration area. It is therefore clear from the above that the petitioners were unable to establish the allegation of non-compliance by ANIC with Section 73(2) of the Electoral Act 2023. The evidence PW2 and exhibits PCQ1 to PCQ6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence, PAPC and Sheriff, others. From the totality of the evidence adduced on this issue, I am of the considered view that the petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. 2 is therefore resolved against the petitioners and in favor of the respondents. Issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practices. Here again, we have considered the admissions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting and wrong computation of results. These allegations are contained in paragraph 60, 78 for the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent scores, which occurred in 18,088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the IRF, and thereby suppressed the lawful scores obtained by the petitioners in the said polling units. He further alleged that in Rivers State, during the collation exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' lawful votes are 205,110, while that of the second and third respondents ought to be 84,108. They similarly allege that in Benue State, the first respondent suppressed the lawful votes obtained by the petitioners when it announced their votes as 308,372, and that of the second and fourth respondents as 310,408, when the actual votes of the petitioners were 329,000, and that of the second and third respondents at 300,421. The petitioners also alleged that the first respondent was purporting to upload the result of the presidential election on the IRF, embarked on massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, as well as uploading incorrect results. He stated that if the results of polling units, wards, local government states are properly tabulated and calculated as required by the Electoral Act and the regulation and guidelines for the election, the overall results of the election and the percentages scored by the political parties will show that the petitioners won the presidential election of 25th February 2023. He stated that the petitioner should rely on a report of inspection of the electoral materials. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the averments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures are alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of the material particulars. We held that the said averments contain no particulars of the polling units where the alleged infractions took place, or the figures alleged to have been inflated or reduced. We had struck out those paragraphs for offending paragraph 41D2 of the first schedule to the Electoral Act 2022. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigations, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. The Omoborio and others versus Ajasin, Yeso Limited and Honey Legion, Lorin and others versus Tangolana, others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of results of an election. This Sadinja versus Ukur. The Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the Evidence Act and cases of Buhari and Obasanjo, Emmanuel Umana, Ipiazu, Oti, Abubakar, and others versus Yaradua, Omishore, Aliko Shola, Magaji, and All Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mobodo and Ono, Adewale and Olaifa, also Chima Anoze versus Dr. Ken Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raji Fashola. The Okechuku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, or only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 45B of the first schedule to the Electoral Act. However, even if the statements of those witnesses of the petition were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent in Pecho proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the election beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and annual regulations, he is aware that the presiding officer in a polling unit is mandated to electronically transmit or transfer the result of the election direct to the collation system as prescribed by ANEC, and to also use the beavers to upload a scanned copy of the polling unit result sheet to the ANEC result viewing portal area prescribed by ANEC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANEC servers, including virtual servers hosted on AWS Cloud. On cross-examination with his respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANEC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it from EC8S. He said he did not have the documents and forms he used and that everything was in the laptop. Contrary to the speculation of the petitioners that ANEC was not prepared to conduct the promised credible, authentic, and transmitted election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANEC chairman, Mahmoud Yakubu, and ANEC National Commissioner, Christos Okoye, wherein they gave assurances that the results of the election will be transmitted to the IRF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegations of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PZD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on both of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on Forms EC8S of 39,556 polling units were inaccessible as they contain uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,533,553 553,553, and number of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs of Forms EC8S matched the results of the first respondent. He stated that the annex CTCs of Forms EC8S showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the ANEC announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling units results, which the witness claimed to have downloaded from the RF portal, show that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90B of the Evidence Act 2011, case of Emeka versus Ipiazu. Others. Of note is that PW4 admitted under close examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel versus Mana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on RF portal are not the same thing, and that Form EC8A is a paper, while the result on RF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the RF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death nail to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause with 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the RF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the RF portal is not capable of collating and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is taken to the collation center, which he stated is collected at the ward, local government, state, and national collation centers. He also admitted that since the result in the Form EC8A is taken to the collection centers, the failure to transmit its image in RF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, would have been different. Further admitted that his report, exhibits PC1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. On the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition, a report in Exhibit PCJ 3A-F, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PWA, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PWA, having admitted that in the course of his commissioned work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of his petition. PWA had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed when as accreditation and voting took place, the votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the RF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the INEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and INEC regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day he collected the materials with security agents and other INEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue by 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the RF portal after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center tech, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well and the results were entered in Form EC8S in the unit and were properly announced. He added that the fiscal copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was to produce and tender the following documents. A. Correspondence of documents, letters, emails sent by him, sent by or from Independent National Electoral Commission, the National Information Technology Development Agency, requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by ANIC for the conduct of 2023 general election. B. The certificate of clearance approval issued by NIDA to ANIC pursuant to any request in A above. C. The report submitted by ANIC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election. Stated that they don't have any of the documents in their office. Under cross-examination by the second and third respondents, he stated that the NIDA Act does not contain cyber security standards. He also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness is of no effect the assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. Second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay. Settled that hearsay evidence is inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, the certified true copy of the judgment of Federal Court Abuja, suit number FHC ABDCS 1454-2022, was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court, which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collate results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents' council to state the scope of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 said he was not aware that INEC chairman had given a statement that INEC will not transmit results electronically. When confronted by the fourth respondent's counsel, he confirmed that his statement on oath, wherein he stated that he will rely on the evidence of forensic experts, was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. Clear that PW12 relied on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field, Ward 04, Tukun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form PC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by First Respondents Council, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the Ward Collation Center, which he did. On cross-examination by Second and Third Respondent Council, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, a petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in witness all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the legality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast in the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. The petitioner has a difficult, though not impossible task, close of court. Mohammed and another for Ladi and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, unlawful reduction and inflation of results, uploading of fictitious results, misrepresentation, nomination, manipulation of results, where no election took place, and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses they called, only 2 are presiding officers who were present at the polling, who are present at their polling units. Hence, the petitioners have not been able to establish any of those practices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results provided by the first respondent. Any of the malpractices which they allege are devoid of any value. The petitioner allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Landed Counsel for the first respondent contended that to prove overvoting, the direct record of accredited voters and the Beavers machine are required alongside the voters register for the affected polling units. He pointed out that the petitioners failed to produce the Beavers machines and the voters register. He submitted that the voters petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degima, LGA, River State, which was part of his report on overvoting, in exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oyetola and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraph 72, 76, and 77 of the petition, which have been produced here. In the earlier ruling of this court, the respondents' various perennial objections to the competence of the above petitioners' allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference were not filed along with the petition as to be part of the pleadings. Proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,407 some polling units, which affected 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead of 1,807,206 over the first runner-up. He also stated that from his analysis of River State results, the first respondent announced results which were inconsistent with those uploaded on the RF portal. PW4 also stated that from the Forms EC8As downloaded from the RF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. He stated that from the results on the RF portal, LP got 208,564 votes, while APC got 118,999 votes in River State, as against 175,071 votes for LP and 231,591 votes for APC. Concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections to witnesses and documents made in the earlier part of this judgment, the witnesses stated on oath, the witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to electoral 2022, them not having been filed along with the petition. With the statement of PW4 struck out for being incompetent, exhibits PCD 1, 2, and 3, forensic report tendered by him, were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in exhibit PCD 1, 2, and 3 are the only evidence adduced by the petitioners to establish their allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, and the forensic report in exhibits PCD 2, 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove their allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the Based on all the foregoing, it is evident that the petitioners have failed to establish their allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and favor of the respondents. But issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. This issue used to section 134 subsection 2 of the Constitution, the issue of 25% was Abuja. Whatever it is. Well, the resolution of this issue basically borders on the interpretation of Section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue, therefore, is to reproduce, for ease of reference, Section 134, 2A and B of the Constitution of the Federal Republic of Nigeria, 1999, as amended, the interpretation of which is in quotation. It reads thus. A candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation, in the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of section 134 quoted above. In particular, the contention is whether or not by the wordings in that paragraph, a candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or his status is to be regarded as distinct from the other states of the Federation, such that scoring 1/4 of votes in the FCC is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principles. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the electoral law reports, where the Supreme Court succinctly reviewed cited cases on interpretation of the Constitution and outlined these principles, guiding principles as follows. A, in interpreting the Constitution, which is the supreme law of the land, mere technical rules of interpretation of statutes will be avoided so as not to defeat the principles of government enshrined therein. Hence, a broader interpretation should be preferred unless there is something in the text or in the rest of the Constitution to indicate that the narrower interpretation will best carry out the sub-objects and purpose of the Constitution. B, all sections of the Constitution are to be construed together and not in isolation. C, where the words are clear and unambiguous, a literal interpretation will be applied, thus according to words, their plain and grammatical meaning. D, where there is ambiguity in any section, the holistic interpretation would be resorted to in order to arrive at the intention of its framers. E, since the draftsperson is not known to be extravagant with words or provision, every section should be construed in such a manner as not to render other sections redundant or superfluous. F, if the words are ambiguous, the lawmaker's intention must start first in the Constitution itself, then in the other legislation and contemporary circumstances by resort to the mischief rule. G, the proper approach to the construction of the Constitution should be one of liberalism, and it is improper to construe any of the provisions of the Constitution as to defeat the obvious ends which the Constitution was envisaged to achieve. In the case of Nafi Rabiu and the state, Bendel State was Attorney General Federation, Buhari Obasanjo, Savannah Bang Ajilo, Abia State was AG Federation. In finding appropriate answer to this issue, are we to observe first that, with all due respect to counsel to the petitioners, their interpretation of Section 134, subsection 2B of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases, it has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation. The Federal Capital Territory Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because so the JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal, so much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provision. The Global Excellence Communication Limited, Donald Duke, AG Bendel State, AG Federation, Saraki versus FRN, Sky Bank PLC, Yugu, Elim versus Gwabang. That this is the position is not at all open to doubt. In Bronic Motors Limited versus Wema Bank Limited, Nnamani JSC or Blessed Memory, speaking from the Apostle Court, confirmed it when, after a painstaking analysis of the cases on the point, said at pages 30 to 32 that, quote, a constitution is a living document, not just a statute, providing a framework for the governance of the country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of these provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, the constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of parliament. Although the manner of interpretation of constitutional instruments should give effect to the language used, recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of interpretation of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation or private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which such provisions were intended to serve. Udo Udoma, JSC, very aptly stated this in Nafi Review and the State, where the learned justice said, my lords, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, ut res magis valeat cum tirea. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, will serve to enforce, to protect such laws of God. Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Onogen JSC, later CJN, reiterated the relevant principle of the interpretation of the Constitution, which is Lordship saying, among others, at page 19. Follow. The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness. Close of quote. All these were further followed by this court recently, the Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi, in the following ways, at page 33 of the report. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. The Global Excellence Communication, other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it's meant to guide. The Adeleke or your State House Assembly, in interpreting the Constitution of a nation, it is the duty of the court to ensure the words of the Constitution preserve the intent of the Constitution. Every Constitution has a life and moving spirit within it, and it is this spirit that forms the raison d'etre of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation, and that while the preamble embodies the hopes and aspirations of the people, the direct principles set out the proximate grounds in the governance of the country. Kur and Union of India. In other words, in interpreting the words of Section 212(1)A of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision, and where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carry out its objects, purpose must always fact, close of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. Do hereby make and give to ourselves the following Constitution. For those who are not used to reading preambles, the Constitution, still in its fundamental objectives and directive principles of state policy, contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction in Federal Republic of Nigeria and Ingedi, repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their votes. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, with the essence of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider for whatever it is worth their interpretation of Section 134, subsection 2B of the same 1999 Constitution, which incidentally centers around the word "and" that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provision. And while the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned for another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134 2B of the Constitution will leave no one in doubt that the use of the word "and" by the framework between the words all states in the Federation and the Federal Capital Territory Abuja indicates nothing more than that the framers' understandable desire for consistency in referring to the Federal Capital Territory by that name, as it is done all through the Constitution whenever reference is made to the Federal Capital Territory. The word and Federal Capital Territory Abuja do not by any means imply the meaning imputed to it by the petitioners. In any event, Section 299 of the Constitution dispels any lingering doubt that may still be existing in anyone's mind by stating that the provisions of this Constitution shall apply to the Federal Capital Territory Abuja as if it were one of the states of the Federation, then ABC. This provision states most unequivocally that the entire provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It is noteworthy that the punctuation mark employed by the framers immediately after the part of that provision ending with federation, emphasized by me, is a semicolon, whose function is, in a sentence, is to separate independent clauses of a compound sentence. The Merriam-Webster's online dictionary would define semicolon as a punctuation mark used chiefly in a coordinating function between major sentence elements, such as independent clauses of a compound sentence. Wikipedia also explains its use thus. In the English language, a semicolon is most commonly used to link two independent clauses that are closely related in thought, such as when restating the preceding idea with a different expression. The point being made here is that, contrary to the position of the petitioners, by the express provisions of Section 299 above, the provisions of the entire Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. This means that Section 134, Section 2B of the same Constitution, requiring a president candidate to poll at least 1/4 of the votes cast in 2/3 of the states of the Federation in order to be returned elected, means nothing more than that the Federal Capital Territory shall be taken into account in calculating the state 2/3 of states of the Federation. In other words, the FCT is no more than one of the states of the Federation for the purpose of that calculation. Nothing more than that can be implied or inferable from Section 134, subsection 2B of the Constitution. If anything, this position is confirmed in the cases of Bakari and Ogundipe, where it was said by the Apex Court that by virtue of the provision of Section 299 of the Constitution, it is clear that the Federal Capital of Nigeria has the same status of a state. It is as if it is one of the states of the Federation. And in Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory Abuja is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory Abuja is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory Abuja a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory Abuja is to be treated as one of states in the calculation of 2/3 of the states of Federation. Thus, that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory Abuja as the second respondent. In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, issue 4 is also resolved against the petitioners and in favor of the respondents. It is right now that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption credible evidence. This settled principle was stated by the Supreme Court in Buhari and Annie, and Mason and Peter Side, others. Also in Udom Gabriel Emmanuel versus Mana Okon Umana and others. All citations applied. I have also referred to Abubakar and Eradua, Dewey versus Anik, Kiriko, Buluma Hop versus Barrister Joseph Ela and others. From the foregoing, it is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the 3 grounds contained in paragraph 20 of this petition. They have not been able to lead any question credible and acceptable evidence to rebut the legal presumption of correctness of the result of presidential election held on 25th February 2023, led by the first respondent. Having resolved all four issues in this petition against the petitioners, this petition is clearly unmeritorious. As I stated earlier, it's a consolidated petition. So when we examined that of petition number 4, our learned brothers state their own position. And number 5, sorry.
My Lord, sir, I'm very sorry again, sir.
Yes.
Even if your lordships are going to say, your brethren are going to say their piece later on, sir, at least your own, my Lord, well, you all should be arrested by saying it is either dismissed or is allowed. Huh? I was wondering if your lordship would not pronounce that it's been dismissed. So that.
What are you saying?
I'm sorry, but I don't want to be confused, sir. I've listened to your lordship's eloquent judgment.
Sorry, please, let us see you. You don't have to interrupt judgment. We are delivering judgment and we are still on. Please leave the judgment where it is.
My Lord, I'm very sorry, sir.
If you are confused, when you get the judgment, you read it.
No, my Lord, I'm not confused at all.
Okay, then please.
I'm making a suggestion.
You don't have to suggest to us how to deliver judgment.
I'm sorry. So
you seriously think that all 5 of us wouldn't know that?
Lord,
wouldn't know what to want to do?
I apologize.
Well, we now proceed on petition number 5. The motions in that petition will be read by my learned brothers, by my extreme right.
This is an election petition by the 2 petitioners against the first, second, and third respondents. The first petitioner, Abubakar Atiku, was a candidate at the presidential election held in Nigeria on the 25th day of February 2023. He was sponsored by the second petitioner, People's Democratic Party. The first respondent, INEC, was established as one of the executive bodies created in Section 135 of the Constitution of the Federal Republic of Nigeria, 1999, with power to, among others, organize, undertake, and supervise all elections to the offices of the President and Vice President and others. On Saturday, the 25th of February 2023, the first respondent conducted election to the office of the President and the Vice President of the Federal Republic of Nigeria and the National Assembly simultaneously. Petitioners and the second, third respondents, along with 16 others, participated in the election. At the conclusion of the election, the first respondent declared the results, by which it is indicated as follows. We show the results for out of the 2 contestants here we are concerned with. The APC of Tinubu Bola Ahmed and Tinubu Bola Ahmed scored were declared to have polled 8,794,726 votes, and Atiku and the PDP 6,984,520 votes. Petitioners were aggrieved by the outcome of the election, so they filed jointly this petition to challenge this election.
The grounds of the petition were four, and these were stated as follows. One, that the election of second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. Election of the second respondent is invalid by reason of corrupt practices. A second respondent was not duly elected by a majority of lawful votes. A second respondent was at the time of the election not qualified to contest the election. The petitioners are seeking the following release that may be determined that second respondent was not duly elected by the majority of lawful votes cast in the election, and therefore the declaration and return of second respondent as the winner of the presidential election of the 25th of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. Be that it may be determined that the return of second respondent was by the first respondent was wrongful, unlawful, undue, null and void, having not satisfied the requirements of the Electoral Act.
Well now, very
and the Constitution of the Federal
interesting.
Republic of Nigeria, which mandatorily requires the second respondent to score less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of the states in the Federation and
I don't know what to say
and in
anymore.
capital letters.
How are you
And
seeing
the
this,
Federal
everybody?
Capital Territory,
I've been
Abuja.
watching.
He that
had
may
to
be
go and do a
determined
few
that second
things, so
respondent was at the time of
I
the
am
election not
here.
qualified to contest the said election.
So then number 5. Now let's
He
continue.
that
to
may
work.
be determined that the
That was an interesting
first
episode
petitioner
a few
has
minutes
scored the
ago.
majority of lawful votes cast at the
I
presidential
apologize,
election
my lord. I apologize, my
of
lord.
Saturday, 25th February, be returned as the winner of the said election and be sworn in as duly elected president of the Federal Republic of Nigeria. In the alternative, another directing the first respondent to conduct a second election runoff, in brackets, between the first petitioner and second respondent. In the further alternative, that the election to the office of the President of Nigeria, held on 25th February, be nullified and a fresh election, rerun, be ordered. G, any such further others as the Honorable Court may deem fit to make in the interest of justice.
I don't know what to say anymore. Now,
Upon being served with the petition, the respondents join issues with it by filing their respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. Consider them.
They talk and say power,
7
power.
applications were filed and argued by the respondents during the pre-hearing session of this petition. 2 each of the said applications were filed by the first and second respondents, while 3 were filed by
That's the
second
Fedeco and old schoolers work.
respondent. First respondents' 2 applications were filed on the 19th of April this year and the 9th of May. The first of these 2 applications dated and filed on the 19th, which also largely reflect the position of second respondent in his first 2 applications and third respondent in his first
all
application.
this while for
First
we've done
respondent sought
good
and
few
others
hours now,
striking
it's
out
5
paragraphs
hours.
92.
I
we
thank
give
you
the
all
paragraphs
very much for being part of this job.
Of the petition on the grounds of their bigness, the several
program.
paragraphs which you get there as you get
Let's-
your when you get your the judgment. For being generic, imprecise, and lacking in specificity to elicit a reply from it. B, and other striking out paragraphs 129 and 138 of the petition for failure to join necessary parties. Among other grounds, the 2 necessary parties are Yaya Bello and one Adevo, the chairman of a local government in Kogi State. 3, another striking out the ground of the petition that second respondent did not score majority of lawful votes as contained in paragraph 16C of the petition for incompetence and lacking in specificity and materials in the pleading for a sustenance. Consequent upon 1 to 3 above, another striking out paragraphs A and B and D are sought in paragraph 130 of 150 of the petition, and another striking out the ground of the petition that the election is invalid by reason of non-compliance. Consequent upon 5 above, another striking out the ground of the petition alleging that the election of second respondent is invalid by reason of corrupt practices as contained in paragraph 16B of the petition for lacking specificity and material files in the pleading for a sustenance. 7, another striking out the ground of the petition that second respondent was at the time of the petition not qualified to contest the election as contained in paragraph 16A of the petition for lacking specificity.
Wow.
8, another striking out the ground of the petition
Specificity, he means.
that the second respondent was at the time of the election not qualified to contest the election. 9, consequent upon 1 to 8 above, another striking out and dismissing the petition for being incompetent. Frivolous, vexatious, abusive. In the alternative to the above, another striking out paragraphs, prayers A, B, C, and D of the petition are sought in paragraph 150 for being incongruous, contradictory, and self-defeatist. The grounds of the petition were stated there, and we set them out, which you get. Second respondent also filed a similar preliminary objection application for preliminary objection, seeking striking out the petition or portions of it. The single prayer on the application is one, is an order of the court striking out jointly and or severally paragraphs 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on the spot in his first application on the same issue filed, and we gave the day, sought similar prayers like first and second respondents. All three respondents also had issues with the replies petitioner served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so had no place in the reply. For these same reasons, they sought striking out with additional statements, witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following four grounds: that the entire petition constitutes a gross abuse of the process of court by reason of an originating summons in suit number SCCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation.
You have been watching
where the said plaintiff raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit polling unit results from his.
You've been watching Citizen Network, the platform where we speak truth to power. The judgment is obviously a long one. We've been on this broadcast for the past 5 hours and it's still going. I want to take this opportunity to thank each and every one of you that's been following Citizen Network, the platform where we speak truth to power. And I would please like you to do something for us. Real simple. We'd like you to go ahead and subscribe to Citizen AY on YouTube. How do you do that? Those of you on Facebook, here's what you need to do. Subscribe to Citizen AY, hit the notification button, and of course give us a thumbs up and help us grow the platform, and of course share. We are grateful for your support. We are grateful for those of you who have been following the broadcast and coming in and out throughout the day. We need to ask you, what are your thoughts on the judgment thus far? How are you reading this? How are you, as a citizen, what impact do you think this judgment thus far? Because it looks like it cements the place of the president in his position from the judgment that has been reached, that the judgment has been read out thus far. So what we would like to hear from you in the comment section is what your thoughts are. Do you have confidence in the judiciary of Nigeria as we speak? You know, those are the things that we really want us to look at. And do you what has happened now? Does it not make it more clear to all of us now why we need to participate in our governance using the powers we currently possess that we haven't used for 24 years? Those powers, let me quickly refresh our minds, are those two powers that we have as citizens. We are sovereigns, 14 two-way states. Sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. That is a power that we have collectively that we can use in all our local government areas to begin to hold these politicians to account. Secondly, how to use those powers specifically goes into detail. 14 2C states, the participation by the people in their governance shall be ensured in accordance with the provisions of this constitution. Now, that is showing you direct, clear terms how we can use those powers. What we are aiming to do on Citizen AY is to begin to share those powers. To share those powers, to teach those powers to our people in a way that will make them be part of the process. Currently, they talk about the document being a living document, but it is only a living document in the hands of those who are governing us. We, the people, don't even know it's a living document. That's why we're trying to wake it up. That's why we're trying to interpret it into our local languages so that we can be part of this process. That is what we're trying to do and encourage for many others to do on not only Citizen AY, but all other platforms. So the judgment itself emphasizes the need for us to begin to monitor what is going on in our governance. And we've got those two powers, 14.2a and 14.2c, to be able to do so. So I just wanted to just touch base on that. But let's proceed on. Let's hear the further judgment. It's pretty much wrapped up. We all know that President Tinubu is going to be the president. Nothing is going to change in that aspect. But let's listen on.
Governments, they argued, were laid bare in the petition with particulars of the allegation. They argued that first respondent, instead of considering the paragraphs of the petition holistically, seems to have considered them in isolation and apparently hence its wrong conclusion that the petition was vague, imprecise, and without necessary further particulars. While admitting that the names of polling units were not specifically stated in the petition, Petitioners' Counsel submitted that petitioners stated in different paragraphs of the petition that the polling units affected were to be contained in the statistician's report to be relied upon at the hearing of the petition. They cited the cases of Oluwedu Asajayi, Awolaja, and others, as of Citrate and East Horizon Gas Limited versus AFIOC and others. To submit that petitioners have by that pleading incorporated by reference the said statistician's reports. On the argument of the first respondent that the petition did not disclose any reasonable cause of action and so constituted abuse of process, Petitioners' Counsel argued that first respondent was by that argument trivializing matters of high constitutional importance raised by petitioners in the petition. Submitted that the petition that touches on correct interpretation of Section 133(2)b of the Constitution of this country, vis-a-vis the return of second respondent and the qualification or disqualification of second respondent, regulated solidly by Sections 131 and 137 of the Constitution, cannot by any means said to disclose no reasonable cause of action. On first respondent's contention that petitioners' failure to join Honorable Adejo and Governor Yahaya Bello and unnamed thugs against whom they made allegations of criminal misconduct in paragraphs 129 and 130 of their petition made those paragraphs of the petition incompetent and liable to be struck out. Answer to the petitioner submitted that Section 132 of the Electoral Act has specified the persons who may be joined as petitioners or respondents in an election petition. At Honorable Friday Adejo and Governor Yahaya Bello having not participated in the election or returned, petitioners are not in violation of the Electoral Act or any rule of law in not joining them. Besides, they also argued, no relief was claimed against the said two men, so they cannot be said to be affected in any way by the eventual outcome of the petition. That is the way we resolve this. My Lord, resolve it. Now, paragraph 4.1 of the first schedule of the Electoral Act, as amended, states thus: 2020 states thus: an election petition under this Act shall state clearly the facts of the petition, and the ground or grounds on which the petition is based and relief sought by the petition. This provision is so clear and direct that it does not require any aid in its interpretation. It simply restates in mandatory terms the first rule of pleading that claimants, in this case a petitioner, shall state clearly, quote and unquote, the facts of the election petition and
please
again,
let's have your comments on the screen and in the comment section
this
on both
requirement
Facebook and YouTube. We really appreciate that. I will endeavor to answer each and every concern or questions you may have.
It's a basic rule of pleading even in ordinary
just to
civil
aid
proceedings.
dialogue and to see your thought process on what's going on. How do you feel about this judgment? What does it mean to you? How does this impact our people on ground? These are the questions that we should all be thinking about.
Pleading, at the hearing to be pleaded, goes to the fundamentals of justice. For no one and defend the unknown. If one has to defend or counter a fact made by his adversary, the one must have due notice of that fact to enable him prepare for a defense. That is the very essence of pleading. As it goes to the very root of the rule of audio alteram partem, one of the twin pillars of justice, it would be misconception to describe it as mere technicality or regularity. It's a matter which cannot be waived. Indeed, by a long line of decided cases, it has been long settled that any evidence on the fact that ought to have been pleaded but it is not, goes to no issue at all at the trial and ought to be disregarded, end quote. Now, the complaint of first respondent is that the petitioners in their petition did not state their case as clearly as required by Section 4.1d of the Electoral Act, 2002. It complains that petitioners' complaints were vague, imprecise, and lacking in particulars. It does not appear to me that this complaint can by any means be waved away as idle. If anything, even the petitioners seem to have admitted that they did not plead those necessary facts. But their response to that contention, as shown earlier, is that they pleaded a statistician's report, which contains required details of the polling units where the corrupt practices they alleged took place. Incidentally, the said report, a very voluminous four-part document, the later tendered through his maker, Mr. Samuel Oduton, PW1, during the trial, shows on his face that it did not even exist at the time they filed their petition, and so was not served on respondents along with the petition to enable them exercise their constitutionally guaranteed right of responding fairly to the corrupt practices, quote and unquote, alleged particularized in it, and if necessary, also engage their own experts to reply to it. Engage their own experts to reply to it. Yes, the principle of incorporation, by reference relied on by them, that is petitioners, is part of our adjectival law and is supported by a fairly long line of cases, including MMA versus NMA, Ekpemupolo versus Edremoda and others, DFS Investment versus Brawalai Limited, Elo versus Idaosa, Abode Brothers Limited versus Niger Construction Company Limited and another. That principle cannot by any means override the fair hearing trial provisions of Section 36 of 1999 Constitution, which also underpins the rationale for exchange of pleadings by parties. See once again the victim of Naimeka and Atondana Ajani already quoted. A statistician's report that is supposed to contain missing particulars in a petition, but which was only filed in the middle of hearing of the same petition, long after the time for exchange of pleadings had closed and even after petitioners had called as many as 16 witnesses in proof of their case as happened in this case, cannot serve that purpose of our Audi and Terran pattern. Let the other party also be heard too. In short, the tactics employed by the petitioners in this case as regards their pleadings, and the petitioners and the statisticians report referred in it, is to say the least most unfair and definitely negates the current practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statisticians report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent, but it shall only be as it stands in the petition. In that regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State is lacking in particulars of the particular polling units affected and so are able to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think, sufficiently meets the requirements of paragraph 41D of the First Schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units of local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is in my opinion bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondents allegedly depleted and inflated respectively. The need to plead exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the First Schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims a seat alleging that he had the highest number of valid votes cast at the election, that is which is what the petitioners are doing here, the party defending the election or return shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed. Second and third respondents can only properly exercise the right under this provision, requiring them to, quote, give particulars of the votes claimed by the petitioners that they object to and the reasons for the objection against such votes, after petitioners have themselves set out clearly the lawful votes depleted by the manipulation alleged by them. Paragraph 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as the petitioners have stated in those two paragraphs that the disruption of elections in Adavi and OKE local government areas of Kogi State by agents of second and third respondents allegedly was captured in video recording which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. It is therefore also liable to be struck out. I'm also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof, which is a matter for the substantive hearing, especially as infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election material, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and what these failures enabled results of the polling units in the third LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioner votes is bad and vague as the particulars of specific polling units and votes of petitioners and respondents affected by said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the electoral acts aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly should say so, my lord. We have already produced all these things in EA03, and we don't intend to read. In any case, you get it and you see it. He also PDP versus INEC. For the same reasons, I am also of the opinion that paragraph 103 of the petition, where the petitioner simply advised generally that, quote, first respondent wrongly entered incorrect results for the petitioners in Borno State, is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am however of the view that paragraphs 104, 105, and 106 of the petition sufficiently clear necessary facts to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent use of beaver's machine. As to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent use of beaver's machines. The presidential election in Benue State, while paragraphs 105 and 106 simply state the petition as ground that second respondent was not elected by majority of lawful votes. With respect to paragraph 104 of the petition, first respondent complains that the petitioners there contended that the entire results of the presidential election were wrong.
Right thing
Yet they did not plead the results they perceive to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4.1, 4.1, C of the first schedule to the electoral act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondents won't show did not pull up to 25 of the was properly returned by first respondent having regards to the provisions of section 134 of the Republic of Nigeria.
Citizen AY. That's why we're speaking in English. And others
I am afraid paragraph 114 of the petition 115 and 116 and paragraph 4 where they said purported results from 6,418 polling units have and indicate zero accreditation. And paragraph 118 where they have that critically paragraph 118 and 119 are all bad for lack of particulars of necessary facts.
So we're trying
as for
to
the
do this.
statisticians report again referenced by them for the said particulars, I hereby confirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondents, so I shall overlook it, at least for now. Petitioners in paragraph 121 of the petition allege that first respondents presiding officers.
They're reading through the judgments, in fine detail. No problem. But the question that remains: how do you, as citizens, feel about what you are hearing? Are you happy with it? Could it be improved? Does it reflect your will as citizens, as sovereigns? Is judiciary working? Is the judiciary doing what it's supposed to do? Do you have confidence in the judiciary? These are questions we will continue to ask in this broadcast. We're not here to make any judgment. We are here to only pose questions and to really get us to look at what is happening and to demonstrate why it is important for us to continue to begin to exercise our sovereignty. I've stated that many times. Many of you know it. Offhand, I'm saying it. Section 14.2a. That's a power that we collectively as citizens possess, that we can use to hold your executive, your judiciary, and your legislature to account. Those powers are things that we must begin to teach to our children, ourselves, and workers. Everybody need to begin to exercise those powers. 14.2a states, sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. 14.2a. 14.2c, the participation by the people shall be ensured in accordance with the provisions of this constitution. These are things that we must begin to use. You see, our failure to, well, combination of failure as well as deliberate, what's the word I'm looking for now? A deliberate skewing of our mindset to focus on religion has meant that we are bystanders in what is impacting our lives on a daily basis. This kind of judgment, if it's the right judgment, is fine. If it's not the right judgment, it has huge ramifications on our lives. Something that we must be actively ensuring that we monitor and we participate in that process. That's what I wanted to state. But let's carry on.
Made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in one Kuanyara, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, Sub 2 of the Electoral Act, which is now Section 132 of the Electoral Act 2020, and confirming that provision had done away with the whole regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, this is what his lordship said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is an issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows: however, where such a party is not made a party, it will not result into the whole petition being struck out, and the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eitai Ojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State didn't talk to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also barred for non-joiner. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria Post Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also barred and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, Sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of President, the whole of the Federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. The percentages of votes polled by presidential candidates in any of the 36 states of the Federation or even the Federal Capital Territory only become of consequence when the issue verges on whether the candidate returned also satisfy the provisions of Section 131B and 2 of 1999 Constitution, as amended, requiring him to poll 25% of votes cast in at least depths of in at least 2/3 of the 36 states and the Federal Capital Territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested
Special
the
thanks
election
to
with him.
each and every one of
Section
you that
133
are
of the Electoral
subscribing
Act,
to
only
Citizen
other
AY
candidates
as
in
we
the election
speak
petitioner
and giving
can
us
properly
thumbs
join
up.
this
Thank you all so very much.
The person
The
returned
more
as
you
the
share
winner of
that,
the
the
election.
more the algorithm
Equal of
gives us,
this case of
which is
Buhari
more
and
people.
another
Thank
versus
you for
Yusuf.
watching. You're watching
Yusuf
Citizen
versus
AY, the
Obasanjo and
platform where
50
we
others,
speak
Obasanjo and
up.
Yusuf
Please
versus
subscribe,
others,
hit the notification button, and press
particularly
the thumbs
Buhari.
up. Thank you once again.
And another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, an unsuccessful candidate in an election cannot be made a party to an election petition against his will, end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. I do not, sorry.
Thank you.
I am rather of the view that facts necessary to elicit an appropriate response from the respondents of electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong
you
results.
can subscribe and help us grow the platform on YouTube.
For 22 namespaces herein,
Thank you all so much.
paragraph 44, where they aver that there were discrepancies on very large scale at the various local governments, various levels of reporting and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where these said quote-unquote large-scale discrepancies took place, and paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report among other documents they did not front-load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground for their petition that the petitioners aver that the correspondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said. It's also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the cases coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41b of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahya Bello of Kogi State accused in petition of committing electoral malpractices, paragraphs
please, I want us all to know that in the end, we're the ones with sovereignty, and we need to begin to exercise those powers. We are happy to demonstrate how we can use our sovereignty collectively in each of our local government areas, and we continue to speak on that. Please do join us in spreading the awareness about our sovereignty and how we can use those powers to monitor our governance on a daily basis.
100, 500, 800, 900, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140. On the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether having regard to the mandatory provisions of paragraph 41b of the first schedule of the Electoral Act, a reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraph 16a, b, C and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraph 16a, b, and C of the petition where the petitioners alleged that we read them out. The next reference, section 134 of the Electoral Act, stating that the election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1), So the fact that an election shall not be liable to be invalidated by reason of non-compliance with provisions of the Act, if it appears the election tribunal or court that the election was conducted substantially, compliance with the principles of the Act and non-compliance with that substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, Senate Council submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the turn of second respondent as the winner of the election. But not only the petitioners not assert in their petition that non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court form an opinion on that non-compliance and corrupt practice complained of substantially affected the result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioners counsel submitted have simply blown quote-unquote muted trumpets, and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners are aware that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election. In that the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, first respondent first application. Also to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition. Submit that the petition as by reason of the alleged information in the petition identified above had become academic and considered abuse of process of course, so this court is robbed of jurisdiction. Entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issue 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81.
How are you seeing this, citizens?
In
the end, they are working for us. How do we feel about this? What is your sense on what you are hearing? Do you agree? Do you disagree? What is your sense of it? How does it feel? Are we translating this to our people in our villages? These are the questions we should be asking. Are we communicating this to the village? What impact this judgment is? What the impact of the judgment is? And how will it impact each and every local government area?
Set out the arguments, both of them. He said, in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. In exercise, I also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitioners, paragraphs 92 to 1% of the petition, also made by the second respondent here, I dare determine.
I said this earlier on in the broadcast that we need to have sections when this kind of thing is going on, because we're a multi-language nation. Certainly, our local languages, they need to be translating this. There need to be people who are translating it in their local languages for our people to be able to hear and follow, and actually have specific channels for Yorubas, for Igbos, for Middle Beltans, for as many. And I think it's something we probably need to do, because that way they can be involved in this process. What is clear is that the process as it currently stands excludes millions of us. Maybe about, in all honesty, maybe about 5 to 10 million of us will probably follow what is going on. The overwhelming 133 million that are proven to be in poverty will not be able to follow this. How do we address that? These are the things that we really need to be addressing now. Whatever the judgment, however much whichever way this thing falls, the evidence here is clear. Our people we're not actively participating in our governance, and that is where we must focus on to lift our people out of poverty. You can only get involved in what you know of. But if you are told this is it, and you're not aware of your powers, you can't actively participate in that. That's why this idea of translating the constitution into our languages is so important, and transmitting this judgment or the court cases of such importance in, so that everybody in, from the local, from the villages into the local government areas, we are all aware of what is happening to us and how it's going to impact our lives. Anyway, let me proceed. I just wanted to just add that.
Defined properly and sufficiently clear paragraphs 24 down to 27 of the petition. However, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters cards collected the unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first petitioner and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading not to contain the precise number of permanent voters cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in conduct of the election, which practices they complain took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondents' votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akwa and Port Harcourt local government areas of Rivers State did not reflect the actual votes. Just as presidential votes, actual votes scored in the said local government areas, or even those updated to IRF by INEC and so liable to be voided, no correct quote-unquote figures of the actual votes cast as reflected in the IRF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of amendments, all by second respondent against the petitioner, only laid out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 410 of the first schedule of the Electoral Act. Pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out.
Hello again. For those of you who are joining us on YouTube, as you're coming in, please don't forget, just take a moment and give us a thumbs up. Help us grow the platform. We really appreciate those of you who've given us the thumbs up already. Let's continue to grow that. The more you give us a thumbs up, the more it actually helps to improve the algorithms. So we want to thank each and every one of you for joining us and watching our broadcast. Please subscribe, hit the notification button, and of course, give us a thumbs up. This judgment is very, very important. It's going to have a huge impact on the lives of all of us, millions. As we all know, there are over 133 million Nigerians in poverty. This judgment, how will it improve their lives? That's the question I'm asking. How will this judgment, whichever way it lies, how will it improve the lives of the 133 million? Will either way, let's just say by a miracle, we'll know the judgment already. The judgment is Tinubu is going to be the president. But how will that make the lives of 133 million people better? It's not about palliatives. It's about infrastructure. These are the things that we really must address to impact the lives of our people through our collective action, making them aware of the powers they possess. So there is a lot of work for us all to do collectively. But I just wanted to just say that. So please don't forget, as you're watching, either on Facebook or on YouTube, please go ahead and subscribe to Citizen AY, the platform where we speak truth to power. Let's proceed. Thank you very much.
Right to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yar'Adua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IREP portal in real time, was caught and made comatose by Section 134 of the Electoral Act. We think it is, I think it is neater and even safer to defy to the main argument for determination of this merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Nwankwo and Yar'Adua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. In his own application of 8 May, third respondent, like the first and second respondents, also pleaded to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join the Sadejo and Governor Yahya Bello of Kogi State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argue in response that their complaints were properly pleaded in the petition and so not imprecise, nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents based on the same paragraph in the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. We further hold that petitioners have amendments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas the issues of the assurances given by INEC of real-time transmission of results to IREF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house experts from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners. What is that? In petitioners, the amendments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses, testify about first respondents' omissions and commissions in the conduct of the election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraph 23, 82 to 89, 88
Oh, thank
to
you so much,
91,
those of you giving us a thumbs up. Continue to do so. It will help the algorithm. Continue to give us the thumbs up on YouTube. We really appreciate you. Every single thumbs up helps us. So thank you, and thank you. You're watching Season Away, the platform where we continue to subscribe, thumbs up, share, and please help us reach more people. You'll help the algorithm.
And
Thank
leaves
you
us
so
to the
very much.
standalone application of third respondent also filed on 8th of May 2023, as well as the 3 applications of third respondents, all objecting to the petitioner's replies to their petition. To their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. Then we went on to say that the thrust of the response of Petitioners' Counsel, that is 455. Thrust of the Petitioners' Counsel is a suit number SCV 351 that was not filed by the petitioners. So this petition, sorry, I'm still reading 544. And now it is settled position of law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See your Okafor as Attorney General of Anambra State. Necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Atiku Abubakar, and his political party, the PDP, can be properly described as PVs of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response. But the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound or obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this.
Duas is waiting.
Good example is recent new currency case.
Fix the 4 refineries. That's what our people need. This judgment will not improve that, but
the new currency case that was initiated by the Attorney General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case the said suit number SCCV 354/2023 filed by the plaintiff in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as SBPV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and inspect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. That simply add that we should not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. Proper sanction in circumstances of this case, as we have already pointed out, citing Wanko and Yaradua, to strike out the paragraphs of the petition where those allegations were made. That order will also further add, contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutigi and Pastor Cholo on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. Okay. So the next one, we now go to the challenges, the replies filed with the petitioners. All the respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies of paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner, and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They are sought striking out of paragraphs 1.1, 21, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the provision as Senator Dino Melaye, and PDPC, both deposed on 20th April, striking out the petitioner's list of additional documents dated 20th day of April, which accompanied it. Sorry. Thrust of the argument, which is counsel founded principally, and we replied, we produced the arguments, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. The second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be to be objecting to them. The issue raised by first respondent, that's INEC, actually relates to the competence of the major process before the court to which reply filed by petitioner. It's an issue which counsel to first respondent as ministers in the Temple of Justice. And even first respondent itself as a party to the petition.
It's a very long
has
one.
a duty to bring to the attention of the court.
Please subscribe
that objection even becomes that obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. preliminary objection like this preliminary objection like the argument of petitioners, therefore rejected. Coming out to the merits of the application, it is common ground that the provisions of the electoral act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision with the employment of the word shall forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the context of this petition. Cited cases, I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this sin only restate the well-settled position of adjective and that the claimant's claim or grievance are made in the statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Ulubodu and Lawal. Cited what the Supreme Court said there. They said the plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad, and no evidence would be admissible in his proof, end quote. That settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is a law and implied joinder of issues on any fact placed in the statement of defense, and any averment contained herein is deemed denied. This is cited. As to what will amount to new issue, we cite again against Simba. Against Simba was earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners to their reply. The additional averments of how results could not have been uploaded to INEX IREF after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it, not to talk of the repetitious reply of amendments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the Schedule of the Electoral Act, particularly as relates to the further details as are quote and unquote as petitioners labeled them in their reply of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. Yes, reiterating that all that the petitioners refer to in paragraph 146 of their petition is the bare statement that, quote, the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seem to have had no clear idea of what they meant by second respondent's non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications the person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61(a) of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 2(1)(b) of their reply that they were simply giving, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they averred in paragraph 1(b) of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraph 2(1)(b) and C of the reply, where petitioners are about to no upload of polling unit results by first respondent, presiding officer at the election. We also agree with first respondent. And new issues, or at least mere further denials by the petitioners, respondent denials of the petition. Such is not also permitted in reply. See again, Bakar and another. Versus Ibrahim, Akeredolu versus Akinremi, Egesim versus Onuzurike, Spasco versus Alrain, Shola versus LGB, and Obot versus CBN. In light of all the foregoing, the two witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply issue, are also incompetent and liable to be struck out. Summary, first respondents' applications of 9th May succeeds in its entirety. Accordingly, paragraphs 1, 2, them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)(b), 2.1.
We have pushed through the 6-hour mark. The broadcast has been going on for over 6 hours. We want to thank you all that have joined us that long on Citizen Wider platform where we speak truth about. We truly appreciate your support. Please go ahead and go down to Citizen Wider on YouTube and subscribe. We have over 119,000 followers on Facebook. We would like as much of you as possible to go ahead and subscribe to us on YouTube to help us grow that platform. So it gives us an alternative platform to carry out our broadcast, should in case Facebook starts doing the usual stuff. Please subscribe, hit the notification button and press thumbs up. Thank you so very much.
Of documents and that is foul play, which paragraph 16 sub 1A to the first schedule of electoral act expressly forbids. Consequently, paragraphs 1B, 1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. Second respondent, when petitioners about new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11,
struck out.
Roman figure 1, 24, and 25 of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on 20th of reply 2023 stand either not objected to or the complaints against them are not made out. Otherwise, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, now we come to third respondent's application, and we come straight to say that I find necessary to first observe that like all other replies of the petitioners, the impugned reply of petitioners of 24 district that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent in reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist qualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 16A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, that last paragraph 35, are, as third respondents has rightly pointed out, either mere denials of third respondents' reply to the petition or repetitions of petitioners' amendments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act, see again the cited cases. It's also not the law, as erroneously argued by petitioners' counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. Somehow, counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. Yeah.
You know what I would wish for in all of this as I'm hearing this? I wish we would be this eloquent in using our own our own local languages. Because the eloquence displayed here, who is going to benefit? The display of this eloquence in the speaking in the language and everything else, it's not going to benefit 133 million people who are in poverty. But if they were able to do this is why we need people who can speak our language to be part of this process. Because those who are going to be impacted by this decision are not even aware that this decision has been made. And these are the things that really concerns us on the platform. Citizen Network, the platform where we speak truth to power. You can hear the way the English is rolling off his tongue, and all of the people, they're speaking all this grammar. Fine, that's well and good. But how is that? It's not going to crystallize into something that would be meaningfully improving the lives of over 133 million people who are living in poverty. Whichever side wins the argument, by the way, we know President Tinubu wins. Even if it was to Peter Obi, because of the way that constitution is structured and our lack of participation in it would mean that we will simply continue to suffer. But that's why we need to participate. 14.2a and 14.2c, I reiterate, in our local languages. I've done it in Yoruba, I've done it in Igbo, I've done it in Pidgin, I've done it in Hausa. You know, we need to begin to make our people be part of the process so that they know what is going on at every step of the way. Let's proceed. Please subscribe to Citizen Network, the platform where we speak truth to power. Let's go ahead.
EW18, Ms. Sadia Mohammed Haruna. EW21, Mr. Samuel Odunta, a statistician. EW23, Janet Nuhu Turaki. EW24, Christopher Bulus Ado. EW25, Victoria Sani. EW26, Hitler Egwonu Nwala, a forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties. The ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents.
Ladies and
now
gentlemen,
proceed to consider the said objections of respondents. 1. The validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45E of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents Council on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, to which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition, and even after hearing of the petition had commenced, Respondents' counsel again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanipepo SAN, for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6, sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondents has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election, and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Wonwala, but also their last witness, Mike Enauro-Eba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Wonwala, and Mike Enauro-Eba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or notes were not front-loaded with the petition, are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus, and I want to mention it. It says the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANVP, Mr. INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogbo, citations supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 45B of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party, MP versus INEC, in appeal already cited, presided over by Justice Ige Nimpa and Agim colleagues, as Agim as he then was unanimous in his decision on the point in issue. Ige JCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 34554 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call, in proof of the petition, and more importantly, written statements on oath of witnesses. Where there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoena witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi Ararume and INEC, this court also decided over by my Lord Justice Samani JCA, the concurrence of my brothers Owade Akimbami, Bolaji Yusuf, and Bayero JCA, again confirmed this position when in that decision was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena at its civicandum, but it must be realized that this witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement on oath was subject to the requirements of the law as stipulated by paragraph 4.5 of the first schedule, strict compliance with paragraph 4.5 of the first schedule to the Electoral Act is mandatory. Please subscribe to of such a nature that there is sanction in paragraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okabwe, and then Oba and Vincent, Midra and Patricia, Awayemi, Lasun and Awayemi, all these cases of the citation here and there already referred to
Facebook. Please go ahead. Earlier, just go to the YouTube if you know and subscribe there. You're doing us a great favor to reach more people. Thank you.
It is of interest that in all these cases, the earlier decisions of this court, Midira versus Patricia and another, and Lasun versus Awayemi, relied on strongly by Mr. Chris Uche SAN, what the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche SAN, the lead counsel for petitioners hearing, wrote a glowing forward to. Learned Dr. Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SR position of this court in Omidira and Nete, and then Lasu versus Awayemi. There, Chief Uche SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidi Wrong versus Sete, see also Lasso and Awoyemi, citation supplied, wherein the Court of Appeal held that it will be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by sufficient witnesses outside the stipulated time frame has been watered down.
It is a
in that
momentous
all evidence required in proof of the case must be brought within stipulated time frame.
And we
See the
thought
case
it
of
was
Ogba
best
and
we spend the
Vincent,
time to
where the
discuss
court
to have that on the
where the
platform.
Court of Appeal,
And we are grateful
Adim
that this
JCA,
many
as it then
of
was
you
in lead judgment,
stayed
held.
to
I
watch
think
it
that
with
this
us.
court in
Sorry, I'm
Omidi
just killing myself.
and the Supreme Court in Oke
I suffer from
Aminico
mosquito
adopted
bites. I
different
get mosquito bites,
approaches
so I'm
in
putting something
addressing
on
the
my
issue
skin.
of whether a
It's
tribunal
getting evening,
or a court
and
can
if I
allow
don't put it on,
a
they
witness
will
deposition
bite me
or other
like
document
crazy.
not filed along
this
with
heat
the
they will,
petition
so I'm
or not
putting
filed
that on.
within
I
the
will
time
put the other
allowed for
ones later
filing
on.
election petition
But
to be
I'm
filed
just
and
showing you that.
used
So, but
in
we're
an
thankful.
election proceeding.
Please, as
Omidi
you're
Wrong's
watching,
case did not
take a
strictly
minute.
enforce the time
If
limits
you haven't subscribed
prescribed
to Season
in Section
1,
141 of
go
the
and
Electoral Act
subscribe. Hit the button, give
2006,
us thumbs up.
the provisions
This decision
in the
is,
first
it's
schedule
got huge
bear to in
ramifications,
prohibiting the
and we're
introduction
going
of
to see
additional
what
facts
will be
in
said
the proceedings after the
post the
period allowed
decision.
for filing
We are in the middle of the
petition
discussion,
and
the
closure of
decision
pleadings,
and the judgment.
paragraph
But
1,
post the decision,
1
what
of the
impact will it
Election
have on all
Tribunal
of us?
and
What
Court
this
Practice
means
Direction
for
2006,
what we could
and
know
the
as a
content
democracy
and
in
form of
Nigeria
the
today.
petition.
Is it a good
It
thing?
held
Is
that
it
the
a bad
purpose
thing?
of the
Will it
Practice
improve it? Will
Direction
it make it
is to
worse?
guide and
You
regulate
know,
compliance
so
with
many
and
questions. So many
observance of the
questions.
provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal, applying the election
take a
tribunal and
minute,
court practice
go ahead,
directions as
subscribe to
overriding
Season
the
1.
rules
Give
of
us the
court
thumbs
in
up as you're
election
watching.
cases.
The more you give us a
Noke
thumbs up, the
versus
more the
Mimiko, the
algorithm
Supreme
will
Court
reach more people.
approached
We need to grow the platform. There's a lot of work we need to do,
in keeping with the
particularly in
current
translating and
position,
ensuring that
with the
people
current
begin
judicial
to
trend
know
of
their
strictly
own
applying
laws
electoral
in their
laws
own language.
and procedural
That is
rules
something
and
that
giving
would
them
be a
supremacy
game
over
changer.
rules of
It will
court
be a
in
game
election
changer
cases.
for
The law has laid
democracy
out
in the place we call Nigeria, and perhaps
the
even lead
strictest
to the
jurist
self-determination
in
for
Okemi and Mimiko
Yoruba and
is
Biafra
that a
nations
witness
in the long
deposition
run.
that is not
Now is
filed
not the
along
time
with
for that,
the petition
but that is the goal.
within 21
That is
days
the plan.
allowed for filing the
What is
petition
the
cannot
platform
be
where we speak
filed
to
in the
the power?
proceedings. It held thus. If there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any
not
person.
admitted into
There are
petition.
several
Exactly.
ways to
This
go
is
about
crazy. How
placing
can you?
same
I
before the
mean,
tribunal? The
yeah.
evidence are
What is
very
you
clear
on
this,
YouTube?
and the
You're right.
petitioner ought to have
You
resorted
know, let me read to you
that
what
procedure.
Put
this in italics, we have earlier mentioned it in 03.
on the broadcast.
As
And I
earlier
think it's
said,
what it says here,
CPC
all the PVC and beavers and voter sheet tampering not admitted in the petition. I mean, that is, yeah, why not? You know, why shouldn't it be? But, I mean, they just...
The author has ably and
I think it's a
remarkably
valid
sought
point to ask.
to examine the
Certainly.
legal framework of electoral legislation within the landscape
But anyway,
of judicial
what are your
decisions
thoughts?
emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all
it's hot today, so
stakeholders
I've
in the
opened the
development
door.
of our constitutional democracy,
the last few
unquote.
days. So
I shall hold counsel to his words,
the mosquitoes just have
not
a
just because they are coming from him, but
the,
also because they are correct.
The repellent on.
Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoena witness even after commencement of the action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement they say of their witnesses filed by them after hearing of the petition had long commenced wherein were in order, were in order, full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court.
I'm sorry, all of those lawyers and sons, they look bored on there. The judgment should really go to the central point. But anyway, listen, I've got a bit of good news. On Oduduwa TV Radio, even though that platform has been demonetized by YouTube, wrongly demonetized, I might add, we have reached 10,000 subscribers on Oduduwa TV Radio. We want to say thank you so very much to those of you who subscribe. More importantly, we would like you to go and subscribe to our new platform, Oduduwa TV Radio 2, because it really will help us in what we're trying to do. We keep talking about trying to translate things into our Yoruba language, our Igbo language, and all of that, and doing the work behind the scenes with people on ground. All that will require funding. Through subscription on Oduduwa TV Radio 2 and Citizen AY, the combination of that will give us ability to be able to fund things without having to ask for funds. Or I'm not, since the stuff with what's happening in Yoruba Nation, I am loath to come and ask some people to donate something for me or for what we're trying to do. What we need to do is we just need you. This is why it's important that you subscribe to Citizen AY. Just subscribe to Citizen AY and Oduduwa TV Radio 2, and to help us grow that platform so that the work we need to do, there is a lot of work that we need to do in our communities. We need to reach, you've seen, poverty-stricken 133 million people. When they have this information in their local languages, they can begin to take control of their own future and participate in the governance and hold them to account using 14.2a and 14.2c. That's what we want to do. So it is really important when we say to you and urge you to please subscribe to Citizen AY on YouTube, hit the notification button, give us a like, give us a thumbs up. Likewise, same thing on Oduduwa TV Radio 2. We really need that support. But we are, however, grateful. Despite the fact that YouTube has demonetized Oduduwa TV Radio, the main channel, we are grateful that it shows that we have the love and the support of those following us. So we would like that to be reflected in all our sister platforms. I want to say thank you very much to everyone, each and every one of us, of you who helped us with that milestone. And I want to thank the Oduduwa TV Radio crew for all the work we've been doing for over 2-3 years consistently. I thank each and everyone, Lady B, Omoba, Amotekun, Ima, Lekure Rosulu, and so on and so forth. Olanrewaju, TJ. There's so many people that we need to thank for being able to reach that milestone of 10,000 subscribers on Oduduwa TV Radio, even though we know that we've been demonetized. The fact that the people still subscribe there shows us that our messages is cutting through and trying to empower people, and we're so grateful for that. But let's now build Oduduwa TV Radio 2, and of course Citizen AY, the platform where we speak to the power that you're watching just now. So that's a bit of good news I wanted to bring to you. Let's proceed.
A very strong admonition of the British House of Lords of Lords, Lord MRL in Dupont Steels Limited versus SIRS. Citation supplied, where the learned Lord Scaman in his speech said, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. Interpretation does, of course, imply in interpreter a power of choice where different constructions is possible. But our law requires that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Palatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits its idea of what justice requires in any case. That is the settled position of the law, even in this country. See Ndomaeba and Shukwogo, citation supplied. Aromolara versus Aguru. Coca-Cola, Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new Section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management through pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okogbu, and others, citations supplied, where my colleague Abadwa JCS said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties and open the floodgates for all kinds of abuses of the judicial process. Quote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC. And then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of study decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuabu GSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16, Ms. Edosa Obosa. PW17, Ms. Aleria Ayuba. PW18, Ms. Sadia Mohamed Aruna. PW21, Mr. Samuel Oduntan, the statistician. PW23, Janet No Turaki. PW24, Christopher Bulusado. PW25, Victoria Sani. PW26, Hitler Ewonu Mwala, forensic expert. And PW27, Mr. Mike Enauroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that, given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1E, PR1C, PR1D, PR1E,
I greet you all. It is a long one.
PBD1A,
We will stay for the duration of this broadcast, no doubt. We are pushing through 7 hours now, I believe. We're coming to 7 hours now. Please, as you're watching, go ahead and subscribe to Citizen AY on YouTube. Help us grow the platform. Subscribe to Citizen AY on YouTube. Hit the notification button and give us a thumbs up. Here's how you do that.
PBF2, PBF3, and PBF4, coming from and tendered by the same petitioners' witnesses, namely, as I already listed, EW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned
on Facebook,
are incompetent and are hereby expunged from the records of this.
We thank you all so much for your continued support of this platform. Without you, we will be nothing.
That takes so into the other objections.
All over 119,000 of you, we thank you for following us.
Raised by the respondents to the admission of documents tendered by petitioners at the hearing, which
here's what you need to do.
Objections, they only give notice that there will be reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, I deem it necessary.
What is January? I want to say special thank you for staying all this while with us and of course Vivian D, the moderators on the platform. They are the two moderators we have on the platform, and Alagba Ima as well. Akalamago TV is run by so please do subscribe to him as well. And
so respondents cannot resile from that agreement
as we go
raise objections
as
they are doing
here. Take a minute.
Even cited section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it. And it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As ministers in the Temple of Justice are therefore within their right and in fact duty bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Answer to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023, second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under Section 104 of the Evidence Act 2011 for certification of public documents. They say petitioners did not pay for certification of some INEC documents, specifically exhibits EAJ1, to PAJ 37, PAJ 38, PAJ 39A to F, PAJ 40, PAJ 41 to PAJ and PAJ 41 to PAJ 7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAS13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Then Council, all citing the cases of Tabik Investment and GTB, Dimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argue that certification fees for the said documents having not been paid by the petitioners, documents remaining admissible and liable to be expunged from the records. Petitioners' response argued
each and every one of you that have subscribed to us on YouTube, on Citizen AY, the platform where we speak to power. Let's continue to do so. Share it among family and friends. The task has truly just begun. The task has truly just begun.
Second respondent and paragraph 2.16 to 2.
I want you to know one thing for a fact. For a fact, take it or leave it from me. For a fact, whoever wins, whoever would have won this case, we know in this case is Tinubu, even if it was Peter Obi. The fact that we the citizens have not been encouraged to participate in our governance, and now that we are now aware of it, that fact that the only way to get our good governance it requires our 100% participation in our governance using the powers I keep reiterating, 14.2a and 14.2c, using those powers on every day, continuously, beginning to hold our governance to account is the only way we will get the infrastructure, the quality of life that we truly deserve as citizens of a great country with untold mineral resources. It is our monitoring of our governance using the powers of Section 14.2 and 14.2c to hold them to account and make sure that we remind them that we are the sovereigns. We need to be having monthly meetings with our State House Assembly, House of Reps, local government chairman, and senators, and indeed governors, to come to the meeting to remind them that we are the sovereigns, and every meeting we say these words: sovereignty belongs to the people of Nigeria, from whom the government through this constitution derives all its powers and authority. We serve that as a reminder to them. For 24 years they have not remembered that. They've forgotten once they got in. We must remind them at every meeting. In all 774 local government areas, we need to have that kind of a monthly meeting, town hall meeting, where we remind them of the sovereignty that we possess at every meeting, so that they will comply with what we, the citizens, want. We have suffered for too long. Out of 200 million people, over 133 million are suffering. That system has broken. It requires our active participation. We must collectively join hands in doing this. Please subscribe to Citizen AY, the platform where we speak truth to power. Let's proceed. Thank you.
Fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it, as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document, as required by subsection 2. Payment of certification fees is only a condition precedent to the certification, so it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoman, Sodike, ANPP, and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made by the receipt number RRR 270-842-653235.
And on almost 7 o'clock, we're going to see if it's going to go past 7 o'clock, I think. I think we are...
It specifically states on its face thus, the sum of 6,696,301 naira 25 kobo only, being payment for CTC, IPO, electronic, of a copy of data.
Let's hear your comments as you're listening, as you're watching. And some of you may be coming back from work.
Although not
let's
very
hear your
legible.
thoughts on this judgment.
With time,
in effect, status quo remains. President Tinubu remains the president of Nigeria based on this judgment alone. But what will be the reaction of the people?
Another documents, 2023 president.
What will be the reaction of people to this judgment when it dawns on us that President Tinubu is in place and now the courts have now validated his own assertion as against that of Peter Obi? What are the ramifications of that for what we know as Nigeria? Will people accept this? Will there be issues? How will those issues be resolved? What steps can we take to address these age-old issues of governance failing to meet the needs of the people? What steps can we take, in that awareness? Are you prepared to play a role in that? These are the many questions that we have on the issue on ground. Whichever side wins this argument, unfortunately, the participation of the people in their governance has been absent. And we're trying to encourage that through what we're doing and promoting on Citizen AY, the platform where we speak truth power. We are championing the cause for the people to know the constitutional powers that they possess. Section 14.2a, for example, sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. 14.2a, 14.2c, how to use said power. The participation by the people in their government shall be ensured in accordance with the provisions of this constitution. These are two powerful sections of the constitution that we need to teach to everybody in the community, in all 74 local government areas, in our local languages. I emphasize in our local languages, because that way they become engaged in the process. That is what we are really trying to drive at. So please, we need your support here. I'm calling on everybody watching this and who will be watching it later on. As you're watching, please don't forget, go straight ahead to Citizen AY on YouTube. Subscribe, hit notification button, give us thumbs up. We've been doing a drive about this section 14.2 and 14.2c and how to use it. And we want to begin to get some champions in terms of, I like to call it constitutional awareness champions, who will be in those communities teaching the people in their local languages so that they can all stand for themselves. We should be tired of giving fish to the people. Now let's give them the net to be able to fish themselves. The net in this case will be the powers within the Constitution, teaching them in their local languages so they can begin to exercise those powers at a local level, holding their governors to account on a monthly basis, calling town hall meetings that those they elect into office, local government chairman, state house of assembly members, house of reps, senators, even governors, to come to monthly meetings where they will remind them who the sovereigns are, which is, of course, the people of the citizens of Nigeria, to whom sovereignty belongs. Sovereignty belongs to the people of Nigeria, from whom the government, through this constitution, derives all its powers and authority. I am really, really sure, I'm absolutely certain that if we all collectively work on this basis, we can begin to empower our people, and they can then take the decision themselves later on whether or not to put referendum based on the actions or inaction of their governance now. So we need to be active in this process. Please subscribe to Citizen AY, the platform where we speak truth to power. Let's proceed. Thank you very much. Don't forget, subscribe, hit the notification button, give us a thumbs up. Please go do so now. Help us grow the platform. We truly are grateful for your support. Let's proceed.
Also of the opinion that the petitioners seem to 595 seem to completely misconceive the objection raised by the respondents, which is to the effect that the said documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011 and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to Section 146 of 1 of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, Section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of Section 83 sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of
It's 3 minutes to 7, and normally we'll be going to channels news to see what's going on, many of us. But channels, I'm sure, will be watching what's going on. I'm going to try and do something behind the scenes to see what they are doing there, and I'll give you that heads up on that. But let's continue to listen to this judgment. It is comprehensive indeed. But what is it going to do to our life? What does it mean? What does it mean for us all?
To eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was still produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH 1 to 4 and PAR 1 A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them.
So we're just going to look at what's happening on channels.
I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of Section 83 sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then
I don't
the
see
next one is
anything on channels
inadmissibility
as
of
of
election
yet,
documents
but I'll
tendered
look at other platforms
as
no doubt.
exhibits by
So let's
petitioners
see.
on
Let us
grounds
see
of
what's going on.
absence of pleading to support
So it may
them
be
and
on the
consequential
Facebook side.
irrelevance
They may be
to
doing
the
it on
petition.
the other side.
The respondents'
So let us
arguments
see what's
here
going on.
are given. So we now skip that to the resolution. We've seen that, and the resolution we
we've
have
been
is,
watching this for
it
over
appears clear to me that
5-6
the
hours
respondent's
now.
objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and his agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely
so we're just trying to see what's going on. I think you need an
Damawa,
update on
Akwa
that,
Ibom,
obviously.
Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi,
So
Niger,
it's 7 o'clock exactly now. So we want to see what they're
Taraba
doing.
states.
So they are still on that case themselves. They are not going to go and do live broadcast. So channels news, and I presume Arise and others are likewise doing the same thing. They are fixated on this judgment that
if that
you
is
see on the
done as
screen.
it should be done,
So
the respondents
it's
would
gonna
have
be,
come across
let us
where
continue to watch
petitioners
that.
let no one
yeah.
in doubt that their complaint about the election is nationwide and not isolated to only some few states.
Let's see. It looks
That
like
much is
there's some
clear.
discussion.
First, from paragraph 107 of the petition, where petitioners averred that the petitioner shall give evidence to show that the election results as purportedly declared by first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table below, and table was given, are wrong. Then they proceeded to list each of every state of the federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said averment.
So, ladies and gentlemen, it's over 7 hours. We are through the 7-hour mark now on the broadcast. 7 hours straight on Oduduwa TV Radio. I'm sorry, on Citizen AY. Beg your pardon. And we've been sharing it on Oduduwa TV Radio as well, on YouTube and Facebook, and Facebook and on YouTube. Oduduwa TV Radio. So, thank you so much for those of you joining us. Please don't forget, as you're watching, wherever it is you're watching from, go ahead and subscribe to the AY on YouTube. Hit notification button, give us thumbs up, help us grow the platform. We really appreciate your support. We need to grow that platform. There's a lot of work for us to do. If this court case now proves why our people need to know these decisions in their local languages. Many people in the local government areas will not know what this means because they're speaking grammar. We need our people to understand it in our local languages, so that they can understand the impact on their lives. Really important point to make.
Of the petition.
Let's proceed.
These are the same averments to documents respondents are certain were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection
if you haven't hit the like button on YouTube as you're watching, please do so.
Then objection made by only the third respondent.
Just go ahead. It will only take a second, not even a second. Just hit the like button.
Petitioners were raised by only third respondent, and now proceed to consider them. Admissibility of video clips. Arguments were advanced there on. Okay.
You may not be. I can't show you. I'll have to do that way. But I will endeavor to show you. But there's a let me show you.
So we say that I have the opinion that the contention is also conceived, especially
hit the red button.
when regard is held to paragraphs 1.
So just go here. So
G of the
hit the red button.
Of the same video clips made by PW19 Dr. Ted.
That's the like button.
The authentication required by section 84 of the evidence
that's all
in
it
the
will take
circumstances
you. It won't
the
let down a
video
second or two
in issue were made. The statements assuring the court that they are in exact state,
really appreciate
same
that
state
very much.
they were in the internet, where Dr. Ted, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Ted's certificate in XBPAF 4B above. For the same reason, the argument of Dr. Ted is not the argument that Dr. Te is not in position to answer questions.
Again, we are grateful for the 10,000 subscribers on Oduduwa TV Radio YouTube. Even though we know that YouTube have demonetized the platform, the strength of following by the people, by those following us on Oduduwa TV Radio, we thank you also very much. We are over 10,000. What we need to do is to now do that on Oduduwa more and more. And of course, Citizen AY, the platform where we speak with you. We are close to 3,000 subscribers here on Citizen AY. We'd like to get to 10,000. We would love to ideally. So every time you hit the like button, every time you share it, every time you share it to family and friends, give us a thumbs up and subscribe. You help us get closer to that milestone. We are truly grateful. Thank you very much.
Only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding. I think we've seen that. And anticipation of it by interested parties. I think we've done a little consideration of this earlier. So we'll go to number 3. They said also that exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Mike Enauro to show second respondent's non-qualification for the presidential election on grounds of his alleged conviction stroke fine in the United States of America, forgery of certificates and dual citizenships are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and...
Is it irrelevant, really? But, I mean, I don't know. I mean, that's a judgment. We can't. Is it irrelevant? I don't know. I mean, just... One has... I'm not trying to...
I have already ruled while considering the preliminary objection of the respondents to the petition and replies by of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of a second respondent's conviction / fine by a district court in Illinois in United States alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1d and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just few seconds ago ruled here in this judgment that evidence of PW27, though through whom they say the documents SB is now impeached by third respondent were brought in, is incompetent for non-compliance with paragraph 45b of the first schedule to the Electoral Act. Those rulings constitute issue estoppel, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Francis Shano and Afribank, and also Lawal Dawodu and Kadoso and Daniel, and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted.
Can the judiciary be said to be impartial based on this judgment? I don't know. Can it be? Do you have confidence in the judiciary? Do you? I'm genuinely asking a fundamental question here. Now, to be able to answer that question, how many people know about this process right now in Nigeria? I can categorically tell you that 133 million people are unaware of the ramification of what is being discussed here. It's not in the language they understand. It's in English. And we know that maybe, 1 million or 2 million, maybe 3 million people are able to follow the grammar that they've been speaking for whatever. There are over 133 million that will not have a clue what's going on. They will only know this is what they said and that's what it is, and they will not know that they have powers to begin to actually question their governance, like I've been trying to promote and raise awareness about. So there's a lot of work for us all to do. I mean, I'm just putting that out there. Let's hear your comments on this. Thank you.
PW26 is also further upheld and the said documents already held incompetent and inadmissible by earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then the third one now, exhibits the objection of third respondent to the admissibility of exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, PBD4, PBE1, up to PBF3, PBF4, tendered by PW27, Mr. Mike Enauroeba, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents to documents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my leader to continue with the judgment. Thank you.
Well, I now consider the substantive matter, the substantive petition. However, I wish to state that despite our conclusions above on the objections raised by respondents to documents tendered by the petitioners, I am still reminded to evaluate evidence adduced and consider merits of the petition. The only evidence I shall not revisit are exhibits PBD, PBD1A, PBD1C, 1B, 1C, 1D, 1 PBD1A, PBD2A, PBD3, PBD4, PBE1, 2, 3, 4, 5, 6, PBF1, 2, 3, 4, and 4, relating to second respondent alleged non-qualification that were tendered by PW7, 27.
Okay.
Mr. Mike Enauroeba, the said documents, in our view, being bereft of pleadings to sustain them as elaborately stated earlier in this judgment. Coming to the hearing, the petitioners called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The said respondent called one witness as one of his staff, RW1, and closed his case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the parties, the court ordered written addresses. The addresses were filed and scheduled. In the final address for the first respondent filed on 14 July 2023, the learned leading senior counsel of first respondent, Mr. A.B. Mahmoud S.N., raised 4 issues as follows. 1. Whether, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraphs 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the BVAS device to the IRF portal constitutes non-compliance with the Electoral Act if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2. Whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3. Whether, going by the provisions of Section 131 and 137 of the Constitution of Federal Republic of Nigeria as amended, the second respondent was at the time of the presidential election held on 26th day of February 2023 not qualified to contest the said election. 4. Whether upon proper construction of Section 134(2)(b of the Constitution of Federal Republic of Nigeria 1999, the requirement that a candidate must score not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation as the Federal Capital Territory Abuja means that a successful candidate must specifically score at least 1/4 of the votes cast in the Federal Capital Territory Abuja in addition to 2/3 of all the states.
We've pushed past the 7-hour mark now.
The second
We've
respondent,
been on the
through
broadcast now for
counsel,
well
Wale
over 7
Olan
hours.
Tekun,
Once again, we
the same,
thank you all.
filed his written address on 14 July 2023. He raised for determination 4 issues which were listed as follows. 1. Considering the relevant provisions
Our
of the
participation
Constitution
as
of the Federal
citizens will
Republic
put
of
an
Nigeria
end
1999 as
to
amended,
all
the
attempts to
salient
rig
provisions
or
of the
to,
Electoral
because
Act
they will
2022,
listen
as
to
well as
our
the admissible
voices.
evidence on
They will
record,
be compelled to
whether the
listen
election of the
because we
second
will be able to
respondent
hold
into
them
the
to
office of
account at
President
every
of the
corner,
Federal Republic of
exercising
Nigeria
our sovereignty.
on
I
25
firmly,
February
truly
2023
believe this.
was not in
It's not going to
substantial
be easy.
compliance
It's not
with
going to
the
be a
principles
cakewalk.
and or provisions
It
of the
needs
Electoral Act
consistent, active
2022.
participation and monitoring of our governments,
2.
holding
In
them to
view of the
account
clear
using those
provisions
two
of the Constitution,
essential
the
powers.
Electoral Act
I firmly
2022,
believe
and
that.
plethora
There's
of
work to
judicial
do for all
precedents
of us.
on the criteria for qualification of candidates for election to the office of President, coupled with the peculiar circumstances of this petition, wherein the petitioners pleaded no fact in support of their allegation of non-qualification of the second respondent, whether the second respondent was or is not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of Section 134 and 299, as well as other relevant provisions of the Constitution, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitution of the petition and the terse evidence adduced, whether this honorable court can accede to any of the reliefs being aimed at claimed by the petitioners. The third respondent, through her lead counsel, filed his final address on 14 June 2023. Similarly, 4 issues were generated for determination. 1. Whether, having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th day of February 2023 was mediated by non-compliance and corrupt practices that was substantial enough to direct or directly attributed to the second respondent as to have affected the outcome of the election and to justify notification of the election in a manner envisaged by the applicable provisions of the Electoral Act.
If you haven't subscribed to Citizen AY, please, I urge you go ahead and do so. Every
2. Whether the
subscription
burden
will help
of
us
proving
with the
that
milestone
first
of
petitioner and not
the
second
initial milestone of
respondent
3,000
got majority of lawful
subscribers. We
votes
need
cast
your
and
support to get
satisfied the
there.
constitutional
We can't do
requirement
without you.
of
We
having
are
1/4
grateful
of
for
the votes
everyone
cast
subscribing and
in each
joining
of
us.
at
Thank you
least
so much.
2/3 of all
Please
states of
subscribe.
the
Hit
Federation
notification button
and the
to
Federal
subscribe.
Capital
Thank
Territory
you.
to
Which is
declare and
the
return
platform where we
as
speak truth to power.
the winner of the presidential election held on 25th February 2023 has been discharged by the petitioner. 3. Whether, having regard to the issues joined and evidence led on the qualification of the second respondent to contest in the presidential election held on 25th February 2023, the petitioner has established that second respondent was not qualified to contest the presidential election as provided for in the Constitution and the Federal Republic of Nigeria 1999 as altered. And 4. Whether, having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the reliefs sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. In response to the addresses filed by the first, second, and third respondents,
we
the
thank
petitioners,
each and every
through
one
their
of you
lead
on
counsel,
Facebook joining us.
Chief
Even
Chris
the
Uche
numbers are
SA,
dwindling, that's
filed their
fine, we
respective written
understand.
addresses on 21st
Let us
July,
continue to subscribe to Citizen AY on
20
YouTube, help us grow
22nd July and
it. We have
25 July
112,000 followers
2023.
on Facebook
The
as stated.
petitioner's senior counsel filed
I'll see
separate
if I can
written
actually
addresses with respect to each of the first,
that
second, and third
evidence
respondent
up
addresses.
for us all to see,
The issue for
so that
tablet raised in
we
the
know
3
that
written
there's
addresses
a lot
filed
of
by
us
two
there and we
petitioners
could really
in
help.
response to each of the
We
written
can do
address
our
of
bit,
each
we
of the
can play our
respondents
bit in
are the
actually
same,
growing
and they are
and reaching people. So we're
1.
going to show something shortly
Whether the return of
to
the second
encourage
respondent
you
in
all
the
to
election
do
to the
what
office
we
of the
can to help
President
us
of the Federal Republic of Nigeria held on
more
25th
people
day
and subscribe
February
on YouTube.
2023 was not
So I'm
invalidated
going to put that up
by
now.
reason
You
of
will see
substantial
comment. The reason why I'm
non-compliance
doing
with
that
the
is because
provisions
I
of the
want you
Electoral Act
to see
2022 on
that Facebook
electronic
are doing
transmission
something. I
of
don't know what
results
it is
for
they're doing,
collation
but
and
they're deliberately
verification.
bringing our notification. They're switching off our
2.
notification so
Whether
people
the
won't
second
see it.
respondent was
But what we
lawfully
can do,
declared and
yes,
returned
there
as
is
the
things
winner
we
of the
can do to
presidential
help
election
us
held on 25th
get
day
around their
of February
shenanigans.
2023.
And that's
Having
what we're
not
trying to
secured
do. That's
one
why we're
quarter of the
doing a
value
direct
was
appeal
cast in
to
the
you
Federal Capital
to
Territory,
help us,
Abuja, as required by the Constitution of Federal Republic of Nigeria, 1999, as amended. 3. Whether the second respondent was not disqualified under the provisions of the Constitution of Federal Republic of Nigeria, 1999, as amended, to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense.
I just want you to be able to see
acquisition of the citizenship of a country other than Nigeria and presenting a forged certificate to the first respondent. 4. Whether the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of the lawful votes cast in the election.
I'm just trying to show you what we have and how you can help.
A look at the issues formulated by the parties will show clearly that though differently worded, they are similar in context and content. It is in the defense of this
you can see that we have 119,000 followers there. So we're not lying. It's not about me trying to lie. It's not about me trying to. The platform where we speak with power, that's what we are. When we tell you what we are, that is what you will find. We have 54,000 likes, 119,000 followers. That followers has been pegged down. We were as high as 130, 140 at one point. I think over 127, we may be coming to 130, 140. But Facebook have gradually whittled that down.
Whether
So
the second respondent was
those of you
lawfully
watching,
declared
you can
and
see on
termed
the
as the
screen
winner of the
that we
presidential election
have
held on 25th day of February
119,000 followers.
2023.
So we
Having
would
not
like as
secured
many of you to
one
go
quarter of the
and
valid
subscribe to
votes
us on
cast in the Federal
YouTube
Capital
to grow that
Territory,
platform.
Abuja.
We really do need your support.
3. Whether the
You can
second
see it on the
respondent
screen
was
right
not
there.
disqualified
So I
under the
wanted to
provisions
just,
of
I'd like to
Constitution of
provide
Federal
evidence when we're
Nigeria
saying
as
when
amended
we're talking about things.
to
So
contest the
please
presidential election
go
held
ahead
on
and subscribe to
25th
us
day
on
of February
YouTube. Help us grow the
2023.
platform.
Having regard
So
to the alleged
just a
order
quick,
of forfeiture
you
arising
know,
from
confirmation
that
of what I'm
related
saying.
offense,
That's all.
his acquisition
As
of
you
the
know,
citizen of the
Citizen was a
country other
platform where
than
we speak
Nigeria
truth to power.
and presenting a forged
Let's carry
certificate
on.
to the first respondent. 4. Whether the second respondent was duly elected by majority of the lawful votes cast in the election and the first respondent was right in returning.
Anybody, as you're joining us on YouTube, give us thumbs up, please. We really need your support. Give us the thumbs up. It's really, really important.
Whether
The thumbs up is very important. Those who will watch now, those who will watch later on, those who are watching now, go ahead. Always give us a thumbs up as you're joining us. It would really help us to grow the platform and reach that milestone of 3,000 subscribers. We're about 273 something, 37 or thereabouts. We're just like, 2,000 and 200 and something short of that. So you can help us get there by sharing it. If you share it to 100 people, they share it to another 100 people, that way we can help us reach that milestone. And we know with your help, support, we will get there. But however, we are grateful for each and every one of you that's been watching the broadcast from the time we started this morning or mid-afternoon. It's now 7 hours plus. And in fact, it's 7 hours plus, and the broadcast is still going. But we need to cover this from beginning to end because we need to be sure that this is something that is followed live, and hopefully people can see that it is of immense importance. We're trying to grow this platform, so everything you can do to help us subscribe and hit the notification button, give us thumbs up, and share it to people. And you have the evidence now that we have over 119,000 followers. It's not hearsay, it's fact. But Facebook has switched off the notification, and that's why we're trying to do this podcast, so to build that up on YouTube as an alternative platform. Thank you so much. The
respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. By Section 1341B of the Electoral, non-compliance with the Act is a ground for questioning or challenging an election. Primarily, the law is well settled that the results declared by any first respondent in an election enjoy a presumption of legality. In other words, they are prima facie correct.
So we're not sure what we're going on. We might probably, if I step away from the screen, I will do, but the broadcast will continue. The broadcast will continue because we need to follow this to its logical conclusion. And we need you all to help us continue to grow the platform. I want to once again thank Waris Jinodu, Vivian V, Malagba.
Where in the JSC
for the moderation on the platform, and let's continue to grow the platform. We appreciate each and every one who joining us. It's really important we continue to build this, and hopefully we will be able to push through a number of milestones and grow the platform and be able to carry on with the work we need to do, because we will need the constitutional awareness and champions, CAC, constitutional awareness champions on ground in villages, local government areas. We will need them to be able to pass the message that we're trying to pass. It's a simple message. Simply translate this constitution into our local languages, and those who we're going to teach the process of how to do this, they will then go into the ministries and make people, so to each one teach one. Because the churches and the mosques are there to deceive you. They're not there to free you and empower you. The church wants to see yourself as a sinner. The imam wants to see yourself as serving Muhammad or Allah and all that. Meanwhile, who is serving you? You are a sovereign. You don't know you're a sovereign. If you don't know you're a sovereign, you can't use those powers. And that is why we are doing what we're doing. Please subscribe to the platform where we speak to the power. Help us grow the platform. Subscribe, hit the notification button, give a thumbs up. And of course, share. Let us do something just to a gentle reminder, of course, as you all know, every few minutes or so. Subscribe to Citizen AY.
Generally, it is the law that he who alleges must offer.
As you're watching, every time everybody comes in, please make it a matter of course to give us thumbs up on all of our broadcasts, on all of our videos. Go always give us, as soon as you see a video, first thing you must do, give us thumbs up. First thing you must do, give us thumbs up. That's the first thing. Once you give us thumbs up, of course, after you subscribe, share it. Then that will reach more people. That will help the algorithm. Thank you so much. We're still listening to the judgment of the Court of Appeal on the case, the presidential election. We will follow to its logical conclusion as far as possible that we can do, that the platforms will allow. You're watching Citizen AY, the platform where we speak to
civil cases, when the primary onus of proof is on the petitioner who makes all the claims against the respondent in this case. Well, we had started this case of Daché and Druven by Ugo JCA, and the earlier petition just determined. That's petition number 3. Usually the burden of proof is the debt owed by the petitioners to the success of their petition. The burden of proof rests upon the party who substantial asserts the affirmative of the issue.
Just make it a normal thing you do. You come in, you sit in there while you're on
if the party with the
YouTube.
burden fails or could not discharge the burden,
first thing first,
must be
thumbs
against him.
up. First thing first, thumbs
Case
up.
of
Make it a matter of course. Let it be something that we do. It's like you're wearing your clothes. You get up in the morning. First thing you do is step out, you put your clothes on. Same thing with this. You come to the platform, the first thing you do, give us a thumbs up. That way it helps us grow the platform. The algorithm takes on and starts building it, and reach more people, because we need the information that we can send out to reach more and more people. So we're thankful for your support.
The burden of first proving existence or non-existence of an assertion or fact, whether positive or negative, lies on the party against whom judgment will be given if no evidence were produced on either side. In the instant case, it is fundamental to point out that from the pleadings, the allegation of non-compliance is generated by the petitioners. Under Section 1341 and 135 of the Electoral Act, the level of proof required for the success of the petition is doubled. There must be proof of non-compliance and the further proof that the non-compliance affected substantially the result of the election. In the face of such an allegation of non-compliance, the court is enjoined by the law.
Burna Boy is in Leicester tomorrow, guys. That's a side issue anyway. Side issue. Is it? Oh, that's today. Sorry, that's today.
All said and done.
Is it today?
The petitioners have the primary burden of proving that there was non-compliance and that the non-compliance affects substantially the result of the election before the burden can shift to the respondents to establish that there was no substantial non-compliance with the Electoral Act in the conduct of the election. If petitioners have in their petition pleaded some of the facts relating to their complaint of non-compliance to the Electoral Act 2022, the key paragraphs of their petition in that regard are paragraphs 18, 22, 23, 25, 28, 29, 35, 36, 37, 38, 39, 40 to 44, 46, and 48 of the petition. The respondents joined issues with the petitioners in respect of this issue, and they all denied the facts pleaded by the petitioners. The denials of the first respondent in its reply are very significant. In paragraph 17, 18, 19, 31, 32, 33, 34, 35, 36, and 37 of the first respondent reply to the petition, the first respondent.
Okay, we're just waiting for them. It's
Your torn backpack, our gorilla tape.
Whoa, sorry about that.
Toughest jobs on planet Earth.
Whoa. We don't want that. We do not want that. Sorry about that. I think I know what's happened. So we're just going to have a little break. We don't want that. We do not want that at all. So we've been watching. I think I knew something would happen. We may have to bring this broadcast to an abrupt end, but we will be no doubt. We'll be back. Let us see what we're doing here. So we don't want that. That's not what we want at all. There is something going on. But anyway, we're back. We're back. I think we're back. We'll keep an eye on it. I think what's happened is after a while, it would normally check into that. I've been trying to get that fixed, but that's not a problem. But, you know, like I said, that's why we are here. We wanted to bring this to a logical conclusion, but let's see.
Another versus 2 J.I.
So let's.
Starting,
we're watching that.
And Yaradua and Akeldu and Mimiko. The Electoral Act 2022, in an explicit manner, has laid out clearly grounds upon which an election can be questioned in Section 134 thereof. Then there is Section 135 of the Electoral Act, which looks like it provides with Section 134.
So please subscribe to Season Y on YouTube. Help us grow the platform. We really need your support. If you're coming in for the first time and you haven't subscribed, go ahead and subscribe. And as you come in, give us a thumbs up. The thumbs up is really important. That really helps us grow the platform, and it raises the algorithm.
The election was invalid by reason of corruption or non-compliance with the
doing that for us helps us. You play your part in growing the platform.
One says an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this Act.
We are over. We are past 7 hours in the broadcast now. We've gone past 7 hours.
This ground of
this may
non-compliance
go all the way to late at night again.
From when we had parliamentary system.
We'll see how it goes. We'll try and cover
The
as
courts
much
have
as
over
we
the
can.
years
But,
shed a lot of light on the requirement of the law in proving the allegation of
clear as possible
non-compliance.
as to what is going on and to give you a clear
A
information.
short chronicle
But
of
we
the
thank you
decisions
all
of our
for
courts
watching
will
Citizen
throw more
Network
light on the
platform where we
prudential
speak
burden
truth to power.
of proving non-compliance. For that purpose, we started the cases of Basi and Young, Awolowo and Shagari. We also cited the cases of Buhari and Anada versus Obasanjo and others, and CPC versus Buhari and others.
Will we be able, do you have confidence in the judiciary? That's the question we need to ask.
Of non-compliance
Do you have confidence in the judiciary?
That there was non-compliance, and secondly, that the non-compliance has substantially affected the results being contested. Let me say that at the risk of sounding repetitive, that it is after the onus on the petitioner is discharged to the satisfaction of the court, that the onus will shift to the respondents to establish that the results were not affected. It follows, therefore, from the authorities referred to, that for the petitioner to succeed in the allegation of non-compliance, they must plead clearly in their petition the non-compliance and call witnesses or place before the court cogent and credible evidence.
Apparently, Labour Party to announce their next move following the court giving judgment in favour of Tinubu and Shettima. So that's the breaking news we're hearing.
And that the impact is substantial enough to invalidate the election. The petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collection centers, local government collection centers, and state collection centers in all the states of the Federation and the Federal Capital Territory, as well as the National Collection Center. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicates of results from UC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraphs 7, 8, and 11 of his statement, he deposed that from his analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of Vivas machines, manipulation of accreditation, intimidation and harassment of voters, massive printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegations of multiple printing at the polling
forensic
units.
report
In PDP and ANEC and others. This court, per Agim Jesse as it then was, held that it is only a polling unit agent, or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in the unit. See also Goyal and Anada versus ANEC, Buhari and ANEC and others. In the instant case, PW1 was not a polling agent, he was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling unit agents in all the polling units and that they are
Please don't
still
forget,
alive.
as you're watching Citizen Wire, the platform where we speak with power, go and subscribe
also
to
a
Citizen
collation
Wire.
agent.
Before you do that,
His
give us
witness
thumbs
statement on
up,
oath
thumbs
is at
up
pages
on the platform,
213
thumbs
to
up on
215 of the
Citizen Wire,
petition.
the platform where we
His
speak
statement
with
is
power,
similar to that of the
platform
PW1.
on YouTube.
His name
Please
is Dr.
help
Solarin
us
Sunday
grow the
Adekunle.
platform. Thank you so much.
He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW 3, 4, 5, 6, 7, 8, 9, 10, 11, and 11 are all collation agents. The evidence of these witnesses centered around the events and the duties carried out by the polling unit agents or the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units. Under our law, specifically in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or her principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by the law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows therefore that PW 1, 2, 3, 4, 5, 6, 7, up to 11, PW 19, 20, and 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of the analyzing results of the election of the ward local government and state and national level without calling polling unit agents who witnessed the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What the we are told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. This court and the Supreme Court in several cases has explained the intent of this legislation. But that started Jam and Oji, Ute and the state Kasa and the state Ukud and the state Buhari Obasanjo. It is therefore settled law that hearsay evidence is not admissible to prove a fact of non-compliance with the Act. It follows that the evidence of the collection agents in this case, instant case, who are PWs 1, 2, 3, 5, and 7, relating to the suppression of votes, multiple tampering of ballot papers, entering of wrong scores of results, disruption of voting, are inadmissible hearsay and are hereby discountenanced. In the instant petition, the petitioners called 27 witnesses and tendered documents and exhibits. The main and crucial complaint of the petitioners from the evidence placed before the court was the inability of the presiding officers employed and used by the first respondent to upload and transmit the polling unit results to the first respondent's result viewing portal, that's IREF, and the electronic collation system. Of the 27 witnesses called by petitioners, 10 of whom were presiding officers who manned some polling units on the election day. A look at their evidence will bring out the facts of how the presidential election was conducted in some of the polling units on 26 February 2023. These witnesses are PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25. PW 12 is Yoguma Omachuku. The witness was on subpoena. He was the presiding officer in collation unit 07, Ward 3, Abanorth of Abia State. His evidence is that the election was conducted as his polling unit and that at the end of the election, the results were recorded on the result sheet and duplicate copies given to the party agents at the polling unit. He stated that he had challenges in uploading the presidential election results from his polling unit to the IREF portal and electronic collation portal. When cross-examined, the PW12 testified that the election was peaceful and that it was the image of the result on Form EC8A that was supposed to be uploaded to the IREF portal. He further testified that the result sheets were delivered at the Ward Collation Center to the INEC Ward Collation Officer. He said he was happy with the conduct of the election. PW13, Grace Timothy, who was the presiding officer for a polling unit in Bauchi State, corroborated the testimony of the PW12. She could not upload the result of the election to the IREF, but that the party agent signed from EC8A and that she took the original result to the Ward Collation Center. PW14, Grace Ajabona, whose petition was polling unit 6, Ward 1, Yaba West, local government area of Kogi State, equally testified that the election result from her unit from EC8A was signed by her and all the party agents before she took the result to the Ward Collation Center. The PW15, Abidemi Joseph, was the presiding officer in charge of polling unit 047, Ward 9, Maji of Babambola community in Maji, Suleja, Niger State. She gave the evidence also that election was conducted in her unit and that the results were signed by her and the party agent before she took it to the Ward Collation Center. She also could not upload the result to the average viewing portal of INEC. The PW16, Edosa or Bosa, was the presiding officer at polling unit 09, Welu Health Center, Ego Ward 05, Edo State. She equally testified that even though voting went well in the election at her polling unit, she was unable to upload the result of her unit to the RF using the beavers. She did the manual recording of the results from EC8A and signed the result along with the party agents. The result was equally taken by her to the Ward Collation Center. The same story was told by the PW17, Alheri Ayuba, who presided at the polling unit 05, Garki Ward 02, FCT Abuja. She used beavers for accreditation of voters, but could not upload the results through beavers to IREF. She and the party agents signed the results, and she took the results to the Ward Collation Center. Even the testimony of Mohammed Haruna Sadia, the PW18, is in the same order. He was the presiding officer for Unit 05, Amak City Center, Ward 06, in FCT, Abuja. She testified she could not also upload the results to the IREF. She entered the results manually to Form EC 8A and took it to the Ward Collection Center. She testified that she gave copies of the result to the party agents before taking the original to the Ward Collection Center. Janet Nuhu Turaki, the PW23, who was the presiding officer for Walori West Ward 04, AB Bomala Danladi Jalo polling unit 03, Gombe State, could not upload the results to IRF after using beavers to snap the result as recorded in Form
Like I said, I may step away from the broadcast myself, but we are going to follow it to its logical conclusion. I just need to take a break and do one or two things in between. I'll be following it behind the scenes, no doubt. But I wanted to just sit through this as much as possible. This is over 7 hours long. Again, I want to thank those of you that subscribed to us, that have been following the broadcast from the very beginning, and we are grateful.
So, he said the election was successful, except for failure to upload the results to the IRF. The PW25, Victoria Sani, who was the presiding officer at polling unit 020, Ward 01.
Don't forget to give us thumbs up as you're joining us on YouTube. We really do appreciate your support.
With the beavers and the issue of uploading results.
You're watching anywhere the platform where we speak.
The testimony of these witnesses were so clear and cogent that the election went well. The only difficulty was in uploading the results to the IRF portal. These highlighted witnesses were all called by the petitioners. The witnesses were emphatic that the voting and the election in their respective units went well.
So
the votes were collected and results announced at the polling unit.
Don't forget to subscribe, hit the notification button, and of course give us thumbs up.
The witnesses called to establish the fact of non-upload of results, emphatically and directly testified that the election went well and votes
hit the notification button, give us thumbs up, help us reach more people.
Were accounted for and sent to the Ward Collection Center for collection of the results.
Those of you
These 10 witnesses
YouTube,
were all presiding officers engaged by the first respondent for the election of 25th February 2023. There is no gainsaying the fact that under the Electoral Act 2022, election is not just a process. It is a well-regulated process. In fact, in the case of OK and another versus Mimiko, the Supreme Court is scripting out the meaning of election held as follows.
Please don't forget, always, if you're watching and you're joining us, always as soon as you
on this first issue, I will want to hang for support on the case of Abubakar and Yaradua, in which election was defined thus: election is a process spanning a period of time and comprises a series of actions from registration of voters to polling. Then in Bile and the state, the court, Payanguta JSC, explained further that election is defined as inter alia, the act of choosing or selecting one or more from a greater number of persons, things, causes, or rights. See Black's Law Dictionary Special Deluxe, 5th edition, page 464. The Oxford Advanced Learner's Dictionary, page 372, defined it as the action or an instance of choosing by vote one or more of the candidates for a position, especially in political office. The process of election commences with the nomination of candidates through political party primaries. Then it moves into the election proper, which entails the voting, collation, announcement of results. To make this process sturdy, clearer, and credible, the Electoral Act devotes time into making provisions for specificity of actions and steps at each stage. It will not be out of place, my lords, considering the strategic and fundamental nature of election, to survey some of the provisions of the law in this respect. The law made provision for accreditation of voters and voting in Section 47 of the Act, which provision I have reproduced in this judgment. This law has made it mandatory for accreditation of voters for the election to be done with the aid of a smart card reader or any other technological device that may be prescribed by the first respondent. The first respondent exercises the discretion given by the law to prescribe the use of bimodal voter accreditation system, that's BVAS for short, and popularly known as BVAS or BVAS machine. As the name indicates, BVAS is primarily a technological device for accreditation. By paragraph 18A of the regulations and guidelines for the conduct of elections 2022, the use of BVAS for accreditation is mandatory, and all the poll officers who fail to use it for accreditation shall be accused of dereliction of duties and penalized. It is after a voter passes accreditation that he will be allowed to vote. The bottom line of every election exercise is to choose one out of many or to show affirmation of the approval of a candidate who wins the election to lead the country in the instant case as the president of the country. To achieve this goal, election must be result-oriented and successful. A successful election must produce a winner who is expected to emerge by popular vote and as specified in Section 134 of the of the 1999 Constitution. It is in this respect that all votes cast at an election must be duly secured, collected, and counted. The Electoral Act is so clear and explicit on the issue of the votes cast and the results of the election. So for that purpose, I produced Section 25 of the Electoral Act, which stipulates the steps to be followed. So this provision makes it clear and straightforward that voting for all elections takes place at the polling units, and that is why the election is won or lost. The law requires that since the election, the present election, unlike others, is not done in one location but throughout the country, collection of votes commences at the registration area from ward level after voting, then it moves to the local government level, and then to the state collection center, and finally to the national collection center. It is after this that the winner of the election shall be announced. Furthermore, Section 60 and 60 of the Electoral Act deal with the counting and collection of votes cast. These provisions of the Electoral Act are very simple, plain, and straightforward, and do not require any technical rule of construction. The law is strict that where words used in the statute are clear and unambiguous, the courts are enjoined to interpret the words in their ordinary and natural meanings. Words used are to be interpreted in a way that will not clash with and defeat the manifest intention of the legislation. Every legislation is scripted by the lawmakers with a purpose. The court must be careful not to interpret the law so as to create absurdity or make nonsense of the law. See the cases of Imano and others versus Anekwe and others, Degede and Anek, Guma and versus APC and others, Lado and another versus Masari and others. The law as prescribed in Section 60 and 62 of the Electoral Act 2022 does not in any form or sense make any provision or pretension as to any form of counting and collection of election results other than manual collection. In Oyetola and Anik Supra, the Supreme Court, again JSC, held on transmission of results the essence and status of the collection system and the Anik IRF portal as follows. Court, as I had held herein, there is no part of the Electoral Act requiring the presiding officer to transmit the accredited voters in the polling unit or the polling unit results during election to the Anik database as part of the election process. As stated in Section 62(1) of the Electoral Act 2022, after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their polling units, polling agents, where available to such person as may be prescribed by the Commission. This is to enable the Commission compile, maintain, and update on a continuous basis a register of election results. This intention is clear from subsection 2 of Section 62, which provides that the Commission shall compile, maintain, and update on a continuous basis a register of election results to be known as the National Electronic register of election results, which shall be a distinct database or repository of polling unit by polling unit results, including collected election results of each election conducted by the Commission in the Federation, and the register of election results shall be kept in electronic format by the Commission at its national headquarters. As their names depict, the collation system and the annex result viewing portal are part of the election process and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. It is clear from the positions of Regulation 38(1) and 2 that the collation system and result viewing portal are different from the National Electronic Register of Election Results. The collation system and result viewing portal are operational during the election as part of the process. The National Electronic Register of Election Results is a post-election record and is not part of the election process. With this step of the law, let us now assess the case of the petitioners in this petition. The petitioners, as earlier mentioned in this judgment, are claiming that the failure of the first respondent to upload the election results constitutes non-compliance to the Electoral Act. They pleaded in paragraph 14 and 15 of their petition. Thus, reproduce paragraph 13 and 14. So the petitioners, by this pleading, are relying on the summary of final collation and declaration of results, which are in forms ECDA, in bracket, EC8E, as issued by the first respondent. The issues generated on this were not about the scores, but the alleged invalidity of the scores and the error of calculation of the scores. This pleading was not admitted by the first respondent. In reply, the first respondent joined issues with the petitioners in paragraphs 9, 10, 11 of their reply filed on 11 April 2023, which paragraphs are produced. It is settled law that issues for trial by the court are joined in the pleadings, and the parties and indeed the court are bound by the pleadings of the parties. The petitioner's case stands to collapse if no evidence is called on the issue. See the case of Uruwari and Osla and Nada versus Dixon. In the instant case, the petitioners anchored their case in this issue, on the report of the statistician, forensic examiner, and other experts. The statistician's report referenced by paragraph 14 and 15 of the petition was tendered in court through PW21, Mr. Samuel Oduntan. It is filed on 14th of June 2023. The statistician's report were tendered, admitted, and marked exhibits PAH1, PAH2, PAH3, and PAH4 respectively. This report was challenged by the respondents, and in our earlier ruling, we came to the conclusion that it was incompetent and liable to be struck out, and was in fact struck out. Without prejudice to that ruling, I wish to assess its value. Nevertheless, PW21, the maker of the said reports, was cross-examined in court by all the respondents, and he showed clearly that he is an unreliable witness. He was contradicting himself on issues around his report, apart from the fact that this witness is a subpoena witness whose witness statement of oath was not from law date. He did not present himself as a credible witness. Hear him under his cross-examination by Mahmoud SN for the first respondent. He said, I have formal training in information technology, IT, as stated so in my written statement. I was commissioned by the petitioners. I was compensated by the petitioners for my work. I am an expert in statistics. Apart from what I stated in paragraph 5 of my witness statement, I have enough experience in my work and election petitions. One does not need to be an expert to read INEC forms EC8S. I commenced my work sometimes in April. It took me about a month to complete my assignment. I cannot recall any proceeding where I admitted that I am not an expert. I agree that if my primary data is defective or incomplete, my conclusions could not be wrong or incorrect. Could be wrong or incorrect. I also agree that if my methodology is wrong, my conclusion will be wrong. I've seen page 4 of Exhibit PAH1. That page refers to the methodology I use as referring to Forms EC8S. I inspected the Forms EC8S at the ANIC headquarters. I do not know if those Forms EC8S are before the court. I am aware that the Form EC8S are stored in the various state headquarters. If what are stated in paragraph 2 at page 4 of Exhibit PAH1 is wrong, my conclusion will be wrong. I have seen column 1 of volume 3, Exhibit PAH4, at page 1, line 1. It refers to polling unit 009 or 6 of Anambra State. When cross-examined by Chief Olani Pekon for the second respondent, the PW21 said, I have seen paragraph 5A of my written statement on oath. It is true that I did not present the report in Khalil and Yaradua. I agree that no pictorial images of the electoral documents I referred to in my statement are attached to my statement. I am aware that PDP won the election in Adamawa State. By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I am not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation room of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH2. Furthermore, in response to the cross-examination of the Lano Senior Counsel for the third respondent, 5MESN, the PW21 said, it is true that I have been following ANIC activities since 1999. There was a time that ANIC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANIC chairman announce 2 days to the election that due to the security and cash crunch, elections will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. I stated the role played by each of those persons. I have seen volume 3 of my report. The said volume 3 of my report deals with ANIC documents which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I am aware that BVAS machine was used for accreditation. I am the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the state treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost its steam and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that Form EC8A series were altered and were not signed. It also talked of 15,002 polling units, where Form EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several forms EC8A series had a lot of alterations and they were not signed by the presiding officer. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature, stamp, and any alteration on the forms. Since PW21, who authored Exhibits PH3 and PAH4, did not place this in his report, and the petitioner did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3, that allegation is unfounded and not proved as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines make it mandatory for electronic collation system. I have carefully considered the submission of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153F1F of the Constitution, and part of its functions as stated in paragraph 15, item F, part 1 of third schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulates its own procedure, and in so doing it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the Federal, State, and Area Council or the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of credited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that a collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collated results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collated results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47.2, referred to in Section 64.4a, relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, subparagraph 4b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. The Act also provides in Section 60, subsection 5, that the collection officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collection or returning officer will use to verify and collect the results, subsection 5 also provides for what the collection or return officer will use to collect the results. Subsection 6 of the same section provides for what the collection or returning officer will use to determine the correctness of disputed results where there is a dispute. These are the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, sub 2 of this Act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 60, subsection 4 of the Act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in Section 61, transfer in Section 65, and transmitted directly in Section 50, sub 2, 64, sub 4, 5, and 6 of the Electoral Act in stating how results of elections should be handled under those provisions. A look at the definition of those words in the Black Law Dictionary 6th edition show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1999 Constitution, and Section 148 of the Electoral Act 2022 that that the first respondent herein made the regulations and guidelines for the conduct of elections 2022, as well as INEC manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal vote accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation on non-compliance on paragraph 38(1), Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and paragraph 93 of the regulations and guidelines. Paragraph 38 Those provisions refers to have been reproduced in this judgment. So from the foregoing provision of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 621 for the delivery by the presiding officer of the result, along with other election materials under security and accompanied by candidates or their polling agents, were available to such person as may prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area for ward collation officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the annual result viewing portal, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area for ward collation center. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload them to the result viewing portal RF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that ANIC results viewing portal RF is not a collection system. Thus, the Supreme Court in Oyetola and ANIC has explained the difference between the collection system and RF, where again JSC held as follows. As their names depict, the collection system and the ANIC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collation. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials and the security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines as well as the ANIC Manual also state that hard copies of election results shall be used for collation, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists that electronically transmitted results or results from the ANIC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that is substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instance case, from the myriad of decisions, the onus is directly on the petitioners not only to establish that through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another versus INEC, Audu and INEC, Wake versus Mimiko, Kente and Ishaku, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This is section 66 and 68 of the Act, which have been produced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the President as in section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collation and announcement of results, signing of result forms, and publication of results. The results sought by the reliefs sought by the petitioners are declaratory in nature. It is cited in law that where a petitioner seeks declaratory reliefs, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondents or defendants. See Omishore and Arebeshola and Oga versus Piazzo. It is also the law that the pleading and the claim of the petitioners determines the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the commission of a crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. See the application of this provision in the cases of PDP and INEC, IG versus PDP and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 2022 and an allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is simply non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probabilities. But the standard of proof in any ground that is primarily on corrupt practices will require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case, and on the issues being resolved here, the petitioners tendered some documentary evidence directly from the bar. The objections to the most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioners called 2 star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Tar, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131 to 160 of the petition. In paragraph 23 and 30 of his sworn deposition, Dr. Tar, that's PW19, said as follows: I know that on the face of the form EC8D, 8 in A in bracket, there are calculation errors as shown and contained in the report of the statisticians, which the petitioners shall rely upon. The non-compliance consists of refusal to authenticate all the intending voters in the election using the technological electronic device prescribed by the first respondent. In addition, the failure of the first respondent to transfer the outcome of the election directly into the portal of the first respondent created for the viewing of the public as a means to ensure the integrity of the election at the polling unit, and the electronical collation system before the declaration as to who is the winner of the election. There are no particulars supplied in his statement on oath. All that can be read from this statement are projections without substance. When he was cross-examined by A.B. Mahmoud SL, he said that it is true that I am a lawyer and politician. I am the national coordinator for the petitioners. I was at the National Collation Center. I was throughout okay, so, yeah. Well, the cross-examination of that witness has been reproduced. Is a bit the sworn deposition on oath of the next star witness or the petitioners, PW22, Senator Delo Melai, is almost a rehash of the entire petition. What he said on cross-examination by A.B. Mahmoud has also been reproduced. The testimonies of these star witnesses under cross-examination aggregated the same account given by other witnesses that the election went well. Accreditation with the Vivas device was all right. The agents of the petitioners were on ground at the polling units, and that the results were entered on forms EC8S and duplicate copies given to the agents. The facts elicited from the cross-examination of these witnesses have belied much of the strands of their written statements on oath. This, of course, is a challenge to the credibility of the evidence of PW19 and PW22. While cross-examination has the capacity to tarnish the credibility of a witness, it also has the corresponding capacity of strengthening the case of the opponent. In the instant case, the evidence elicited from the PW19 and 22 on cross-examination has fortified, in my opinion, the case of the respondents that there was nothing wrong with the results of the 2023 presidential election and that there was substantial compliance with the Electoral Act 2022. That also played out in the cross-examination of PW20, Walatunji Oshele. His deposition on oath is at page 204 to 207 of petition. That is the same trend in the account of these witnesses. They were majorly given account of not only the polling stations they voted, but other places not within their reach. The significant tone is that they testified of casting their votes without any problem. The results by their admission were properly declared and taken to the vote collation centers. The irony though is that the witnesses, okay. The irony, though, is that the witnesses did testify to a peaceful and valid election in their polling units where they voted and then turned around to give evidence of alleged infractions in polling units where they were not present. Their testimonies in that respect are hearsay. Hearsay evidence is not admissible and has no value in proving the petition filed by the petitioners. Furthermore, in the instant petition, first respondent is consistently maintained that the technical glitch that occurred on the election day was the failure of the e-transmission server to upload polling unit results for the presidential election into the IRF portal. It claimed that the glitch only prevented the members of the public from viewing or assessing the results that were already uploaded and listed on the first respondent e-transmission system. On their part, the petitioners asserted in their petition that the glitch claimed by the first respondent was actually a bypass by the first respondent to tilt and switch the results of the presidential election in favor of the second and third respondents, as pleaded in paragraph 40. In furtherance of that assertion, they also pleaded in paragraphs 41 and 42 of the petition as follows. The petitioners applied to the court for subpoena to issue to the witnesses listed in paragraphs 41 and 42 of the petition on 26/5/2023. These witnesses were not called by the petitioners, and no reason was given as to why they backed down from calling the witnesses they pleaded to call in proof of their petition. It is tried that litigation, particularly election dispute litigation, is fought on pleadings. Parties swim or sink with their pleadings. For this, see the case of Anyafulu and others versus Meka and others. See also Ifeanyichukwu Osondu Company Limited and another versus Ahibe. Those pleadings in paragraphs 41 and 42 of the petition, having been abandoned, are discountenanced. In the same vein, paragraph 96 of the petition averred that agents of the second and third respondent disrupted the election. Votes scored were not accurately recorded, and the ballot papers were torn. The petitioners averred that video recording shall be tendered. However, the video recording was not tendered in that regard. In this respect, the presumption in Section 167D of the Evidence Act 2011 that they withheld the said video recording because it will be against them if tendered shall also apply. From the foregoing, therefore, it is very clear and certain that the petitioners have failed to prove that the 2023 presidential election and return of the second respondent was invalidated by reason of corrupt practices or non-compliance with the Electoral Act 2022. This issue, that's issue 1, is therefore resolved in favor of the respondents and against the petitioners. Issue 2 is whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, he having not scored one quarter of the total valid votes cast in the Federal Capital Territory, Abuja. This issue has been resolved in petition number 3, and we adopt our finding and conclusion in that regard in this petition. Which was
Yeah. Hello again. We're doing this slightly different now. I'll be back shortly. Just give me a minute, please. We are just trying to quickly get updates on things. So give me a second, please. Give me a second.
Issue 3 is whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended to contest the presidential election held on 26 February 2023, having regard to the alleged order of forfeiture arising from the drug-related offense, his acquisition of the citizenship of the country other than Nigeria, and presenting a false certificate to the first respondent. I do not intend to reopen this issue, having already ruled on it while considering the preliminary objections of the respondents. I held therein that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and their efforts to remedy it through their replies to respondents' replies were belated and of no avail. That ruling constitutes issue estoppel, binding not only on the parties but on this court, meaning that this court cannot depart from their earlier ruling. So this issue is therefore discountenance. This issue is whether the second respondent was elected by majority of lawful votes cast in the. That's issue 4. Yes. This issue is whether second respondent was elected by majority of lawful votes cast in the election, and first respondent was right in declaring him as elected. This issue covers ground 3 of the petition. The facts in support of this ground were pleaded by the petitioners from paragraphs 105 to 145 of the petition. The petitioners specifically pleaded in paragraph 106 to 107 as follows. The petitioners shall lead evidence at the hearing to show that A, the result of the election as announced by the first respondent, and especially the votes allocated to the second respondent, do not represent the lawful valid votes cast at the election. And B, the lawful votes cast at the election were deliberately and massively deducted from the first petitioner's scores by the first respondent in order to return the second respondent. 17. The petitioner shall give evidence to show the election results as purportedly declared by the first respondent in respect of each state of the Federation, including the Federal Capital Territory, the details of which are contained in the table following are wrong. The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So where the complaint in an election petition is that candidate returned did not poll majority or highest votes in the election to be returned as contended herein by the petitioners. Not only must the figures disputed be pleaded, the figures or votes the petitioner perceives as the correct figures of the election ought to be true and must also be pleaded. That is not only logical. Support for it can be found in several decisions, among them Nadabo vs. Dabai, where Okoro Jesse, as it then was said, when a petitioner is alleging that the respondent was not elected by majority of local votes, he ought to plead and prove the votes cast at the various polling stations, the votes illegally associated to the winner, and the votes which ought to have been deducted from the supposed winner in order to see if it will affect the result of the election. Where this is not done,
more importantly, what is going to be the impact on our lives collectively going forward? That's the question we need to find out.
See also Ojo versus Isohe and others.
So what is going to be what is this judgment going to do? What does it mean for our lives? What does it mean for 130 million people
which the petitioners
in
are
poverty?
disputing as manipulated? Nowhere in the petition did petitioners plead that what they considered the authentic vote of the election to guide the court in the inquiry suggested by them in this allegation. The second respondent did not poll majority of lawful votes in the election. Their petition therefore did not meet the legal threshold to ignite a proper inquiry by this court, and so lame even on the pleadings. Going further, if we must at all, the petitioner claim is that 19,702 polling units results contains various forms of infractions. They assert that the results from a total of 4,307 polling units are without stamp on the respective forms EC8A from the states, and details are said to be in the statistical report, which report we have repeatedly held incompetent and inadmissible. They also contended that results from 1,300 polling units do not have signatures of the presiding officers on the respective forms EC8A. It was also alleged that results from 6,408 polling units have and indicate zero accreditation. It was further alleged that 9,464 polling units across 30 states showed that the votes returned are in excess of accredited voters. Furthermore, that the presiding officers failed to properly fill and countersign alterations in election forms, including forms EC8A, EC8B, EC8C, and EC8D in over 40,000 polling units, which they claimed were in the statistician's report. It is clear from the affirmance in the petition as captured above that neither the particulars of the polling units in issue nor those involved in the
welcome aboard
were given by petitioners.
Please,
In any case,
everybody
our
join
law
us.
is well settled that
We
before
urge you
a party
to
can
please go ahead
legally
and
rely
subscribe
on
to Citizen AY on YouTube, the platform where I speak to power. We do need to support to grow that platform on YouTube. As you know, we have over 100,000 followers on Facebook, and we would like to migrate quite a lot of you to join us on Facebook also. Sorry, on YouTube also. That way we have two platforms. So one of them is not functioning, we have another platform to be able to carry on giving you very important information such as to raise awareness about the powers that we possess as citizens and sovereigns in Nigeria. So we do need to support in growing that platform on YouTube. If you haven't subscribed to Citizen AY on YouTube, go right ahead and
massive suppression, deduction, and allocation of
just a quick thing again. Chukwemeka Monday, good evening to you. Sonia Kafo, good morning, good evening to you. Ahmed Jami, Udadekunle, and others. I greet you all. If you haven't subscribed to Citizen AY on YouTube, take a moment, go ahead and subscribe. And as you subscribe on YouTube, hit the notification button, give us thumbs up, and share the broadcast to as many people as possible. What we're trying to do is this platform on YouTube, particularly, we want to migrate as many people on Facebook. We have over 119,000 followers on Facebook, but Facebook has switched off our notifications, so that's okay, that's fine. In that case, we want our people to be able to have the opportunity to see our broadcast without interruption on YouTube. So we have right now, we are live on YouTube at the same time as we're streaming on Facebook. We're live on YouTube, streaming this live. We would like you to go ahead, go to YouTube, just follow the link on the broadcast on Facebook, and you can subscribe to Citizen AY, hit notification button, give us thumbs up, help us with more people. David Brook, good evening to you. Welcome. Good evening. Good evening. So give me 1 second, guys. So yeah, got it. Yeah, 1 second. Okay. So keep going. We'll keep watching for a few minutes. Thank you very much.
Circumstance was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 2856 of the 1999 Constitution as amended. That, however, does not diminish the petitioner's or appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This portion of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections called oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsify it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification or election documents when it is so alleged, as pointed out in Belgoled and Ahmed. See also the case of Wazir Ibrahim and Shagari and Buhari vs. Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complaint of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issues of evidence of witnesses who were not polling unit agents. The collection agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. The interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, the otherwise potent adverbial word manifestly used by the legislator in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or the understanding plainly or obviously, evidently, close of court. This means for the petitioners to throw up their arms and say we need not call oral evidence in proving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of non-compliance. We have started this approach to Oetolo and Anek of the JSC. From this authority, it is the law that while the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at these documents to see if they manifestly show any lack of compliance. These exhibits include the following: exhibits PG, PG1 to PG3, which were the printouts of bimodal voter accreditation system, VIVAS, for Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ekiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Ondo, Oshun, Oyo, Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara were admitted, though objected to. Exhibit PH1 to PH36, which were the annex data on number of registered voters and collected PVCs for the 2023 general election for the state, listed in the first schedule of documents as numbers 46 to 82 were admitted. The second schedule of documents was filed on 31st May 2023, and the documents listed here Surprisingly, the documents were dumped on the court without any witness linking them up with the specific complaints of non-compliance, it is certain law that despite the tender of exhibits in proof of a petition, the onus of proving the case pleaded and for which the documents were tendered in evidence lies on the petitioner. In the instant petition, a lot of documents were tendered from the bar. When a party decides to rely on documents to prove his case, there must be a link between the documents and the specific areas of the petition. The party must relate each document to the specific case for which the documents were tendered. Failure to link the documents is fatal and catastrophic, as it is in this case. The Supreme Court, in the recent case of Tumbi Bido versus Anik, have cited the questions. In this situation, it is invariably correct that all the allegations raised in this petition have not been proved as required by our law. See Buhari and Anik, part 20 JSC. It is also important to draw our minds to the fact that criminal allegations are usually and directly made personal. For allegations of crime to be proved against the respondents, it must be proved that they committed the corrupt acts or aided, abetted, consented to, or procured their commission. Furthermore, it must be proved that the corrupt practices substantially affected the outcome of the election. See Omishore versus Arebeshola. The law also places the onus on the petitioner to demonstrate by credible evidence that the alleged corrupt practice indeed occurred and that it affected substantially the outcome of the election. In that quest, the petitioners pleaded some states where the malpractice allegedly occurred. One of such states is Sokoto State. They placed PW19, PW21, and PW22 to prove the allegation that the first respondent cancelled results from 241 polling units in Sokoto State in respect of National Assembly elections in the state, but went ahead to declare results for the presidential election. The three witnesses, PW19, 21, and 22, were not in Sokoto during the election. There is also no evidence tendered of the cancellation of results in any of the units alleged. PW19 and PW22, when cross-examined, said they were in Kogi State, where they voted, and later came to Abuja. The PW21 is the statistician who testified of overvoting, non-signing, and cancellation of forms used, but he did not tender or show those compromised forms. The same occurred in their testimonies in Kano State, Kogi State, Lagos State, and Rivers State. From the foregoing consideration, it is very clear that there was no credible evidence by the petitioners to prove the allegations of corrupt practices. Under this issue raised, the petitioners were asking if the first respondent was not wrong in returning the second respondent when he was not duly elected by a majority of lawful votes cast in the election. From the facts placed before the court, the first respondent declared the results of the election by which the second respondent was returned. Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the result declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, the 4 issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the 3 petitions, number CA/PEPC 03/2023, CAP-EPC 04-2023 and CAP-EPC 05-2023 are all devoid of merit. The petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected president of the Federal Republic of Nigeria. The parties in the three petitions are to bear their respective costs. So now I will call on my learned brother by immediate right to reach his own judgment.
Thank you. Please sit down, sit down. Thank you, my Lord. I was privileged and privy to be part of the decision and the judgment elaborately given by my Lord presiding Honorable Justice Haruna Somani, and I am in full agreement with the lead judgment as delivered by him in these three consolidated petitions, which are petitions number CAPEC 03-2023 and CAPEC 04-2023 and CAPEC 05-2023. I agree also with the consolidated rulings on the various objections and other interlocutory applications relating to the competence of witnesses and the documents tendered in the three petitions highlighted. I also agreed with the reasoning and the conclusions arrived at the rulings on the preliminary objections and the substantial issues raised therein. In any concluded election, there are bound to be a winner and losers. While the winner celebrates victory, an aggrieved loser may come before the court to ventilate his grievances. This is made possible by the Constitution of the Federal Republic of Nigeria, 1999 as amended, which in Section 6 thereof empowers the courts to determine disputes, including election disputes. It is well settled that an election petition by nature is sui generis, of its own kind or class. It is not like going to court to make a claim of debt, contract, or tort. It has its own character and is unique by its nature. The slightest non-compliance with a procedural step, which otherwise could either be cured or waived in ordinary civil proceedings, could result in a fatal consequence to election petition. There are a lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal for the hearing of the election petition and for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the courts. It is tried law that under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements on oath of witnesses. 3, copies or lists of every document to be relied on at the hearing of the petition. A petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall, used in this legislation, makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or it is difficult to prove the state petition. In the instant case, the petitioner's pleadings were deficient, while they complained of non-compliance with the Electoral Act against first respondent. Their own petitions were massively deficient in non-compliance with the State Act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these three consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment.
I will call on my land brother, my immediate left, to deliver his own judgment.
I have read the lead rulings and judgments of my learned brother, H.S. Samani JCA, in the above consolidated petitions. I agree with his reasoning and conclusion in each petition and adopt same as mine. I add a few words for emphasis. Petition number 3. Ground 1 of the petition is that the respondent was, at the time of the election, not qualified to contest the election. The first complaint under this ground is that the purported sponsorship of the second and third respondents by the fourth respondent was rendered invalid by reason of the third respondent knowingly allowing himself to be nominated as the vice presidential candidate, whilst he was still a senatorial candidate for the Borno Central constituency. The controversy about the third respondent knowingly allowing himself to be nominated in more than one constituency was the subject matter in PDP against INEC and others, reported in 2023 LPELR 60457SC. The Supreme Court Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, in their concurring opinions, held that the third respondent, having withdrawn his nomination and personally delivered the notice of withdrawal to his party, fourth respondent in this petition, on 6th July 2022, he was no longer a candidate for Borno Central constituency senatorial election in his subsequent nomination as the vice president for the presidential election was not multiple nomination. The opinion of the Supreme Court Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC is not a comment or observation made in passing. It is an exposition of the law on withdrawal of a candidate from an election and the allegation that the third respondent knowingly allowed himself to be nominated as the vice presidential candidate while he was still a senatorial candidate for Borno Central constituency. Concurring opinion forms part of the lead judgment, and it is meant to complement him by way of addition or an improvement on the issues resolved in the lead judgment. See Nwana against FCDA, Oloruntoba Oju against Abdurrahim, and both and others against Just Electricity Distribution Company PLC. Citations supplied. The Supreme Court, having rendered its considered and definite opinion on the validity of the nomination of the second respondent as vice presidential candidate of the fourth respondent, attempt to reopen the issue in this court is a misadventure. The second complaint is that the second respondent was at the time of the election not qualified to contest for the office of the president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483 on 4th October 1993. The contention of the learned counsel for the petitioners is that the order of forfeiture made by the court is a fine under Section 137(1)(d) of the 1999 Constitution of the Federal Republic of Nigeria. It is a settled principle of interpretation that when the words used in the provisions of the Constitution are clear and unambiguous, same must be given their plain and ordinary meaning, unless to do so will lead to absurdity. See Abegunja and other cases cited here. The context in which the word sentence is used in Section 137(1)(d) of the Constitution connotes formal pronouncements awarding punishment after conviction for an offense. Conviction is a finding of guilt after an indictment, arraignment, and trial. See Kole against FRN, Mohammed against Olawumi, Modu against Federal Republic of Nigeria. Therefore, the words sentence, imprisonment, and fine used in Section 137(1)(d) of the Constitution definitely connotes only a punishment imposed on a defendant following an indictment, trial, and conviction for an offense. See Babangida Usman against the state. Citation supplied at 40 to 41. Sharif against Federal Republic of Nigeria. Citation supplied. In civil forfeiture or a non-conviction-based forfeiture proceedings, in civil forfeiture or non-conviction-based forfeiture proceedings, the government only needs to show by preponderance of evidence that the property is a proceed of crime or was used to facilitate a crime. Criminal forfeiture, on the other hand, is seizure of a property connected with a crime after obtaining conviction and as part of sentence or punishment for the crime. Civil forfeiture is not a conviction or verdict of guilt after an indictment, trial, and conviction. See Jonathan against Federal Republic of Nigeria, citation supplied, where the Supreme Court per Kaas JSC considered the provisions of Section 17 of the Advance Fee Fraud and Other Related Offences Act, and persuaded by the decisions of the various courts across the world, held that civil forfeiture is an action in rem embarked upon when the interest of the government is merely to recover the proceeds of unlawful activity. The court also held that an application for interim forfeiture of property that is not predicated on conviction of the owner of the property would necessarily be an action in rem, because it is the recovery of the property that the law aims at. A forfeiture order by a foreign court can only be accepted and recognized by a court in Nigeria for the purpose of Section 137(1)(d) of the Constitution, if it is made after an indictment, trial, and conviction, and properly proved as required by Section 49 of the Evidence Act. In addition, the conviction and sentence must be shown to have been a product of due process of law. Compliance with the process of law has to be determined by the procedure and standard set by Section 36, subsection 5 and 6 of our Constitution. The forfeiture order being relied on by the petitioners has not been shown to be a result of a process similar to the one set by our Constitution for a trial of a defendant for an offense. The appellant's counsel relied on Austin against United States, citation supplied, and Teams against Indiana, decided on 20th February 2019. The forfeiture proceedings into two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment such as fine for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money, after forfeiting the properties listed under forfeiture of assets, etc., certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, etc., certain provisions, persons decree number 53 of 1999 as punishment. From all the above, it is clear that a non-conviction based forfeiture, being civil in nature and an action in rem, can in no way be equated with a sentence of imprisonment or fine imposed for an offense involving dishonesty or fraud or for any other offense to disqualify a person from contesting for election to the office of the President of Nigeria. An indictment, arraignment, trial, and conviction are necessary preconditions for disqualification of a person under Section 137(1)(d) of the Constitution. Grant 2 of the petition is that the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. The allegations are basically predicated upon electronic transmission of the election. A global reading of the Electoral Act 2002, particularly sections 47(2), 61(5), 62(1), 65(1)-8, will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC Regulations and Guidelines for the Conduct of Elections 2022, the first respondent made provision for electronic transmission and physical stroke manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provides that at every level of collation, where any copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officials shall use duplicate hard copies issued to the Nigerian Police Force and agents of political party to collect results. It is therefore not correct that it shall not be possible to collect results of the election where results have not been electronically transmitted. By law, the INEC Regulations and Guidelines for the Conduct of Elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act prevails. See Odeneye against Efunuga, in Yesom against Peter citation supplied. Section 134(2) of the Act. By Section 134(2) of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECAT at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers, so as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the results were still being uploaded on the IREF? So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW12, the petitioners exercise that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral Acts provided a candidate who wishes to challenge any results declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agents raises a presumption that if those forms had been produced, it would have been unfavorable to the petitioners. The first respondents in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IREF was due to a technical glitch which occurred on their transmission system, which was rectified within a few hours. All that the petitioners could do was to bring a PW1, a member of the second petitioner, who claimed to be a software engineer and an employee of Amazon. She had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the market, or to be persuaded or intimidated by threats on social media? That is not the way of the court. See the admonition of Toby J.S.C. in Buhari against Yaradua on a similar situation like the instant case, citation supplied. Thus, the petitioners not only failed to prove non-compliance with the Electoral Act, they failed to prove that the non-compliance substantially affected the result of the election declared by the first respondent. It is settled that even if non-compliance with the Electoral Act is established, if there is evidence that despite the non-compliance, the result of the election was not affected substantially, the petition must, as a matter of law, be dismissed. See Abu Bakr and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. CLLU, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that would do violence to the provisions of the Constitution and fail to achieve the goals set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of this Constitution, 14.1 and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs. Our constitutional principles of freedom, equality, and justice, democracy, and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. The principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution being urged on us by the petitioners is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality and justice, democracy and social justice, and participation of the people in their government enshrined in our Constitution. It strikes at the very foundation of our Constitution. It is capable of further dividing the citizens of this country. The politicians are good at using all sorts of means and sentiments to divide the citizens of this country. The interpretation being urged on us is their latest invention in that regard, and unfortunately, they found a ready alliance with those who should know better. The interpretation being urged on us is squarely against the letters and spirit of our Constitution, and it is hereby rejected. Based on the above and the further reasons lucidly explained in the lead judgment, I too dismiss the petition. 04. I have had a preview of the reasons given in the lead judgment of my learned brother. I agreed with his reasoning and conclusion. I adopt him as mine. I hereby abide by the orders made therein. As for 05, I adopt my reasoning in respect of the third grant, and I also dismiss the petition. On the whole, I too dismiss each of the three consolidated petitions. I abide by the order made in respect of the petition in the lead judgment.
My learned brother, by my extreme right, can present his own judgment.
I had earlier read in draft the rulings and judgments of my learned brother, Aruna Simon Samani, in these consolidated petition numbers CAPEPC 03, 04, and 05, 2023. I am in complete agreement with His Lordship's reasoning and conclusions on all of them. First, for petition numbers PEPC 04, 2023, that is the Allied People's Movement petition, I am of the very fixed view that the issues agitated by the petitioner therein concerning third respondents alleged disqualification by reason of matters connected to or surrounding his running mate's nomination and relinquishing of his earlier nomination by his party for the Borno Central Senatorial District having been settled on their merit by the Supreme Court in its judgments, in appeal numbers SCCV 501, 2023, in third and first respondents' favor therein, with the Apex Court even holding that the said issues did not disqualify them, that decision constitutes issue estoppel, being status defining and so judgment in rem it binds every person, including non-parties to the suit, like the petitioner in petition number CAPC 04, 2023, C. Kotun, and Oyekomi, Soson, and Odemuyiwa. Furthermore, by the doctrine of stare decisis, it also binds this court. In fact, it will, in my humble opinion, amount to judicial heresy for this court to involve itself in inquiry by whatever guise into that same issue already settled by the Apex Court. Coming to petition number CA03 2020 of Peter Obi and another versus INEC and others, and CAPC 05 2023 Atiku Abubakar and another, again I am of the very fixed view that the two sets of petitioners did not by any means discharge the burden on them of proving that the results of the presidential election of 25th February 2023 as declared by first respondent were incorrect. Incidentally, their burden is even made heavier by the legal presumption that the votes of an election declared by the official organizing body that INEC is are correct, and it is for the person asserting the contrary to prove it, Buhari and INEC, see Buhari and INEC. Even their resort to first respondent's failure to keep its initial promise to upload poly-unit results of that election to its result being portal IREV real time, which failure the alleged evidence is election manipulation, does not help them. And specifically on this allegation of manipulation of election results, the point must be made that since it is their case that from the word go that the election results in issue were manipulated by first respondent in favor of second respondent, and specifically that the manipulation took the form of quote programmed failure of the technological device, machines, that is beavers by first respondent by intercepting the results, quarantining, warehousing, and filtering such results before releasing them to the IREF portal. 2, INEC replacing its in-house IT expert at the 11th hour with a rogue staff, all in a bid to completely control, monitor, and filter data transmitted from the beavers devices to the electronic system. And 3, that Globacom, the internet provider for the beavers electronic system, was also disconnected by first respondent to enable it to manipulate the results. With the petitioners in CA, that is the article petition, even going further to undertake to call evidence to prove all those allegations. The burden of proof was on the petitioner to prove those assertions, and that is regardless of whether they are positive or negative. After all, it is they who would have failed in the case if no evidence at all was adduced in their petitions. See on that sections 131 of the Evidence Act, Buhari and INEC Aladegbemi versus Fasomade, Elias and Disu Dashi and another Abrat and Railway, Northeast Railway Company. I have taken all this time making this point because of the argument of both sets of defendants that they only made negative assertions in their petitions, when they alleged that there was nothing wrong with first respondent transmission system and IREF, so they had nobody to prove it. That the burden of proof was on the respondents who they said positively asserted glitch in real-time transmission of their results. Petitioners who directly made manipulation of its e-transmission system by first respondent to favor second respondents, a pillar of their case, cannot be held to say it is respondents and not them that had the burden of proof in this case. Incidentally, that assertion of petitioners that INEC simply closed down or blocked its IREF and e-transmission system for the public to enable it to manipulate the election results in favor of second respondents also takes me directly to the more important question in the petition, namely whether that allegation is even worthy of belief, given the results declared by INEC for them and the second respondents in the election. To answer that million-dollar question, I deem it necessary to resort to the probabilities arising from the facts of the case. That test, otherwise called the probability test, which test celebrated Judge Chukwudefu Akonne Oputa, JSC, always maintained, and I quote him, is the surest road to the shrine of truth and justice. See the cases of, he said so in the case of Dibi Amaka and others, and in Ojegele and others, the first 1989 and the second 1988. I gave the citations. Here, the assertion of petitioners is that first respondent INEC merely used the excuse of glitch in its IREF portal to block the public from seeing its polling unit results real time so that it could manipulate, and indeed actually manipulate, the 25 February 23 presidential elections in favor of second respondent. It is their further contention that the manipulation of IREF by INEC with the said phantom glitch in favor of second respondent was nationwide. The question is, do the results declared by INEC support that hypothesis? They say the taste of the pudding is in the eating. I shall therefore now try to walk us through some of these election results to see if that assertion of petitioners is supported by the results declared by INEC and so probable and worthy of belief. In doing that, I shall randomly pick on the results of some states of the Federation and the Federal Capital Territory. I shall be relying on the state summary of the results, that's from ECD, declared by INEC and has also attached their petition by the petitioners in CAPC 05, that is Article's case, which result was also tendered by both sets of petitioners and respondents. So I take first Abia State. There, second respondent, the alleged favored candidate of INEC, for which it was said to have shut down its IREF to manipulate results, only garnered a miserly 8,914 votes. That is as against the Labour Party, which by INEC's declaration polled as many as 327,095 votes. Even the other set of petitioners, complainants, the PDP and its candidates, scored more votes in Abia than INEC's purported favored candidate. They also scored 22,676 votes in Abia and was so recorded by INEC. Those votes alone are close to 3 times the votes of second respondents for whom INEC was said to have manipulated results by closing down its IREF so that the public would not witness its manipulative activities in favor of second respondents. In Enugu State, the same favored quote-unquote candidate, second respondent, was again declared credited by INEC to have polled only 4,772 votes in the entire state. Meanwhile, the Labour Party and its candidates were again declared by manipulative and quote-unquote and unfriendly INEC to have scored as much as 428,690 votes in that state. In the same Enugu, PDP and its candidates was also declared by INEC to have polled 15,745 votes, a number that is also nearly 3 times the votes of the so-called favored second respondents. In Anambra State, the same purported favored candidate, second respondent, was declared by its alleged friend INEC to have scored only 5,111 votes. Meanwhile, the Labour Party, whose candidate, first petitioner in CAPC, I must take judicial notice of, VP Section 124 of the Evidence Act is from that state, again was declared to have polled as much as 584,621 votes. Again, like Enugu State, the PDP and its candidate was declared by INEC to have polled 9,036 votes, a number that is also nearly double the votes of, quote, INEC favored, end quote, second respondent. In neighboring Delta State, the same INEC favored candidate, second respondent, was declared by INEC to have scored 90,180 votes. That is as against the Labour Party and its candidate, which is credited by the same bias, quote unquote, INEC, to have scored as much as 179,917 votes. In that same Delta State, the PDP and its candidate scored 161,600 votes, again nearly double the votes of second respondents. In Adamawa State of the PDP and its candidate, the same favored second respondent was declared by INEC to have scored only 105,648 votes, while the PDP and its candidate were declared by the bias, quote unquote, INEC to have scored as much as 214,012 votes. In Imo State, the same purported INEC favored candidate, second respondent, was declared by INEC to have scored only 66,406 votes, while the Labour Party and its candidate is declared by the same INEC to have polled as much as 360,495 votes. In Ebonyi State, the Labour Party again scored as much as 259,738 votes. That is as against alleged INEC-favored second respondent, who by INEC's declaration, that is his friend's declaration, again polled a relatively miserly 42,402 votes. The PDP is said to have scored 13,503 votes there. Even in Lagos State, where second respondent was once held sway as elected governor, the Labour Party and its candidate was again declared by bias, quote unquote, INEC to have beaten second respondent with almost 10,000 votes. Labour Party was declared by INEC to have polled 582,455 votes as against 572,606 polled by second respondents and so declared by INEC. It is a similar story in the federal capital territory of Abuja, where INEC has its headquarters and supposedly carried out, directed, all its, quote, manipulative and biased activities in favor of second respondent that petitioners claim it did in the election. Second respondent and his political party still off there. In fact, by the result, second respondent friendly, quote unquote, INEC declared in the federal capital territory of Abuja, second respondent could not even make 25% of the votes, total votes cast there. He was said to have polled only 90,902 votes. That amounts to just 18.991% of total votes cast in the FCT. Yes, INEC declared that result. That is as against 281,717 votes, amounting to 58.856% of the total votes. The same INEC declared for Labour and its candidates. There are also other states, including Katsina State of the immediate past president of this country, a member of the second respondent, who was still in office at the time of the elections, a part of the judicial notice of VP Section 124 of the Evidence Act. There again, second respondent and his party, the APC, also of the sitting president, was declared by the same INEC to have lost to the petitioners in CAPC 05-2023, that is Atiku Abubakar. Now, if all these results declared by INEC for each of the states for the two sets of petitioners, and second respondent is anything to go by, then INEC must be an abysmally poor manipulator, if not even an imbecilic one. Surely it would not go through all the stress of closing down its IREF and blocking the public from seeing its manipulative efforts in favor of second respondent, as alleged by the petitioners, only for it to still end up favoring the petitioners with jumbo votes and posting miserly figures for its favored second respondent. It is said that all men stamp as probable that which they would have said or done under similar circumstances, and as improbable that which they themselves would not have said or done under the same set of similar circumstances. Things inconsistent with human knowledge and experience are properly rated as improbable. End quote. See again Okuta GSC on this, in Onwa and the state and Bozin and the state. At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agreed that they had agents in the polling units? I have thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building block of election results. That much is stated in paragraph 90 of INEC guidelines and for the election, and also Wobuda and Ono and Awuse and Odele. In short, the allegation of the petitioners that INEC shut down its IRF to manipulate votes for second respondent just does not add up for me. If anything, the probabilities arising from the results INEC declared nationwide as illustrated above rather seem to me to eloquently support its position that its inability to upload the polling unit results real time, as earlier promised, was not deliberate but caused by technical issues outside its control that afflicted its e-transmission system, which issues it claims made it impossible for its e-transmission system to map the uploaded polling unit results for the presidential election to any specific state. That is claimed is unlike the much smaller National Assembly elections that were conducted simultaneously with the presidential election. It is that phenomena it describes as glitch that was giving it an HTTP 500 error, which eventually resultantly delayed real-time public viewing of the said polling unit results. That conclusion also takes me to another big issue in this case, namely the evidential value of the European Union Observer Mission report on the 2023 election and presidential election, over which quite a mountain has been made up by both sets of petitioners. That report was tendered by the petitioners in petition number PEPC, that is Obia and another, as Exhibit X2, and by the petitioners in CEPEC 05 as Exhibit RA27. The impression given by both sets of petitioners that the said report, which in any case has been even ruled admissible by us in petition number CAPEPC 03-2023, is like gospel truth of what happened in the election. And so it must be accepted by this court, and the conduct of the presidential election declared corrupt or at the very least below par, regardless of whether or not its authors presented themselves in court to defend their opinions. That stance, I am afraid, is a non sequitur, a complete non sequitur. Without the makers of that report presenting themselves in court to face cross-examination, to authenticate their opinions, that report, and I dare to add even the ECOWAS report of the same elections, tendered by second and third respondents in petition numbers in the two petitions, are completely valueless and inadmissible for the purposes of authenticating the opinions expressed in them by the makers. See first on that the cases of Yesom and Peter Said and Said Sosoyakowa. It also makes no difference that said reports have been put in the form of print. Books, it must be noted, cannot be cross-examined. On this, I find support in the celebrated case of Idudu and others of Sosokumaga, where the Supreme Court, 1976, where the Supreme Court had this to say, and let me quote what the Supreme Court said. It said, as for the law involved in Idudu and Okumaga, we would like to point out that it is now well settled that there are 5 ways in which ownership of land may be proved. In our view, not only was the evidence of the witnesses, that is continuation, not only was the evidence of the witnesses called by the appellants rightly rejected by the learned trial judge for good and sufficient reasons, we also think that he was right in not attaching any weight to the views expressed in the book cited in support of such traditional evidence. As Lionel Brett JSC, as event was rightly in our view once pointed out in a learned address given by him at the University of Lagos to the Nigerian Association of Law Teachers, smaller quote again, the courts are not to be hypnotized by the authority of print. The crucial fact is that books cannot be cross-examined, either as to the opinions expressed or as to the claims of the author to have special knowledge. If the author is living, there is no reason why he should not be tendered as an expert when this difficulty would vanish. Long quote, end quote of that side. Then the Supreme Court went on to say, moreover, none of the authors of these books in that Kumagba's case testified in support of the views stated therein, and no explanation was given for the omission. For all these reasons, we share the apprehensions of the learned trial judge about the value or weight of the traditional evidence as narrated by each of these authors, particularly as the authenticity and impartiality of the sources of their narratives cannot, for obvious reasons, be easily ascertained. End quote. I went on to say that is the exact same situation we are confronted with here as regards both the European Observer Mission report and its brother ECOWAS Election Observer report. For purposes of proving the opinions expressed in them by their makers, neither of them is of any higher value than the mere sheets of paper on which it is recorded. And for those who, like the petitioners, are enamored by now very familiar patronizing judgments passed on elections, regularly passed on elections, by European election observer missions every 4 years. Even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020 presidential elections of the United States that saw him out of office was also a fraud, It may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read above, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough. It is for these few additions, but much more for the far more illuminating reasons advanced by my brother Haruna Samani JSC, his rulings and judgments, which reasons I concur with without reservation. That I also hold all three consolidated petitions not proved and thereby enter another dismissing all of them, and I affirm the declaration of second respondent Bola Ahmed Tinubu by second respondent as the person duly and properly returned winner of the 25th February 2023 presidential election of this country and duly elected president of the Federal Republic of Nigeria. I also abide by all other consequential orders, including that as a cause contained in the leading judgments.
I now invite my learned brother by my extreme left to present his own judgment.
Well, last but not the least, I've read before now a draft of the lead judgment just delivered by my learned brother Haruna Simon Samani, JCA, in the three consolidated petitions of CAPEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-2023. I'm in agreement with and I adopt all the reasons and conclusions stated therein, both in relation to the rulings on the objections and the merits of the three consolidated petitions. Although all the issues in petitions number CAPEPC 03 and 2023 and CAPEPC 05 2023 have been exhaustively resolved in the lead judgment, I deem it only pertinent to highlight a fundamental vice which has affected the two petitions, especially as it relates to the petitioner's essential contention or premise upon which they predicated those two petitions. In those two petitions, the petitioners have premised their ground that the presidential election conducted on the 25th of February 2023 is invalid by reason of corrupt practices and non-compliance on their contention that by the provisions of the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 2022, the first respondent, INEC, is mandatorily required to electronically transmit election results to the collation system and to the INEC results viewing portal, the IREV. They contended that the first respondent had deliberately refused to comply with those mandatory provisions and had manipulated the results of the election through various corrupt practices which they alleged in those two petitions. However, in both petitions numbers PEPC 03-2023 and PAPC 05-2023, exhibits X1 and X2, which were attended respectively to show that the Labour Party, the second petitioner in petition number PEPC 03-2023, had before the elections approached the Federal High Court Abuja for the determination that, and I quote, by the provisions of the Electoral Act 2022, INEC, the first respondent, has no power to opt for manual method other than the electronic method provided for by the relevant provisions of the Electoral Act, unquote. And I quote again, an order of this Honorable Court directing / compelling the respondent to comply with the Electoral Act 2022 on the electronic transmission of results in the forthcoming general elections, unquote. In that judgment, the Federal High Court Abuja Division had dismissed the suit and held that, and I quote, there is nowhere in the above cited sections where the Commission or any of its agents is mandated to use an electronic means of collating or transferring of election results. If any, the Commission is only mandated to collate and transfer election results and number of accredited voters in a manner or way deemed by it. Additionally, this court's attention was referred to the judgment of this court in appeal number CA-LAG CV 332-2023, APC versus Labour Party and 42 others, delivered on the 19th of June 2023, in which this court set aside the judgment of the Federal High Court, Lagos Division, in another suit number FHC LCS 370-2023, Labour Party and others versus INEC, filed by yet Labour Party, the second petitioner in PEPC 03-2023, before the Lagos Division of the Federal High Court to obtain an order of mandamus compelling INEC to electronically transmit or transfer election results as provided in its regulations, after losing in the Abuja division of the same court. In the judgment of this court of 19th of July 2023, in appeal number CA-LAG CV 332-2023, this court particularly held at pages 23 to 24 thereof that, and I quote, "It is difficult for suit number FHC-LCS 370-2023, which gave rise to this appeal, to escape the level of abuse of court process. I said so because the objective of the suit is to compel the 43rd respondent to adopt a particular way of transmitting or transferring the results of the election in Lagos State. This objective is not in any way different from what the objective of the first respondent wanted to achieve in suit number FHC ABJ CS 1454-2022. Similar parties are the same in the two suits. The second to 42nd respondents are members of the first respondent, which litigated the suit number FHC ABJ CS 1454-2022. The second to 42nd respondent's interest is the same with that of the first respondent, so they are the first respondent's previous. Both suits are against the same defendant, that is the 43rd respondent hearing, and filed in the same court, albeit different divisions of the court. The decision of Emeka Nwite J of Abuja Division of the lower court, which dismissed the first respondent's suit, holding that on the interpretation of the provisions of section 60 subsection 5, 62 subsection 2 of the Electoral Act 2022, INEC, the 43rd respondent hearing, is at liberty to prescribe or choose the manner in which the election results shall be transmitted, finally settles the issue. I therefore find in suit numbers FHC LCS 370-2023, which is herein being appealed against, all the trademarks of the cause of an abuse of judicial process, unquote. Exhibits X1 and X2, tendered in petitions number 03 and 05 respectively, as well as the decisions of this court in appeal number CA-LAG-CV 332-2023, Supra, are subsisting judgments of court which are not only binding on the parties, but which constitute issue estoppel to the petitioner's essential contention in the two petitions, that the first respondent is by Electoral Act 2022 and the INEC regulations mandatorily required to electronically transmit and collect results of the presidential election. The doctrine of issue estoppel is that once an issue has been finally decided by a competent court, the issue will not be allowed to be relitigated by the same or even different parties. See Cotton versus Oekami and another, APC versus PDP and others, Ezewani versus Onwodi, citations on the record. Indeed, in Ezewani versus Onwodi, the Supreme Court, Pauputa JSC, specifically held as follows. Strictly speaking, therefore, the concept and value of an estoppel is to bar a person from denying or asserting anything to the contrary of that which he has, in the contemplation of the law, been established as the truth, either by the acts of judicial or legislative officers or by his own deed or representation, express or implied, unquote. It is clearly evident that the decisions in Exhibits X1 and X2, tendered in the two petitions respectively, as well as the decisions of this court in appeal number CA-LAG-CV 332-2023, APC versus Labour Party and 42 others, have dealt a death knell to the petitioner's contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines for conduct of elections 2022 mandatorily required to electronically transmit election results to the collation system and to INEC result viewing portal, which is the IREP. Apart from this fundamental deficiency, which I have highlighted, the lead judgment just delivered had exhaustively considered all the other issues and rightly concluded, in my view, that the petitioners in petitions number CA-PAPC 03-2023 and CA-PAPC 05-2023 have failed to establish all the allegations contained in the two petitions. I adopt all those reasons and conclusions stated therein and also find the two petitions devoid of merit. Petition number 04, as regards that petition, the petitioner has, under the guise of challenging the qualification of the third respondent to contest the presidential election on the ground that he had violated the provisions of section 142 subsection 1 of the Constitution of the Federal Republic of Nigeria 1999, basically challenged the validity of the nomination of the fourth respondent by the third respondent as his running mate in the 25th February 2023 presidential election. In concurring with the lead judgment just delivered, I also hold the considered view that the status of the nomination of the fourth respondent as the running mate of the third respondent and vice presidential candidate of the second respondent had been finally decided by the Supreme Court in appeal number SCCB 501-2023, PDP and INEC, delivered on 26th of May 2023, now reported as PDP and INEC and 3 others, 2023 LPLR 60457SC, the certified true copy of which was tendered as Exhibit X1. In the concurrent judgments of their lordships, Okoro, Augi, Ogumumiju, Agim, justices of the Supreme Court, they have all determined as proper the nomination of the fourth respondent as vice presidential candidate of the second respondent. As for the petitioner's argument that the pronouncement of the Supreme Court in those concurrent judgments is an obiter dictum, the clear statement of Ogumumiju JSC has left no one in doubt that the Apex Court decided the merit of that case. My Lord Ogumumiju JSC clearly stated at page 74, paragraph C of that judgment that it is apt in this type of political case of public interest to look into the merits of this case, unquote. It is settled law that once the issue relating to the status of a person or a thing is finally and substantively determined by a competent court, such a determination constitutes estoppel to any subsequent proceedings on the same issue. See APC, PDP, and others, Inakoju and others was a delicate citation on that. Now, for all this, and all the detailed reasons succinctly stated in the lead judgment just delivered, I also hold that this petition is lacking in merit. Having also found that no merit exists in all the above 3 consolidated petitions, I join my learned brothers Amani JCA in dismissing all the 3 petitions and abiding by the consequential orders made in the lead judgment.
Well, the judgment delivered by my learned brother Abba Mohammed, who have discharged our responsibility to the nation. We have concluded the hearing of this petition and we have concluded the delivery of the judgment. So we thank the Almighty God for bringing us this far all these months